Good morning, everybody. Yeah, I said I was going to take a break. Well, that didn't happen. Too much stuff going on, y'all. Too much happening. Can't do it. Just couldn't do it. Couldn't stay away from you guys. What can I say? I just love y'all. Oh, trying to get this camera to go where it needs to go. Oh, I can't wait till I get my new mount. See what I mean, y'all? Stay. Don't move. That means I gotta sit way over here to be center. It's driving me crazy. Okay, guys, well, we have some things happening out there, and we're gonna hop in a minute. Excuse my nose. Allergies have been bothering me. Good morning, Miss Endrell. We have 2 cases that are hopping today. In about 30 minutes, I believe, we're going to have the Kohberger case. And then yesterday, we have an audio only from the Chad Daybell hearing that will take about 37 minutes. So I am going to hold off on that. I'm going to bring the Chad Daybell up as soon as it gets its little happiness up and running. Let me see. Here it is. 27 minutes till that happens. So we've got that feed up and running. So I kind of want to visit with y'all a little bit. In the interim, first of all, grab your coffees, grab your teas, get something to drink. It's a morning. It's a Thursday morning. I kept thinking yesterday was Thursday. All day yesterday was not a good day to do that. But we do have some birthdays. I have a special birthday today. A very special birthday. And so we're going to get into the birthday.
Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you. Happy birthday to you.
Even if you were not on my list. Okay. So, I want to say happy birthday to Miss Fabulous. I'll say birthday. Pammy. Happy birthday, Pammy. Happy birthday. I hope it's a good one. I hope that you have a fabulous day, Stephanie. We have Stephanie Adams. Happy birthday. And we have a Stephanie Hare. Happy birthday. And go to her fundraiser. She's raising money for the Happy. I'm sorry, that's loud for me. I got to bring it down. My ears are not handling it well. Stephanie Hare is raising money for the Happily Ever After Animal Society Sanctuary. Sorry. Naomi, happy birthday. Christina, happy birthday. Terland, happy birthday. Mona, oh my gosh. Happy birthday, sweetheart. Christina, happy birthday. Cheryl, happy birthday. Get some cake today. Dupree, happy birthday. Audrey, happy birthday, honey. Mona, oh, I got you here twice. Happy birthday, Geneva. Ruth Ann Garlock. Ruth Ann, it's your birthday. It's your birthday. It's your birthday. Ruth Ann, I wish you happy birthday. God's blessings to you today. And oh my gosh, I'll have to call you. Lacey, happy birthday. Carabine, happy birthday. Michelle, happy birthday. Angie Brown, happy birthday. Bill, enjoy your day. Hattie Gill, oh my gosh, beloved, happy birthday. You, Bromley? I gotta email you too. Bro, happy birthday. And a special someone Patty, Patsy Jordan. I've got Ruth Ann, Patsy Jordan, and Hugh. All three, some of the most godliest people I know. Some of my bestie friends. Hugh, you are not that old. Now, I know how old Miss Patsy is, but Hugh, really? Dang, I thought you were in your 60s. I don't think you're that old. Are you 71? I'll have to call you. Y'all, have a great birthday. I love you all. I miss seeing you. See you soon. Happy birthday, y'all. Oh my gosh, y'all. Sometimes you don't know the age of your friends, and then all of a sudden it's like, what? You're really that old? Dang, I had no idea. You don't look it, honey child, and you sure in heck don't act it. Mm. Woke up with a slight headache today. I went to bed, hence the hair. I'm not doing anything with it. I went to bed and I was asleep by 10 o'clock, y'all. 10 o'clock, I was asleep. That is like never, 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 never. No. Yeah, that song never, ever, ever happens. And I was asleep. I was like, wow. Woke up at 6 a.m. this morning and I thought, oh, I feel great. Perfect. So I go get in the bath and I like baths in the morning, sometimes. I'll just get in a bath. I have 3 hours before I have to be at work. I'll just get in the tub, relax, get a cup of coffee. Never took a sip, fell asleep. Didn't wake up until 8:30. Yeah, that water was cold, y'all. Very cold. But anyway, is what it is. So let's talk while I'm waiting for the about 20 minutes. Well, baby girl. Well, baby girl. My puppers came up here wanting love and attention. You know how that goes. So anyway, last night, place. Yeah, good girl. I could not get the trial. What was it? I'm brain dead. What? Robert Tellis out of my head, and till I fell asleep. But I was really, really just kind of thinking about the Tellis trial and everything and our reactions, and I wanted to kind of chat with y'all about that. I got a little excited. I went, "Yes!" Okay, and I got a little bit of feedback, constructive criticism, and I wanted to share a little more with you in depth why I did that. I do believe he's guilty, but what I believe is not important. It's what the jury believes. It's important. And when 96 to 98% of some polls, even 100% of some people's polls, show that he's guilty, that's what everybody believes. I'm kind of on that same boat. I believed he was guilty, but it was not appropriate for someone to think that that's why I did that, and it wasn't. Um, I did it because we had a verdict. We've had a lot of trials come out hung, and everybody, even the district attorneys and everybody, thought that this would come back quicker than it did. And I was starting to fear another hung jury. I was happy that we had a verdict. That was why I got excited. I am very heartbroken over this situation because you have two destroyed families because of one man's decision to do what he knows is morally, ethically, legally wrong, and spiritually, if he's even on that boat. And I just felt that he was being a pompous jerk through most of this trial. And the way he tried to communicate with this jury via the narrative testifying, and I'm sure he had to do that because his attorney was not going to get up there and be a part of any perjury. And I guess the attorney felt that there was going to be some perjury. So for me, hold on, guys. This is the third time. Hold on. So for me, um, whether he's innocent or guilty is not for me to really decide. But I have to tell you, I was not liking the person. And it's hard to sit in my seat and be objective. And his behavior and the way he talked to the jury and the way he presented himself had me on a tooth edge of just really just wanted to reach through that screen and slap him. So, condescending a little bit, narcissistic, just his behavior in general. And it's not like I felt he had it coming to him. I just was, after hearing the prosecution deliver their closing arguments, I thought, oh, they've nailed it. Their opening arguments were fabulous. Their closing arguments was fabulous. I felt they presented a good trial. Then, when the defendant's attorney did the closing arguments and they brought up the vehicle, and the person in the vehicle had hair, that, hi, Gritty, Gret, how are you? I My heart sunk, and it took me a minute, and then about the same time that Brandy Churchwell, I think we were on the same page because when I saw that, at first I thought hair, and then I looked at it again, and it reminded me of a photo I took of my daughter in band when she was standing out on the marching field, and she had a hoodie on and her sunglasses on, and the sun was real bright, so she was kind of in the shadow, and I went, "Oh my gosh, that could be a hoodie." And I think Brandy and I hit the same at the same exact time. It could be a hoodie. And I believe it was because we did have a witness testify that there was a hoodie. He had a hoodie, he being the perpetrator, had a hoodie on and had that yellow workman's shirt on over it with that massive hat. I think that hat stood out more than just a baseball cap. I think if he put a wig on and then the baseball cap, he might have been better off. Uh, how do you go? I think it's fine to express joy when justice prevails. I do. I just felt that I was so worried after that situation with what the prosecution, I mean, the defense put up, and then the questions came back from the jury wanting to compare the. I'm sorry, I'm trying to find a place to put my perfume today. They were wanting to compare some of the videos and wanting to know if they can blow them up. That that put me on edge of, oh no, you know, we may have a hung jury. I didn't think it was going to come back innocent because even if you just dismiss, and they can pick and choose what evidence they believe. So if they took out that and just looked at the rest of the evidence, I thought they were going to be fine. But if one juror adamantly was, it can't be him because of that video, we were going to come back hung. So um, I'm for the victim's family. I'm glad the guilty came out. I believe he's guilty. I I have a right to my belief, and you have a right to yours. And this is the first trial I haven't had anybody tell me personally I'm wrong. And if I am, that's then you can share that. That's what you feel. But um, now being in the shoes of his wife, I know what she's getting ready to walk through. I've been there. My heart cries for that woman. I'm grieved for her because she obviously thought he was innocent or she wouldn't have been up there. And lawyers a lot of times will say if you if he's found guilty, what are you going to do? Well, I'm going to divorce him. They're going to say, nope, wait, don't even say those words. Don't even say it until trial is over. So she's in a bad place because she's trying to save her life and the life of her kids. And when you lose your husband, who is a big, good morning, Ronnie, who is a big part of your financial stability, she's gone a couple years without him in jail, so she's made that transition. For me, I didn't have it that way. He was home with an ankle monitor, but it was still limited. So I had my own issues to work through. But now he's gone. And then when the prosecution said, I mean, what the defense was talking about letting him have some sort of a. Okay, guys, I can't handle this. I got to do it a little off because I can't just sit this way. So when the prosecution, I mean, the defense was talking and said that let his mother see him before she dies. Basically, I'm paraphrasing. Why are you falling? And I can't tighten it up while I'm online. Oh well, y'all will have to just bear with it. I apologize. I'm going to come out just a little. That may help me a little bit. There we go. No, I don't want my sidewall. Come on. Okay, guys, I'm going to have to fix this because it's about ready to fall. I'll be back in about 30 seconds. Hold on. Mm. Okay, I'm back. No, I'm not back. What's going on here, dude? Please get me back. There I am. Oh, gee, really? Oh, please don't. Please don't. Please don't. Okay, y'all. I can't wait to get my new mount. I don't know why it is being so difficult. I think I used to have I used to have a heavier camera, and I think it possibly that's good enough. I had a heavier camera, and I think it possibly no. Yeah. It possibly stripped some of the things in there. So anyway, um morning, Ronnie. Um, I just know what that poor woman's going to go through, and it breaks my heart. And the children, breaks my heart. He destroyed. Not only did he end the life of somebody, he ended the life of his wife. I mean, think about it. In my situation, we had a college fund set up for both of my children. That went to support us the first 3 months, 4 months of him being imprisoned, and everything gets drained. Everything, unless now, being that she works, at least she's got income, probably has insurance. I didn't. Oh wow, I can see better without him today. I didn't have any insurance. I didn't have income because everything was through him. Out and about with Diane. Good morning. So, for me, it's a problem with wearing black. For me, it was much more difficult in that area, but there's a lot of things that are going to happen, and it's going to be hell. We have 10 minutes, less than, before the Kohberger hearing happens. We're going to watch that. And then we have a audio of the Chad Daybell hearing that we're going to be watching. Mm, way too much headroom. Okay. I'd rather have my hat cut off than the rest of my body. Oh, there we go. That's something I'll just have to accept. I can't stand that background, so I'll get a better mount eventually. I ordered one and then it was out of stock. So I was like, God dag nabbit. That's just the way things happen, isn't it? So, what are your thoughts um, about the trial um, now that it's over for all y'all in chat? Um, the one thing, as I was talking to a friend last night before I went to bed, and the one thing that I couldn't get past was the DNA. I mean, that is the one thing. If and the fact that he would think a professional hitman would do what they did and how they did it, it was too sloppy. I think he should have never taken the stand. I think he would have had. I think he would have had a better chance if he would have had a far better chance if he hadn't gotten on the stand. That's how I believe. So I went to sleep last night by 10 o'clock. I woke up at 6, got in the bathtub, fell asleep within a moment, and woke up at 8:30 with a little headache. I shouldn't have gone to sleep again. Didn't mean to. I just was going to have a cup of coffee, relax, and I was out. So, oh, I could take something for my headache. But we will be doing some formatting changing in the near future. I'm trying to figure out how to work around my school. But with that, I will be sorry, trying to open this without breaking anything. I will be starting to do something similar to I don't know what to call it. I can't call it quick bits. Yes, you know who I'm talking about. But quick insights. Yes, baby girl, you being real clingy today. I'm going to start doing some little insight videos. Yes. What? Go place. Well, your treat bag's down here. I agree with you, Andrew. I think that it's important for every woman, especially I, being that I was the one who didn't at the time, should have a way of having some kind of an income, even if it's doing direct sales um, while you're stay-at-home mom. Um, just have some kind of education that gives you, something. Um, then we can all go out. Not all of us, but most people can go out and get jobs at restaurants and stuff. But that's so hard. So hindsight's always 2020. And my hindsight is I should have fought for my college degree. Um, I didn't believe in myself when I graduated high school. My parents and everybody said I wasn't smart enough to go to college. And I believed them. And yeah, you're right, Andrea. You don't know what the future holds when you get married. Just somebody they could go ill and can't work, um, and you need to support the family. It's but unfortunately, not all women are afforded the opportunities to go place. She may have to go to the restroom. So as soon as we get the court video feed up, I'll go take her. But geez, lint everywhere. So it is important for both people to be able to earn, not that you have to. I always tell people now that no matter what the income is, even if it's $10 a month, $10 a paycheck, or 100, whatever your income is, set aside some money for what I call legal funds because you could get sued. You can get in a car wreck and someone sue you, even though it wasn't an intentional situation. So I always preach to young women, you, as hard as it is, it's much harder if something happens to come up with the money than it is to sacrifice something now so you have the money. So set up a legal fund or a savings account for emergencies, and don't touch it unless it's an absolute emergency. That's right, Andrea. Exactly. What do you need, baby? What? Do you want loving? Are you begging for loving? Come here. Come here. Really? You go up? Oh, did you need some mama loving? Oh, baby. Yes, okay. Now go. Place. Is that what you wanted? She's been really lovey-dovey lately and real clingy, which means I may be getting ready to have a problem. So, about 2 minutes away. Hopefully, they'll start on time. But it is important to plan and um, do what you can to prepare for your life. She loves her mama. I know she loves me. I love her too. But I think she may need to go TT, but we can wait another couple of minutes if they start on time. It's less than 2 minutes. We're at a minute and 54 seconds. But um, I just think that we ought to just don't forget the family. Don't forget the families. They're suffering. As much as he deserved what he got, his family doesn't deserve what they're going to get. Fortunately, while on disability in Canada, we don't have enough to even have food and housing, let alone save anything. Yeah, I don't like the disability. I've been on disability. I've been on food stamps. I understand that 100%. But um, there are people out there who absolutely can't. I get it. You're lucky just to make ends meet. But if you can, even if it's $5 a month, something. But you're true. Even in America, it's really tough. And what's really sad is if you're on food stamps or SSI and somebody gives you something, you're supposed to report it. And now, when you're on disability and someone gives you, they don't care. They don't care because you didn't work for it. But man, y'all, it's very hard on disability to do anything for self planning or preservation. Self preservation doesn't exist. Hi, Broken Baker. Oh my gosh. Hello. We're getting ready to watch. We're waiting for the Kohberger, and we're going to listen to Chad Daybell from yesterday or earlier today. I don't know when it happened. I hope this finds you well, Broken Baker. Um, but this trial is over for now. We just have sentencing verification. The judge will do that in October. But with every victory for justice, there's always another family destroyed. It's never one sided. Never, never one sided when you have um, a situation like this because both families are affected. And AK Swan, I have lived it. I know it. I lost my husband to prison. And to be the wife, to get on the stand to testify. And and here's what I told people. I don't I cannot, how do I put it? Until I see evidence that shows me he is guilty, I have to support him. Because I mean, think about it. if you're married and you were accused of something and you know you didn't do it, for example, that wasn't necessarily everybody's case, but you're innocent. You say you're innocent. Would you not want, thank you, Raiders, appreciate you. Would you not want your spouse to support you? Or do you want your spouse to leave and then, if you're innocent, try to get back together? No, I took vows for better, for worse, for richer, for poor, in sickness and in health. This was worse. It far wasn't better. But until someone shows me it's some evidence that he was guilty, I was not going to abandon him because honestly, I never saw him break rules. He wasn't a rule breaker. If he was to get a paycheck and they said you got a dot to the left side of the I to get paid, he wouldn't question it. He'd just do whatever the rule was. Rules were rules and you just follow the rules. So when my husband was arrested for breaking a law, I won't share what, but I could not, and the what he was arrested for, it didn't fit his character. It didn't fit the way he lived. It didn't fit any fiber of what I knew of my husband. So we went through trial, and I was the last witness, and I got on the witness stand to testify to what we had done during the time that one of the times he committed a crime. I didn't know he was doing it, and um, I found out all too soon after he was found guilty. And even at that moment, I didn't think he was guilty. Now, although understand, I was not in the courtroom. He and his lawyer asked me not to be because they said that it's hard for juries to to hold a lot of weight of a spouse's testimony if the spouse is in the hearing, because what happens is the spouse can change their testimony to one's way or the other to help the husband. It's credibility. And that's how they explained it. So I sat outside in the atrium outside the courthouse for the entire almost 2 weeks of trial. And I got up and testified and then found out later that day they found him guilty. It wasn't until after I started to move out of the house and take care of all the stuff that I saw evidence that led me to believe he possibly could have been guilty. Now, I can never say 100% he was. There was a lot of circumstantial evidence. There was nothing, I mean, you know, back then I thought circumstantial didn't hold much weight. Well, believe it or not, a lot of cases are tried and convicted on circumstantial evidence, far more than are ever convicted on actually a witness. Um, exactly, Pippi. Oh, thank you for joining me, all of you from Broken Baker. Thank you so much for hopping on. So you can still love the person, and that's very true. And that's where I was. And it was so hard because you love the person, but you hate what they've done. And when you're married for years and years and years, and then you go through this, it it's hard. You, you can't just turn off that love switch. I mean, it just doesn't happen that way in reality. It depends on the crime, first of all. But I always was of the belief that I support until I know different. I don't listen to rumors about people. Um, if someone says someone was arrested for DV, then I will go and look. But I had a lot of people spreading a lot of lies and rumors about me, and I wasn't even the one on trial. I mean, it was so brutal, so cruel. The way they treat the families of the victims, of the perpetrator, you're victimized year after year. Mine has been since arrest was in '07. I still get it. People still come up and say things to me or to people that I'm friends with about me saying, "Don't you know? Oh my gosh, did you know this? She did this or that." And it was kind of like, um, you're listening to rumors. And the other thing I got is I supported um him, and I said I would only thing I ever said to the media, until I see evidence otherwise, because I've been shown nothing. If I see evidence that he's guilty, then we're gonna handle it that way. Well, guess what? People got really mad at me for supporting him. And I'm like, okay, so if you were accused of something and said that you're innocent to your spouse, do you want your spouse to believe you and stay with you? And then if evidence was stated or founded later that you were guilty, then they have the right to decide whether to go or stay. I just did what I felt. And once again, when I got married, it was a covenant between me, my spouse, and my Lord. And that's my belief. And I didn't want to break that until I had good, just cause. So I understand where she's from. I understand exactly where she's from. And I feel bad for her, really bad for her. Now she's going to have to face a lot because she did support him. Why am I having? Don't you love it? I got to figure this out. Somebody's trying to charge something. Okay, we find out the hard way. Yes, but do you know what, guys? And this is so true. Every one of us on this planet is 1 second decision from ending up in a jail. 1 second decision. We all have opportunity to react. We all have opportunities to break the law. And it's a 1 second decision that keeps us either on the outside or inside of those bars. People really do not understand that. Let's see what you say. I think about my niece and nephew. If they ever committed a horrific crime, I would be there for them, although I'd be giving them hell. That's right. I told my children, you're now grown adults. I can't save you. I can support you. I can love you, but that doesn't mean I ain't going to discipline you or I'm not going to tell you the way it is. I'll hold you accountable, but I will always love you. And you will face the consequences of your behavior. You will. But I will always love you. And I understand that. And that poor mother, when she wailed, when the defense said that, begging them to give him 25 so maybe he could get out and before his mother passes on. And realistically, she's going to die before he gets out. And for a mother to realize that is living hell every day. So we're going to change gears now. I'm going to gear up. We have the Kohberger happening, and let's get going. Let's do our little. Oh, I'm really bad about this. I'm trying to get better at this, so forgive me. Let's do the swoop de doo. Well, that didn't work. All right. All right, guys. I had to for those of you who don't know, I took out all my stuff to add new equipment and it didn't work and I had to put it all together, so I was having a little glitches. Here we go. Can y'all hear that just fine? I need one of the mods to give me a sound check because it seems low on my monitor. I am 100% gamed. There we go. Woo! That's a lot. Bonnie has the sound. Thank you, none of your business. Hey, I'm going to go to a potty break on a little girl. I'll be right back.
AJB Live will begin momentarily.
Okay, I'm going to bring that down while they're doing this. Thank you guys for hopping on. I really appreciate
AJB
it.
Live will
You're
begin
amazing.
momentarily.
Thank you so much. For those of you who are new to me, I'm Ada Kay, and I am deaf without my hearing aid. Sometimes we have an interpreter on. Today's not with me, but we thank you for hopping on and joining us. And I have my little service dog down, and she is with me, so you'll see her hopping up and down. Sometimes I do have to leave to take her.
Exactly where will Bryan Kohberger stand trial in the Idaho quadruple murders? The long-standing pretrial battle of where coming down to today's hearing, which will set the stage for the
So
trial
true,
in
Daily
June
Mouse.
of next
So
year.
true. So
That hearing
true.
coming into the Stream Center and starting at the top of the hour.
I didn't say that very well. I
From the
apologize.
Stream Center in Tampa, Florida. Top stories, breaking news, interactive coverage in the palm of your hand. This is Hey JB Live. Here's JB Buno.
I've been trying to figure this out for the last few hours as to whether or not we are actually going to have a ruling today. I think it's fair for everyone to, at this point in this story, at least know where the trial is going to be taking place in June 2025. We have the when, we do not have the where. Welcome into the Stream Center, folks. JB here with you now live across all platforms. Hello to our YouTube Live and Facebook Live audience, and of course, those of you joining us on WFLA.com. We're also asking our poll question here today. You can go interactive by going to www.heyjb.live. This is what it looks like here on your phone on the left side of your screen. We are asking this question: would the jury pool have less bias and
let's see.
Stuff to take a long time, and for there to be a lot of motions, a lot of hearings, a lot of arguments, a lot of fighting back and forth about
or Canada. Today's featured guest, Peter, do you want to guess how many times we have talked about this story? How you've been my go-to legal expert on this story a bunch. You want to guess how many times we've talked about Idaho and Kohberger?
I mean, it has to be over 10, right?
It feels like that. It's actually, this is our, I think, our 6th or 7th time on stream together.
Feels like 10.
It feels like a lot. Why does it feel like a lot? Because there's been so much in advance of trial. Is that how normal is that in today's legal world as far as just how much things are just getting sorted out in the pretrial process?
So it's normal for this stuff to take a long time, and for there to be a lot of motions, a lot of hearings, a lot of arguments, a lot of fighting back and forth about what you're going to turn over, what you're not, what's allowable, what's not in the pretrial phase. Now, what's unusual about this case is every single thing that happens, the world tends to watch and have an opinion on. And it makes it a bigger deal when they're not used to seeing it happen in so many cases. And everything seems like a bigger deal, like the state's trying to hide something or the defense is trying to twist something, when in reality, these are the types of arguments and motions that are filed in most cases, and specifically with the change of venue in high profile cases where it's overly negative media attention on your client. It's a pretty normal motion to file.
And of course, we're talking about whether or not this is going to be moved. I should have, by the way, hi, Peter. How you been otherwise?
Been
Let me
great,
just,
man.
yeah, it's been a few months since we've been on stream together, and I'm just saying hello to you first and foremost.
I think it feels like 10 because we've texted about the case a lot more than just the 6 times we've come on here together. That's probably why it feels like more than 10.
Yeah, absolutely. And I haven't been on stream as much the last several months. There's a whole backstory to that. I won't bore our audience, but it's great to be back here with Peter Tragos, the lawyer you know, and of course follow him on his channel because Peter is covering just about every trial under the sun these days. You can use hashtag HeyJB, hashtag lawyer you know, and we'll try to spotlight as many questions and comments here. But let's just kind of set the stage for the next couple of hours. 9 o'clock a.m. Pacific time is when Judge will be hearing the arguments. And they, of course, will be verbal arguments heard in court. We have seen the arguments, of course, through court documents. And we have an idea as to what these arguments are going to look like. Prosecution, of course, wants this trial to stay exactly where it is in Moscow, Idaho. The defense is arguing and using terms that are very loud, such as a mob mentality from the public as to why this should be moved to a larger city like Boise in Idaho, which I believe is the largest city in Idaho. And so we're going to see this back and forth play out, or we don't know how much of a back and forth there will be. We'll be hearing the arguments from either side, with Kohberger making the move from the basement jail up to the courthouse itself to be present, as we understand it, for these hearings today. That begins in about 15 minutes from now. That's a live stream feed that we will, of course, have here. If you're watching here on Facebook Live or YouTube Live, you don't have to go anywhere. We're going to have it at the top of the hour. But Peter, let's get into the defense's argument for moving this. Mob mentality is something that, of course, has made headlines. But the defense is stating that that they did a survey of residents in Latah County and heard things such as they'll probably find Kohberger and kill him. They would burn the courthouse down. Outrage would be a mild description, that he wouldn't last long, that there's this mob mentality when it comes to Kohberger. That of course is a very loud argument, and they of course the defense is trying to, as much as humanly possible, get this out of Moscow, Idaho, into another municipality in Idaho. What do you think of the defense's argument after seeing this document?
Yeah, this isn't necessarily a new argument by the defense. If you remember back when we were arguing about cameras in the courtroom and how much access the media should have to this case, what should be sealed, what shouldn't be sealed, and we've had a lot of things sealed in this case. The defense has been arguing about the media attention in this case, the negativity towards Kohberger, the creation of a poisoned jury pool, prejudgment of guilt throughout the entirety of this case, and making their life more difficult, making it harder for them to find witnesses that would be even willing to testify in Kohberger's behalf. And now they're just taking the next step, and they've added an expert to review the media articles, the things people are posting on social media, to just show the vitriol and the prejudgment of this case, that Kohberger is already guilty in the citizens of Latah County's head, and there's nothing the defense or anybody else is going to do about it. And the defense shouldn't have that burden when going to trial. I think it's a good argument. The harder part comes where are we going to find a better spot in Idaho? And is a bigger county like Ada County really going to make a difference when we have the state on the other side saying how much harder and more expensive and more difficult it's going to be for witnesses and victims if they do change the venue of this case?
I can't help but go back to Murdaugh when I hear about a potential venue change. I mean, Alex Murdaugh was tried in the same courthouse that his family had long, of course, practiced law in, and many cases, of course, that were had by the Murdaugh family, and that wasn't moved. With Alex Murdaugh, it went beyond just, of course, the murder of his wife and son. It was dozens upon dozens of people in the South Carolina community that were swindled out. There was tremendous outrage in the low country of South Carolina in that case, and people weren't burning down the courthouse. People weren't trying to disrupt the legal process. How plausible is this argument that a survey has been done of residents in Latah County, and these residents expressing such outrage as if to suggest that the legal process would be disrupted because something could happen to Kohberger, Peter?
Yeah, so I think one of the interesting parts about the Murdaugh situation is I actually think he had maybe some secret or quiet positivity in certain counties in South Carolina just because of his family members, his friends in high places, even if he screwed them all and made bad decisions and cheated them out of money. Bryan Kohberger doesn't seem to have any of that in Latah County and no real connections or roots in Latah County. So I think that's one difference. And I think maybe the better comparison is the Chad Daybell and Lori Vallow case. And both of those were moved to Ada County, which is where the defense wants to move this case. I think there's logic to that. I think that's the reason the defense is using it. It's also going to seem like they won, and it's also a bigger county where they made some arguments. I don't know if you want to get into that as to why that would be a better county. And I think that's really the comparison that we have to look at in this case. Both Idaho cases, or all three Idaho cases, 2 out of 3 were moved to that bigger county. They went relatively smoothly. Not a ton of issues throughout those trials. They were tried to verdict. Juries felt comfortable coming out and giving interviews. Now, they were both convicted, heinous crimes as well. Children, minors, dying in those cases, and a lot of media attention in them as well. Documentaries on Netflix and other sites on those cases. So I think that's probably the best comparison we have to this case.
Yeah. Is it not a slippery slope? You could make the argument going forward now that every high profile case that gets social media exposure that the public latches onto is going to get moved out of its original jurisdiction and moved to an outside, an external county or an external jurisdiction. Is this just going to could this be the norm in the future if judge sides here with the defense? Is that going to be the standard now?
You make a great point, because that's not how the system is set up.
Right.
It's not set up that certain cases just go to the big city. That's why we have these jurisdictions. People live here. They pay taxes there. They should be jurors there. They should be able to go watch a trial there because that's where they live. This is their community. This is their lives. This is where they put down their roots. So that's not how the system is set up and not how it's supposed to be. And I think that's why Judge's balancing test here is really going to be, how egregious is it? And is it really going to be better in Ada County versus Latah County?
I want to bring up the poll question that we have. Again, you can open up a browser and go to www.heyjb.live for a one-tap, no sign-up response to this question, which I was driving into work today, and I put a lot of thought into how to word this question. So this is straight from me. And because there's a lot of different ways you could ask this question. You could say, should it be moved out of Latah County? And I think that most people out there, Peter, you say, oh, should it be moved? Most of the people are going to probably just say no. It's going to be a blanket sort of a response. So I asked it this way. Would the jury pool have less bias and case awareness if the trial were moved from Moscow, Idaho? And I have 3 options here. So I'm really curious to see what this looks like. And I want to try to get as many people to vote in this poll in the next 9 minutes, because I want to reveal it towards the top of the hour. Yes, a lot less bias. Yes, a little less bias, or no, the same bias. This idea that if you move it to a different, let's say a larger city in Idaho, that people in Idaho are just going to be, in Boise, are going to be less, biased or less aware of the story. We've talked about this, I think, half a dozen times, Peter. So it's not a new discussion for you and I, but I am really curious to see what our viewers, what people watching right now are going to say in regards to this poll.
So you want to talk about why the defense argues that it's going to make a big difference and there's going to be a lot less bias?
I teed you up for it. Yeah.
Because when I look at this, and that's the hard thing for me to determine, it seems like it's a pretty high profile story. I'm down in Florida. People are talking about it here. So I can only imagine Ada County, not that far away. People are probably talking about it. But according to their expert in the research that was done, the biggest difference is the false reporting and narratives that have been put through the media, specifically that he was stalking the victims before, is way more prevalent in Latah County than it is in Ada County. And while everywhere people have a prejudgment of guilt already for Bryan Kohberger, Ada County, Latah County, it is much worse when they connect it to that false narrative that they've already heard and believe to be true, which is much more prevalent in Latah County. So if they can get rid of that or lessen the belief in that false narrative, and they even cite that the state admitted in a hearing that that is false, that's why Ada County would be the better jurisdiction. There are less people that are confirmed and resolute in their prejudgment of guilt for Bryan Kohberger. So while it's still going to be difficult to pick a jury that doesn't already think Bryan Kohberger's guilty, much easier in Ada County versus Latah County.
So how would you answer this question? Do you believe it's a lot less bias out of Moscow, a little bit less bias, or do you think it's, flat across the board, regardless of county jurisdiction in Idaho?
At best, I would say a little less bias.
Right.
I think maybe the logistical issues with the courthouses and the protection and safety and how big the courtrooms are, that to me is more of a reason to go to Ada County than this, because I really think that there's going to be issues everywhere. I think there are issues here when I talk to people in Florida and they automatically think he's guilty based on what they've heard. And I also think that the defense is pointing the finger a little bit at local prosecutors and, people running for local positions and being involved in the case also makes it worse in Latah County than Ada County. And those press conferences that were given were more amplified in the local TV stations in Latah County than Ada County. You have stuff like this that's streamed all over the world. So I think it's, at best, it's a little less bias. That'd be my vote.
Curious to see if we can get to 100 votes. Again, folks, no sign up required. You just go to heyjb.live. If you're in the United States or Canada, you just tap on your response. It's not tracking you or anything crazy like that. You don't have to put in your email address or anything like that. I just want to make that abundantly clear. I stake my reputation on it. It's just one tap, and then your vote is tabulated right there on screen. And if you're joining us outside the US or Canada, you can just go to world.heyjb.live and vote in this same exact poll. We'll come back to it in just a little bit. One thing I'd also like to take a second. Actually, I think I just hit the wrong button. This is going to be for a different story. Now, actually, that's from our most recent coverage of the current race between Donald Trump and Kamala Harris. Let's hit the right button. And this is the one I wanted to get to. From News Nation, senior national correspondent Brian Entin, he tweeted this out yesterday, and it was just your jaw, opens up quite a bit when you see this. And it reads as follows: empty lot today, where Kaylee Gonsalves, Maddie Hogan, Xana Kernodle, and Ethan Chapin were murdered. Almost no sign of the house anymore in Moscow, Idaho. This has been one of the other controversial pre-trial decisions that has been made in this case. The leveling of the house. We were live as it was being demolished. Peter, it was very controversial at the time, and the general hope from the public is this is not something that comes back to bite anybody with the prosecution or with the FBI or local authorities, because they can't go back in that house. It is gone, wiped off the face of the earth.
Yeah, and it shows that when people agree on things in the legal world pre-trial, usually that's what happens. And we talk about how so many things are a battle and they fight over so many things. It seemed like everybody was in agreement and on the same page with this, as far as the lawyers are concerned and the judge is concerned. Maybe not the lay people involved or the victims or witnesses or people, interested in the case. But now it's gone and there's nothing we can do about it. And hopefully it does not affect the case from either side, the defense or the prosecution.
We're getting close to the top of the hour. We've got, of course, our poll results to get to, but I can't let Peter disappear without giving his prediction on where Judge is going today. So as we understand it, how this is going to work is we're going to hear the arguments from both sides in just a matter of minutes. When the hearing starts, 9:00 local time. And then Peter, you and I were texting beforehand. I reached out to Entin. I've been working the phones. I'm trying to find out if John Judge is expected to rule on this today. No one knows. Entin doesn't know. No one in local media knows. He's going to hear the arguments, and either he's going to issue his ruling today, that it's either going to take place in Latah County or it's going to be moved to an external jurisdiction, or he's going to say, well, I've heard your arguments. I'll be issuing a written ruling at a later date. What's your expectation for what is going to happen today? And which side do you think is going to win on this particular pretrial motion?
Yeah, I think that Judge really wants to keep the pace moving and not be a reason for delay. So I think some of his rulings have come sooner or in court, especially if they were going to be something that was going to delay the case, like a motion to compel production of discovery. He would rule so that the other side would produce it and, keep the clock moving. This doesn't necessarily do that. Whether he grants or denies this motion, it's not going to change a lot as far as the timeline goes. He knows he has to make a decision. That's why they set these dates. He has all the written information and briefing and expert reports, so it's possible he makes the ruling in court. I just usually expect judges to do what they normally do, which is take it under advisement, have a written order, and file it sometime shortly after the hearing. And if I had to guess, I'm basing this basically completely off of what happened in Vallow and Daybell. They moved it to the bigger county. I would assume he's going to do the same thing, fall in line with another judge, precedent being set in these high-profile cases in Idaho, that it would move to Ada County. But I'm not confident in either of those answers.
It's going to be fascinating to watch unfold. As a reminder, with our previous court feeds, and one of the most controversial decisions in the pretrial process, and there have been many, has been whether or not we were even going to have access live to these hearings. The only way to watch is on Judge John Judge's YouTube page. We are refreshing this page, waiting for him to go live. In fact, shout out to Rachel Tucker, or DCP, in the newsroom here, WFLA. Just, refresh.
I'm trying to get that direct link.
Most cases, that's not the case. Most cases, it is what it is. Either people don't know about the case or they know about it the same everywhere. So it's just an interesting kind of thought experiment about how judges weigh these things and what the rules say about how you have to weigh them. And this case is definitely one that's gotten more attention than you'd expect, because there's no celebrities. It's not in New York City. There's no political affiliations. It's just a case that's captured the world.
How much would they have to move, Peter, as far as court personnel? How big of a task is it to move to a different jurisdiction, a larger city?
So it's annoying. I don't know if it's that difficult, right? Because a lot of things, like a stenographer is going to bring her equipment or his equipment with them to the courtroom. Lawyers are going to bring their boxes and their computers. It's a longer drive. It's harder for Bryan Kohberger, obviously, and it's harder for the state. Usually, here, state attorney's office is in the courthouse in a lot of different venues. So it's harder for them to drive there, but it's still a courtroom. The judge is less comfortable. But the defense lawyers and the state attorney, they go to different courtrooms, try cases all over the state probably, and maybe in different states. So you're used to different courtrooms. We try cases in different cities, different states, federal court, state court. So a lawyer, every trial is a little bit different. You're getting used to it. The bigger difference is for the courtroom personnel and the judge, a little less comfortable. not necessarily knowing where everything is, figuring out how to work the lights. But nowadays, they've got to figure out cameras and microphones and all that stuff. So it was going to be a different trial for Judge regardless, in my opinion.
And for Kohberger, I mean, moving to a different facility. I mean, folks, as we have had all this time between hearings, as the attorneys have been going through these dozens upon dozens of terabytes of evidence, Bryan Kohberger has sat, as we understand it, in the same jail cell in the basement of this building that you're about to see us go have the live feed from. So Kohberger would be moving to a completely different facility where he would be held in custody up until the actual trial itself beginning, and on the daily obviously be part of the court proceedings and be seated there with his legal representation. So we've been following along with the various reports coming out of Idaho. Anything else that you are watching for today? We know that this is about to begin here momentarily, Peter. I know we will be saying farewell to you for the live stream today. We appreciate your time. Of course, follow him, everybody, across social and on YouTube at Lawyer. Anything else that you're going to be really honing in on today? Anything you're going to be focusing in on, Peter?
I'm going to be listening to how the defense balances going over how Ada County is better and we should move it to Ada County, but also still saying there are issues in Ada County. There's prejudgment of guilt in Ada County, not waiving appellate arguments with the media issues, potentially what the prosecutor did in their press conference, potential jury questions that they're going to want to ask there in voir dire about the prejudgment and about how do people feel about the media. They don't want to waive any of that. They don't want to get rid of any of that and say, Ada County's perfect. It's great. Nobody's got any prejudgment of guilt against Bryan Kohberger in Ada County. So how they balance that argument is going to be interesting to me if Judge ends up granting it, because they're still going to make similar arguments in Ada County with issues of people prejudging this case and thinking Bryan Kohberger is guilty before it starts.
If a large part of these arguments, well, look, these arguments have been stated repeatedly already. We're of course going to hear it verbally today from both sides, but a lot of this has been, present to this point through documentation. Do you think? Put yourself in the mind of Judge for a second, Peter. Does he have his mind made up on this today? Do you think he knows where he's going with this?
I would guess yes. I mean, most judges have a way. He seems to really try to dig in and listen and ask questions. And I like that he seems to realize he doesn't understand what he doesn't understand. I feel like that's wisdom. You know what you know what you don't know. So he'll ask questions to experts. I feel like he listens to experts that he trusts, but he trusts his gut. So I do think he's going to be pretty open-minded there. But when you've heard all the arguments, we've already had kind of a pre-hearing on this. We've heard when, there was an objection to the surveys and the phone calls to prospective jurors. So he's already heard a lot of this. So my guess is he probably has at least a lean as to which way he's going to go. If not, has already made up his mind.
Yeah. And another thing I couldn't find out, I was asking a bunch of questions to people that are closely, honed in on this story than I am here from Tampa in Florida with you, of course, right here in Clearwater, of course, Tampa Bay represented. I was trying to find out how long this is going to be today. I mean, are we going to get up to a lunch break? I mean, is this going to be an all-day affair? Is this going to be a couple hours? I could not get any sense of, how long this is expected to go, depending on how long it goes, folks, and depends, of course, on our stream schedule here at WFLA today. I might be able to go live afterwards so that we can react and break down and hone in on the arguments and figure out why Judge either made his ruling or chose not to make his ruling today. I will try my very best to be live in the aftermath of this. I'm sure Peter will have great content on his channels to discuss this trial and so many others. But we don't know how long this is going to go. We have no idea if this is going to be short, medium, long, or extra long. No chance this goes into tomorrow, Peter, right?
I would be really surprised. I'd be really surprised if it was short or if it was 2 days, right? I think it's going to be somewhere between 1 and 3 hours, which again is a pretty big block. But again, we've heard some of this. It depends on how much the judge wants to hear. It depends on how much the state wants to present. We kind of know what the defense is going to present. That's going to take some time because we're going to hear from their expert and talk about the surveys and things. But I think it's just going to be a lot of argument from the state. So I don't know. I hope it's 1 to 2 hours. Sometimes these tend to drag for no reason. But we'll see. I'd be shocked if it went 2 days.
I would be as well. Here's a programming note for our audience. If they go to a lunch break, I'll be here with you live, everybody, unless something else in the newsroom takes me away from this responsibility. If they go to a lunch break, maybe they hear one side, go to lunch, and then come back for the other side of the argument. I'll try to be live here with you during that lunch break so that we can kind of assess, where we are with today's particular hearing. But again, no people close to this story who have been following it every single day have no idea what the expectation is with this particular hearing. The only thing that we know is that this one is very significant because this is the one where Judge will ultimately, use today's hearing to make his decision as to whether they're going to Ada County or whether they're staying right there in Latah County. A bit of an extended delay here. The time is now 12:07 Eastern, 9:07 a.m. Pacific. Could it be a Zoom thing? What do you think, Peter? Any theories as to why we're still waiting?
Sometimes it just takes time to set up the courtroom, whether it's Zoom, whether it's an expert trying to put a PowerPoint up. Maybe they're turning the PowerPoint over to the state because they made some edits overnight while they were preparing for this. Stuff happens for 5, 10, 20, sometimes an hour before a hearing starts or before the trial starts. The lawyers and the judge, I'm sure, are working. It could be a million things. There's all sorts of things that happen when you show up to the courthouse steps.
I was just checking. Enton, his last tweet was about 45 minutes ago. He said they are very strict here about tweeting in the courtroom. And he says he might go quiet for a while, saying it's all, it's all about the live stream. It's all about Judge John Judge's YouTube page. Also, apology to our audience real quick. At some point in the pre-stream process, our interactivity feature to display your comments went down. That's technical error. Usually we hone in on questions and comments as they come in and display them on screen. I can read them out, and I'll read a few here from, let's see, from Natalie Frazier, joining us from Rapid City, South Dakota, as we await the live stream beginning on the YouTube page for Judge. Natalie says, I would never want to be in Judge's position. Not to mention the family members of the victims are getting increasingly restless with the perceived lack of movement, lack of activity, lack of progress here, Peter. So you would imagine that, Judge should be considering, of course, the victims' families. They want to get answers and hopeful that perhaps there's an answer on this one today.
Yeah, absolutely. And it affects them maybe more than anybody to have to drive out of town. This isn't their job. It takes over their life. It's a huge life event, and it's just so much harder if it's somewhere else, especially if they wanted to rotate who's going to go, or they wanted to come in and out for certain testimony and they can't just go home if they want to miss half a day. It just makes the whole logistical approach to them so much easier, so much harder for the people that are going to be going through the worst part of the case and having the worst time with it because it's affected and changed their lives forever.
I'm going to just read through comments that came into heyjb.live, our website. That's the easiest way for me to cycle through and just get some comments. Peter, and if you have to go, I was not expecting us to be 10 past the hour. So if you have to hop off, you do what you got to do, man.
I got about 5 more minutes and then I've got to hop off.
You got it. Martha joining us from Bradenton, Florida, says he will be found guilty no matter where it's held. It happened in Moscow and should stay in Moscow, in my opinion. Catherine says, hey, JB and Peter, believe it or not, the case is not well known in Kansas.
That's crazy.
I think it might not be well known to the people aren't talking about it at your average diner in Kansas, but there are going to be people that follow cases like this in Kansas, no doubt, that are going to be very familiar with the Idaho murders, the victims, their families, the pursuit for justice, and the arrest of Bryan Kohberger. Peter, do you think that with how well this case is known, that it is reasonable to believe that you could find a less biased jury? She says, I would think almost all parts of Idaho would be similar. Yeah, Peter, you touched upon this a little bit earlier.
Yeah, I mean, if I had to guess, I would say I think it's going to be similar, but that's why we have experts. The defense has an expert, did the research, applied what he knows, his knowledge, education, experience, and he says Ada County is going to be less biased because of those reasons. Those are legitimate reasons. If it is more poisoned with false facts and media reporting in Latah County versus Ada County, then I think it is possible that it's a little less biased.
Annie says, I've been following this case since breaking news. Annie is joining us from Wagga, Australia. I don't,
Wow.
yeah, no, a lot of people joining us from international, and says, Bryan is innocent. Not everybody. If I ran a poll, do you believe Bryan Kohberger is guilty? I can guarantee you 100% of the vote would not be on one side of that poll. There are people out there who believe that Bryan Kohberger, based on the evidence that they have seen, is innocent. Now, I think it's fair to say that it's a pretty wide split between those who believe he's guilty and those who believe he's innocent. But just proof that Annie is one person who believes that Bryan Kohberger is innocent in this case. Let's see here. Dale from Indiana. Most of the country knows about this case, but we still need to hear the evidence. I'm sure that's music to your ears, Peter. People that
Absolutely.
are saying, yes, like the process still has to play out. He's not guilty yet.
Correct. Yeah. It's how the system works.
It's how it works. And I think it's fair to say with the 50 or so terabytes of evidence, we don't know everything yet. There's going to be,
we don't know a lot.
There's an argument to be made that there's more that we don't know than we do know at this stage. So yeah, a lot to come out. Oh, okay. It is live. Peter Tragos, the lawyer, thank you for your time, Peter. Appreciate you. See you, everybody. We'll be back.
As we get started here today, what I'd like to do is provide you with a roadmap of where we're going with our witnesses. The standard here is whether there's a reasonable likelihood that pretrial publicity has affected the impartiality of prospective jurors. To establish the quantity of pretrial publicity, we will call James Todd Murphy with true scope. To establish effect on partiality, we will call Dr. L. Alili to discuss the social science behind juror decision-making. Then we will call Dr. Brian Edelman about the survey and what it means. And finally, we will call Dr. Dare about the validity of the survey methodology. We are not calling today Scott Sunby, but as you listen to testimony today, please keep his sworn affidavit in mind. With his 39 years of studying capital juries and teaching at the National Judicial College, he is considered by the United States Supreme Court an expert in this area. He has published this book. It's called A Life and Death Decision, A Jury Weighs the Death Penalty. And this book is a culmination of interviews of over 1,200 capital jurors and how capital juries make decisions. Research shows that when a small community creates pressure to impose death, an Eighth Amendment violation may occur. Through these witnesses today, we want to avoid beginning a trial with, as Mr. Sunby states, quote, a thumb on death's side of the scale, end quote. And with that, I call James Todd Murphy.
Okay, thank you. Hey, maybe Mr. Murphy, come on up this way, or however you can find your way through. And please face the clerk, raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right. Thank you, sir. Please have a seat there. And once you're seated, please state your name and spell your last.
James Todd Murphy. I go by Todd, my middle name. Last name is M-U-R-P-H-Y.
All right. Sir, James Jackson.
Mr. Murphy, how are you employed?
I'm the president of True Scope. That's spelled T-R-U-E-S-C-O-P-E. It's one word.
And can you explain what True Scope is?
Sure. True Scope is a media monitoring and analysis service. We wrap our arms around all the media types out there. You can do it on a global level or a geographically isolated level. Normalize all that data from television, radio, newspapers, magazines, social media, online sources, index that with metadata so we know date, time, placement. We assign sentiment metrics to it. And from that, we can extract data sets for what our clients need, specific to topics or phrases.
Can you explain how you track this media intelligence that you just described?
Sure. So we have feeds that are coming in. For example, we acquire a feed from X, formerly Twitter. We have an online feed that accesses all available online sources. We have a broadcast feed of TV, radio, and podcasts. All those feeds come into us as they're broadcasted, as they're posted, as they air or are printed. We don't do any modification of the text or the context. We just take it as it was provided by the content owner, index, store it, and then run queries against it.
Where did you travel from to be with us here today?
Our North America headquarters are in Omaha, Nebraska, where I live.
Would you tell the court about your background in media intelligence?
Sure. Might sound cliche, but I was born into the business. My father acquired a press clipping service called Universal Press Clipping Bureau in 1959. Eventually met my mother. Without further detail, eventually I became in existence. It's a technical phrase, I'm not sure. So working alongside my father growing up was just part of the DNA. I studied psychology and communications in college, and when I graduated, the internet was beginning to become a thing. And so I saw a future of data mining and expanding what was a press clipping service into the future. So my full-time employment with Universal at the time started in 1991 and came to today.
Beyond your 30 years of experience that you've described in your educational background, do you have other qualifications in this area?
Yes. So in the mid-90s, I developed a framework for comparative media analysis where we could take those data sets and compare. My first project was letting hospitals compare themselves to others to see how one brand of a hospital might compare to another within a community or market. I also invented the first multi-channel media monitoring software that would let us monitor multiple TV channels on one computer and write the closed captioning text to a database simultaneously. Innovations not quite as exciting as those continued throughout the years. I also made other acquisitions, which I then folded into Universal, buying up other monitoring services in Alaska or Wisconsin or wherever. Eventually merged my company with TrueScope, a technology company out of Australia. TrueScope owns Universal Information Services at this point, and we're adding AI and other natural language processing to what we do.
What about organizations? Are you part of any organizations in this field?
I am. There's a global organization of all media intelligence services called FIVEB. That's spelled F-I-B as in boy, E-P as in Paul. Every continent except the uninhabited ones have many, often multiple media intelligence or media monitoring services. They belong, or most belong to this organization. My peers in this organization elected me president to lead this organization at a global level last year. I'm currently the president of FIVEB.
And have you ever testified related to your expertise before?
I have been asked to do that and have done so, yes.
Before you start talking about the data in this case, how closely have you followed this case on a factual level?
I kind of have a personal standard operating procedure that when a client engages us on a topic that I feel for our company may become contentious or may have downstream effects where I might be called to objectively testify, I purposely remove myself from evaluating the content of the data set related to the subjects they're asking us to monitor. So while I have made myself familiar with the search strategy, the keywords, the phrases, which would include the defendant's name and the family names of the students that are victims, I have done very little. I paid very little attention to the media exposure on this. In fact, I just learned that the judge of this case has a last name that sounds like he was born for this role. That was last night. I didn't know who the judge was. Coincidence. My apologies for not knowing who you were until last night. Thank you.
Are you familiar with Ms. Saucier, who testified last year in this case?
Yes, Jean Saucier is my right-hand person. She's a senior vice president of client success. She has a media measurement background that started years before she came to be under my employment. I would venture to say she's as much of an expert in this area as I am. And if she was actually here, I'd probably say she's more of an expert, but since she's not, I'll tell you that for myself.
So for context purposes, when she testified about data in TrueScope, is it the same set of data that you've just testified to?
Exact same data. We work at the same company. We have access to the exact tools. She works with clients directly as herself, and I work directly with her.
How is TrueScope using media intelligence in this case?
I'll say it maybe functionally. We have been asked by you, our client, to track specific topics related to this case, names associated, and I might say the more unique a phrase is, the more accurate our media monitoring can be. If the name was John Smith and Susan Jones, then we have to do much more Boolean logic, apply more Boolean logic to make sure that we're focused on extracting it's very specific. So for you, we've built a search query using Boolean logic and AI to focus on the stories that are of interest in this case. The second half of what we're doing, so that's the media monitoring. We first capture the data. That creates a data set. Then that data set is analyzed by our analysis team, which is led by Cheryl Lewis, Theril, Lewis, Lewis. And she has an assistant data analyst who they're trained in a way that we call cross-coder proficiency. So whether Cheryl analyzes a story or Harry, her assistant analyzes it, they analyze it in the same manner. That also creates a check and balance that if something in the media monitoring function picks up a story that matches the name Judge, but for some reason isn't the Judge associated with this case, the analyst then at a human level can say, that's the wrong Judge, and it would be removed from the data set at the analysis level.
What objectives is TrueScope trying to achieve in this case?
We've been primarily asked to look at the without even being hyperbolic, would say an extreme amount of media coverage, its impact on a population or a community, and the statistical volume of that media exposure on various communities across the U.S., but focused on several counties within.
How long has TrueScope been gathering data for Mr. Kohberger's case?
I believe we were engaged on February 15th, 2023. We have some ability to pull some data forward from that time, but that's when technically the engagement came.
And you've talked about the media types and the data that's gathered. Is area or location of media coverage able to be determined?
Yes, in most cases, maybe I'll separate that into two areas of media. You have traditional media, which would be television, radio, newspapers, magazines, even online news sources. Those are all tied to a specific city and state. You have the Moscow Daily News, and the metadata that we have attached to that source would say, okay, that publication name is in the city of Moscow, in the state of Idaho, and has a circulation figure of, I'll say, hypothetically 3,000 readers. I don't know the exact circulation on that specific date. For television, each television news affiliate, local news comes from what's called a local news affiliate. It may be the ABC affiliate, but it may have call letters such as KXLY, I think is one of the Spokane channels. And they may be an NBC or an ABC affiliate, but they're the local affiliates who's in charge of airing local news. And Nielsen media data, Nielsen services, you may have heard of Nielsen boxes and market ranks and things like that. They know that that station is in this city, in this state, and each affiliate is part of a DMA, a designated market area. Stop me if I'm going too far down the rabbit hole, but a designated market area, although the news may come out of Spokane, Washington, the designated market area is a radius around that can take in additional cities, counties, and at the functional level, consumers of news, viewers in this case.
Is frequency of media coverage able to be determined?
Yeah, we, since on television, newspapers, online, demographics can change over time, can change by day. So a good example of frequency, why frequency matters. A local news affiliate might have a 6 to 7 a.m. newscast, a midday newscast, a 5 p.m. and a 10 p.m. Depending on what time zone you're in, those can be adjusted based on network. But let's say that they ran a story about anything. They might run it in the morning where the demographics skew one way. They might run it at midday, which might have a much smaller audience or potential viewership. They might run it at 5 o'clock, which would have people who come home from work early or those who are unemployed. And then at 10 o'clock generally can be the largest audience. So knowing what time they run it lets us know the demographics, the audience, and even a vanity metric called ad values. We won't get into that, but what time a story airs and how many times it runs, we aggregate that and we can say, okay, this story ran 4 times on this channel on one day and had a total viewership potential of, say, 50,000. That doesn't mean I watched it at all 4 times. That just means the viewership each of those times has the potential to see it. And that's where frequency comes into play.
Are there types of media coverage that Truth Scope does not gather?
We don't track anything that's illegal. We don't go behind, we don't penetrate privacy rules, such as your personal Facebook pages if they're marked private. We also don't look at streaming entertainment channels such as Peacock, Hulu, where the content on those channels often is broadcast originally in a specific time zone. We call that an ephemeral broadcast, where it aired at 5 o'clock and then was lost to the ether. But Hulu and those streaming channels give the opportunity for that story then to be posted, and you can watch it at your leisure in a time shifting. We don't monitor those adjacent streaming channels, because they're subscription based, demographics are different, and we already have the content as it was aired originally.
I'm going to hand you what's been stipulated and admitted as a part of Exhibit C. I've shown the state, Your Honor.
Thank you.
Can you tell the court what that is?
That is a very base level spreadsheet of all the media exposure, just looking at some of the topics specific to this account that you've engaged us for, including the topics that you've specified we monitor for your account. It includes various things like the type of media, so it might be Twitter or print or broadcast. It would include The metadata we include city, state, circulation, viewership, things like that. There's also hyperlinks. As a client of ours, you see if you exported this from your workspace or we exported it for you, you would have a hyperlink. You would click on that. Because we have a cookie on your computer, it would open that hyperlink and you could see the full story. Unless it's an online story or a social media story, then we take you directly to that end source. So if it's MoscowDailyNews.com and it's in front of their paywall, you would click on that link and you can view that story yourself.
Is Exhibit C in front of you specific to Latah County?
Yes, I see under county.
I'm sorry, y'all. I got a headache.
Checking it and spinning through where it can be determined, either all Latah County
Let me see if my deaf viewer is still here.
related.
She's not.
Some of them are cities within Latah County.
Is the list of Exhibit C approximately 1,360 entries long?
Yes, I can confirm that's the number of rows, which and each row would indicate a individual media mention, or also known as a media story, an article or a news story on a broadcast.
And Your Honor, I won't have him hand that to you now, but for purposes of the record, that will be a paper copy for the court's file. You have that in an Excel spreadsheet that's much easier to read than what is in that paper in there.
Right, okay, so this was agreed by the state too. So I just want to make sure, because I have the exhibit C also that was attached to your brief,
Which is
300 pages. So, but then we have the additional C, which is more I guess thorough.
So this is a part of C related to TrueScope, which is this list of the 1,300 stories. And then I'm about to get into the other part of Exhibit C, which is TrueScope's report.
Okay. Okay, great. Thank you. Just wanted to clear that up.
Did you prepare some other documents that represent media coverage in 4 counties in Idaho for this case?
We did. Once TrueScope had and it's an ongoing thing. We're constantly monitoring your news. So even this morning, you would have received a report of any media exposure that has happened since yesterday morning. It runs on a 24-hour cycle where we pushed out a report to the clients, but we're collecting it in real time. So if a client wanted to look at their workspace at 3 p.m. today, all that news would be in there. I may have digressed from your question.
That's I'm going to hand you an exhibit.
Okay.
This is the second part of C. And I'm going to put that in front of you because it might be easier to see. You've got 2 screens.
Yes, that was the second part of my answer. We did prepare a media measurement analysis, Cheryl Lewis's team, and that's part of the combination of services that we're providing.
Okay, looking at this page here, can you please explain to the court what this is?
Sure. You have 2 pie charts. On the left, you have the volume of media coverage specific to the keywords and phrases searched for our client related to this case. You see on the left, out of all the media coverage between January 2023 and July 15th, 36% of that coverage, or just over 36% of that, was seen or had the opportunity to be seen in Latah County. On the right side, you have another pie chart that shows the population of Idaho, and it shows what percentage Latah County represents of the total percentage of Idaho, which is 2.75%.
On the second bullet point of notes there's some reference to census. Can you explain that note?
Sure. The census data used for this one's from, I believe, July of 23. Of the 40,924 people in Latah County. We were asked to look at age eligible to serve on jury duty amongst all of that, the people in the county, which equated to 61% or just under 25,000 people of the nearly 41,000 all are age eligible to serve on the jury.
Right.
In Latah.
Going to the next page. What does this page tell the court?
This is the same analysis framework performed on a different county. Again, on the left, you see the total media coverage in Idaho for the same date range, but 34% of the media coverage was seen in Ada County, which is just a couple percentage points below that of Latah County. The primary difference is the right-hand pie chart, which shows the population of Ada County relative to all of Idaho. And it's over a quarter of the state population, so Ada, or 26.42%.
What conclusions do you draw when you compare the two counties' data?
There's a lot more people in Ada County. And where I would be going with that as a media analysis, when I would interpret this from a media analysis perspective, is the propensity to dilute the media exposure in a larger population is a factual function of that. If you have a certain number of stories divided by the population, the number of stories a person can see is fewer if the population is larger. Did that answer your question, or was I?
I'll follow up with another specific one. Out of the two counties, where is the most opportunity for a resident to view stories about this case?
It's by far in Ada County. When we did the analysis of the age eligible process, nearly 300,000 people in Ada County are jury age eligible, compared to just under 25,000 in Latah County.
I'm gonna just ask my question again. It was probably inartful on my part. Do more people in Latah County, is there more saturation in Latah County or more saturation with media coverage in Ada County?
Yes. A person in Latah County would be exposed to far more media coverage than people, a community in Ada County.
Can we now switch to the third slide? What does this show?
This adds in 2 additional counties that we were asked to look at. It reflects media exposure specific to Bannock and Camden counties.
And and then there's also a gray area rest of Idaho. You just want to explain what we see here?
Sure. So if you look at the volume of media coverage for the same date range that the first 2, Latah, Ada, and then 4 counties we're looking at, out of all the media exposure for the state of Idaho, Latah received 36%, Ada had 27%, Bannock 1.56%, and Camden just over 3%. The rest of Idaho got just under a third of the meetings. So outside those 4 counties, the rest of the counties in Idaho, or the rest of the people that, the rest of the regions in Idaho would have been exposed to approximately 31.53% of the media exposure.
You turn next to, I believe it's page 5.
Just bring it to Texas. You won't have a problem.
Explain what opportunities to be seen are and the differences in the counties.
Sure. So
Ada,
pie chart again, we're looking at the
talking
same
about
date range.
my county.
Opportunities to be seen are maybe best described relative to probability versus possibility. Each person in any of these 4 counties, or the rest of Idaho for that matter, have an equal possibility to see a story. It's like flipping a coin. You can flip a coin 100 times and the possibility of it coming up heads is equal every time. The probability of it coming up heads every time is much different. Probability is a mathematical statement, a quantitative measure. And so opportunities to be seen are dependent on the media type. So we measure opportunities to be seen for, say, newspapers based on their circulation. These are paid subscribers who you then pay to receive that news, they consume that news. Television has Nielsen audience figures. Nielsen measures those in smaller markets quarterly, in larger markets 6 times a year, I believe. Any of the broadcast markets we're talking about and the DMAs affecting this pie chart would be measured quarterly. So opportunities to be seen are the possibility that people in that county would see it. It's the volume of those opportunities that creates the potential opportunity or probability that they've been exposed to X number of articles or media mentions, discrete articles, stories about this topic you're having us track. The numbers reflected on the pie chart show that over half of those opportunities to be seen reside within Latah County, nearly 60% or 57.03%. The opportunities to be seen per person in Ada County is 31.2%, not quite half, but nearly half the opportunities. And that's a simple mathematical function of all the media exposure in that county divided by the population, or in this case, potentially age eligible for jury population.
And in terms of the green sliver there, Canyon County is close to Ada. And so if we assume that Canyon County residents might review Ada County news with its population of 180,000, is the dilution of Latah County or the dilution of Canyon County still significantly greater than the saturation in Latah County?
If I understand the question correctly, how I may answer that is Canyon, and I would also say Bannock, unless you don't want me to mention Bannock, but the media exposure specific to those counties is statistically insignificant relative to the rest of Idaho, Latah County, and Ada County. In fact, if you combined all those two and grouped them into either one of those, it wouldn't change the inferences that we make on the data between Ada and Latah.
Can you turn to the next slide now? Tell the court which line represents which county and the color.
Sure, the darker line, the red line is maybe the easier one to see. That's Ada County, and the darker line, it's a blue or might look black on the screen, is Latah County.
And Judge, for your purposes, this is C1 that was filed with the reply, which is an update from the original memorandum to include a more recent date, the date that we filed, August 19th, the reply. So I don't know what one you're looking at, but the one on your computer screen is the one that we're talking about right now.
Thank you to tell me that.
Could you explain, Mr. Murphy, what the purpose of showing this over time does for the court?
Yeah, one of the more interesting charts that we develop for our clients is media coverage over time. And in this case, we're looking at January 1st of 23 through August 19th of 24. If you look at the red line, which is Ada County, you can see that aside from May 2023, it often lags by volume of coverage behind Latah County. In most cases, by 50% or more of the media coverage. So if I rephrase that in maybe simpler terms, the media exposure in Ada County for the majority of time between January 2023 and August, continuing into August 2024, has been far less in Ada County than in Utah County.
And what can you tell from the spikes? Have you correlated those with case events?
Sure. It might be convenient to look at it analogous to maybe a stock portfolio. Oftentimes a peak is followed by a valley, unless you invest in NVIDIA. But May 2023, you see 198 stories. I believe that highest peak for Ada County was the indictment is what's driving that peak. Now, when you compare that to Latah County, I can see that moving towards that indictment, there was ongoing media coverage. So while Ada spiked, it had a quick uptick in what I would call a fairly slow decay because of the extreme nature of the topic of this story. When we look at Latah County, it is more consistent. And after the indictment, Latah County surpasses media coverage over time consistently up through August of this year.
And this was filed with the court on August 19th, and we're here on August 29th. Have you been able to review and see what's going on with the coverage regarding this case right now as we sit here?
Yeah, I took a look Tuesday. I started seeing the media exposure ticking up again. It was fairly high yesterday. In my professional opinion, I would wager it's going to be extremely high today. And that's a function of public interest in an extreme news story. A story, you may have heard the phrase, this story has legs. A story that is extreme, unique, atypical, has greater legs than, say, high school football scores you hear on the 10 o'clock news on a Friday night. Those would have a very fast decay of memory on consuming viewers. This type of story will remain on the mind and be of interest up to and beyond the conclusion of this case, however that might be.
Would you flip to the next slide? This green line, what does it show?
It shows somewhat of a similar pattern across the entire country. It's the same date range. It's also showing media coverage over time, but it's looking at all media exposure nationwide. So while you feel things very acutely locally, even a story as extreme as this garners less interest the further you get away from the local community. And to look at this on a nationwide chart like this, you can see it remains in the mind, and these are large numbers. The indictment of over 13,268 or 13,268 media mentions on May 2023 shows that the nation was interested in it, but that decay has been faster on a nationwide level just because, according to the decay of engagement on news stories, the further you get away, the less, I don't mean to sound callous, but the less interesting it is if you're in Florida than if you are in Latah County or something.
So in terms of looking at decay, I want to ask this in the context of the story waning for the court's purposes of projecting, say, months down the line next year at trial. Based on the data that you're seeing, is this story waning in the news?
No. In fact, if we could make one more line on any of these media coverage over time charts, you would see an upslope. On the first one, this chart, you already see it ticking up when I compare Latah to Ada. If we could bring that chart forward to today, you would see that going up, and that will be consistent anytime this case has significant news or a significant hearing in Latah and Ada County. It will be of interest, and I would say that the delta or the difference between Latah and Ada County will continue to be statistically similar. It will probably potentially always be of greater interest in Latah County than in Ada County. Not to diminish the interest in Ada County, it's just, I believe it's further away than Latah County from where the alleged crime was committed, or the crime was committed.
Is Nez Perce and Lewiston are they a part of Latah County's designated market area?
To my knowledge, yes.
What does that mean for Lewiston and Nez Perce to be a part of the designated market area of Latah?
That's real simple. If the population, those are counties or cities?
Nez Perce is a county, Lewiston is a city.
Okay, so the population of those, I guess, could you rephrase the question?
What does it mean for those for Nez Perce County and Lewiston City to be a part of the Latah County designated market area?
Okay, so that would increase the population of people that have opportunities to see the story within the same designated market area. So if you're in Latah County, you have the same potential to see the stories in Nez Perce and Lewiston. Does that change the mathematical outcome of the original pie charts we looked at? Those two counties combined with Latah County would have to exceed the population of Ada County in order for this dynamic to change. I don't know how many people are exactly in each of those counties, but if together with Latah County, they exceed 295,000 potential jury eligible jurors, then you might be able to say the impact from the media on those two populations, exposure to media could be equal. But if Nez Perce and Lewiston are smaller counties and together with Latah are still significantly lower than Ada County, that's not going to change the determination I've made in this data.
I have no further questions.
Thank you. So, Ms. Beatty, here.
Yes, Your Honor.
Thank you. Cross-examination.
Just briefly, Your Honor. Good morning, sir. Just for my own clarification, on those pie charts, when it says Latah County and Ada County, are you limiting that to the boundaries of the specific county, or are you talking about the broader designated market area?
When what we're looking at is media mentioned that impacted the county.
The county specifically.
Right. So.
Thank you, sir.
Yeah.
So in looking at those line graphs that you presented, I noticed that they started in January of 2023.
Correct.
So December of 2022, Mr. Kohberger was arrested. Were you able to make any determinations of media coverage in December of 2022 at the time Mr. Kohberger was arrested?
We were not engaged nor tracking the media.
Okay. And that's not possible to go back and track that?
We can do what's called a back search, but we can't. Certain media types have expired. Online news links, social media might have been taken down. So you can do it. I wouldn't say I would present it with confidence.
Thank you.
I can show you a number.
Thank you. So fair to say, though, that there probably would have been a pretty substantial spike at that time as well.
I would say yes.
And possibly, although you can't say for sure, that spike could have been even higher than any of the other spikes on this graph, possibly.
The possibility exists.
Thank you, sir. So For the first 6 months on this chart of volume of media coverage over time for Latah and Ada County had more intense media coverage in January, February, March, April, May, and then June, and then in July, there's that crossover where Latah County is higher than Ada County. So fair to say for that first 6 months, Ada County did have at times fairly significantly more media coverage than Latah County.
Correct.
Okay. And council talked with you about these peaks and how they correspond with specific events in the case, such as court hearings. Would you expect that if the court were to make a decision to start closing certain hearings, particularly evidentiary hearings as we approach trial, that would be a mitigating factor that would decrease the amount of media coverage in this case?
I can't say yes or no on that. I would say it depends. If those closed meetings were a public record, then the media most likely that's following this would still have a high probability of reporting on it. They may just not have any image or interviews or some of the elements that go into a more engaging news story.
So the coverage might be less intense.
Intense is a qualification that I'm not able to make. I can't tell you how intense something impacts you as a viewer or a consumer.
Sure, thank you. And I noticed in that chart of Latah County and Ada County coverage that in the last couple of months, that coverage intensity in both of those counties has become pretty close again. Is that fair to say?
Yeah. Yes.
And so based on these charts, it's really not beyond the realm of possibility that Ada County could again surpass Latah County in coverage, at least at certain points, correct?
Again, there's an equal chance of possibility. The probability based on the data, I would say is no, in my professional opinion. We've already seen an uptick, and it appears that in Ada County, the news is much more focused and attentive, even to what I might consider a less weighted story. I think there was a story recently about a memorial garden or something that this county garnered quite a bit of media exposure. But that's logical. Sure.
Well, in June of 2024, it looks like they got so close that they were just 2 points apart. Is that correct? Latah County just 2 points above?
Yeah.
And you're not willing to testify that there's a possibility that Ada County could potentially surpass Latah County in the future?
I'll absolutely guarantee that possibilities are always equally available.
Thank you, sir. I have no further questions.
Okay, thank you, Ms. Beatty. Ms. Matthew.
Mr. Murphy, in terms of this discussion on Ada versus Latah, you mentioned the Nielsen rankings. Could you please tell the court the difference between what the Nielsen ranking is, and then I'll follow up with what Latah's is, and what Ada County's is. So what's a Nielsen ranking?
Sure. So I don't want to assume that most people have heard of the Nielsen ratings, but anyone who's involved with selling advertising or the news media knows that Nielsen for more than 50 years has measured the top 200 designated market areas. New York City is number one. It's the largest DMA. The media in that market reaches the most people. And so it's a measure of how many active news consumers, is the way I would describe it, are in a city or a city's area. I know we're looking at counties, but your designated market area here in Latah County fall under the radius, I think I mentioned earlier, Spokane, Washington. In Ada County, their designated market area is Boise, Idaho. A different deal.
And what's the Nielsen ranking of Latah County?
It's ranked 64 out of 210.
And what is Boise?
97.
I have nothing. So I should follow up and say, in terms of how that's measured, 64 mean that is a higher rank than Boise at 97.
The DMA in which Latah County resides has far more opportunities for media stories to be seen based on the strength of the DMA. As you get down to the smaller DMAs, for example, Glendive, Montana, has historically been market 210 last. They have one CBS affiliate. There's just not a lot of news coming out of an area, a DMA like Glendive. But on the two counties you're talking about, they reside in a DMA that's 64 for Latah County. A larger DMA is going to have more media opportunities to be seen and more media outlets available. As you get to smaller markets, you have fewer and fewer media outlets serving there.
Nothing further. Thank you.
Thank you. Ms. Beatty?
Nothing from the state, Your Honor. Thank you.
Okay, may this witness be excused?
He can, Your Honor, and the exhibits that are with him can go for you for the court's paper file for the record.
Thank you. Okay, sir, you're free to leave or you're free to stay. Thank you. Appreciate it. You being here. Thank you. Thank you. They're very small letters.
I agree, Your Honor. It was really hard to get them on one page. Sorry about that.
Thank you. Why don't we take a quick break and maybe come back at 10:20. Okay? Thank you.
Hello. I can't hear you.
Okay, guys. So, I was saying a few nice. I was being super sarcastic. But anyway, he's a good expert witness. I wonder how much it costs to pay that witness. My gosh, those guys are thousands of dollars an hour in court and minimum of 2 hours, that kind of crap. But the one thing I just question, and I know they kind of touched on it, but how reliable is this data? I mean, if he's not doing things like he said Peacock and some of these other channels that may have stories. Also, is he taking into account? He's not even taking into the account what's called local gossip, word of mouth. I mean, there's a lot of people that go have lunch. Hey, did you hear about this trial? You know, everything he's taken is only in the news and it's metadata. I get it. But
what is this trial about?
Okay, do you remember the 4 college students that lives were ended in a sorority or an apartment home? Yeah, this is the murderer. And so, God, I got both animals frustrating me right now. So this is kind of a pretrial. Now it's June of 25.
is when trial is set. But this is one of the most important hearings because the defense wants this moved out of Moscow, Indiana, or Idaho, sorry, Moscow, Idaho. And I got a mosquito bite. Ugh. And then they're wanting it moved to Ada County. My county. I don't know if I want this in my county. But they don't think that he's going to get a fair trial by not being able to get a jury that's not already tainted by the media. And they want to move it to another county, big county. It's the biggest city in Idaho. And I think it's also, they're not really saying it, but it's a bigger courthouse. But like lawyer said, it's going to put a little bit of a strain on everybody in the court process when trial happens. Everybody's going to have to travel further. They're going to have to house him in that county jail. What? Did he not feed you? Seriously? The cat is trying to climb up on my desk. Come here. Without knocking anything over. That's going to be funny. And so I would say anywhere in the United States is going to be hard, but especially in Idaho, how are they going to do this? I mean, it's just like the Murdaugh trial. And then there's a lot of people who just doesn't pay attention to the news. They may have heard about it. They may go, yeah, I heard about it, but I don't know any detail specifically for me. I know about it. I know that these college kids have passed on, and I know he's been charged, but personally, I haven't followed it. Part of the reason why is because I have a college student, and I did not want to follow it that closely because I don't want to live in a nightmare. Is that where she got her ID? What do you mean? I don't know what you mean. None your business. I haven't followed this because I don't want to live in fear. Now my daughter's been in college a couple of years. We're all good. But Cincy, you need to lay down. Oh. Let me let the cat out because she's driving my service dog crazy. Is this what you're wanting? You want out? So you're going to be a little pest? There, go, bye. Cincy, go place. You have your bed. Now go place. Cincy, place. Come on. Good girl. The kitten, I call her kitten. She's young. She's not even a year old. She's probably about, place, Sensei. She's about 6 months old. Oh, that's where I got my ID. Oh, no. Sensei has her own dog bed, and then I have a cat bed that's about the half the size of the dog bed. Well, the cat comes in and takes over the dog bed, and the dog goes and lays in the cat bed, and she ain't happy about it. So both of them are harassing me until I do something about it. Dang nabbit. So anyway, Ada. No. I'm named after somebody. So anyway, I will be diving into this case too, but not until we've got other trials coming up. And then after this is over, we will listen to the judge audio on the Chad Daybell case about the extraordinary circumstances in which the judge is granting more time to the case. While we're doing that, I got some wonderful information from, okay, the motion to dismiss PDF that I got, and then the numbers. Remember the one we got in the I'm going to move this over here. You remember this? I was just informed that it appears that motion to dismiss wasn't from Sarah herself, but a third party, and the judge has denied it. So let's look at that. And I got to embiggen it. Come on, get me up here. Let me embiggen it. Okay. Order striking motion to dismiss the case charged with constitutional authorities. This case has come to be heard before me in chambers on August 29th, 24, upon the motion to dismiss case. You ready, Miss Diane? You ready? Because I'm reading now.
I'm reading. Okay. Ready.
Okay, this case has come to be heard before me in chambers on August the 29th of 2024 upon the motion to dismiss case/charges with the constitutional authorities filed on August 22nd, and the court having reviewed the motion, the court file and being otherwise duty advised in the premise hereby. The court finds as follows. The motion was received in the court on or about the 27th of 2024. The motion was filed by a non-party. As such, it is therefore ordered and adjudged as follows. Motion is hereby stricken. Done and ordered 29th day of August 24. So who filed the motion? The judge also hereby certified that a true and correct copy of the foregoing has been furnished to each parties, including Sarah Boone. So the person who filed this was not Miss Boone, and in fact was don't know who Tiffany Moore Russell is, but the return address is a Raymond and Crystal Bryson in Bakersfield, California. So so they gave Sarah Boone, yep. That ain't good. But the judge did what was necessary and correct. So now we're just waiting on, by the way, I did do some interpreting on this because we had a deaf person, Diane, but she's off. Bryan Kohberger, Kohberger. I'm doing B. K. Burger. I just had a cold burger. No, it was a good one. Yeah, we can do that. Diane, you shouldn't be eating on you shouldn't be eating on my live, girlfriend. I'm kidding, but I'm going to give you respect and let you. Oh no. Is that the one I gave you? Tracy loves blue truck, the little trucks, and a candle fell on her truck and she's upset. It's possible, but it's not going to cause any kind of problem, I don't think. But whoever did it was a fool for the way they did it. Now, I thought it was kind of strange that they marked out the numbers. I'd said that as much, but yeah, that was interesting, y'all. Very interesting. My head feels like I've been swimming all day long. It's that swimmer's kind of usually means I'm getting a migraine since the hat keeps the light off my eyes. Is it signed by whomever sent it? Well, um, no. But what they did put was inmate. Let me blow this up a little bit more. Sarah Boone, inmate number, Orange County Jail, and all that. Attorney Sarah Boone in the Superior Court of Florida, Orange County. It does not say who created this. Okay, Miss Russell, Tiffany Moore Russell, is the circuit court of clerk. Tiffany M. Russell is a clerk circuit. She's a county clerk. So Raymond and Crystal Bryson are the ones, one of those two filed it. Yeah, ain't that the truth? Somebody earlier called me the ASL, what was it, the EDB and ASL interpreting? They didn't know EDB. Guys, a lot of times I wear these hats because I'm getting a headache and it cuts that light because otherwise it's like, whew. When I'm not getting a headache, we all good, but this cuts that light down off my head. So, yeah. I woke up at 6 a.m., no headache. Everything was great. I just went, got in the tub. Wonderful. Got the tub at 6 a.m. because I fell asleep at 10. And as soon as I hit that warm water, and woke up again at 8:30 with a headache. So there I go. I shouldn't have done that. Oh, for those of you who were wondering, I picked out a new color for my wheelchair. Usually it's black, and I thought maybe a dusty rose would have been pretty. I agree with Nanya. Yeah. I thought a dusty rose or something lighter would be pretty, but the colors I had to choose from, the pink was neon. And when I say neon, I mean neon. But I got me a kind of a dark purple. It looks black till you get close, and then you can see the purple flecks. You get purty. Kind of got fussed at yesterday because I have the intracranial hypertension. Uh-oh, I gotta go get potty for the dog. But anyway, when I'm imbalanced, I should be in it, and I haven't been. So let me potty dog. We be right back, y'all. Oh, I lost. Okay, we're going. Hold on. I need to share screen. I forgot. I accidentally knocked it off. Kohberger motion hearing. There we go. We'll be right back, y'all. Come on. Let's go. You will go outside this time, baby girl. Come on. No, ma'am. Come on. Let's go.
All rise. Thank you very much. Please be seated. Okay, let's get back on the record, please. Back on the record, State versus Kohberger, CR 2922-2805. Sorry for the delay. I think we had to adjust some mics, make sure everybody can hear. And counsel and Mr. Kohberger are here in the courtroom, so we're ready to go forward. Next witness.
Thank you, Your Honor. We will call Dr. Anani L. Alili.
All right, thank you. Thank you, ma'am. Please raise your right hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you. Please have a seat and then please state your name and spell your name.
My name's Anani Alili. Last name is E-L-A-L-A-Y-L-I.
Thank you. Ms. Taylor.
Thank you. Good morning. I can see you brought some papers to the witness stand with you today. Will you identify what those are?
Yeah, it's just copies of the slides. It's nothing. None of my piece I couldn't see.
Okay, and the slides, does that refer to the PowerPoint presentation that you for us to share today?
It's
okay. At this time, will you place that document in front of you face down? And if you have difficulty seeing the slides, let me know and we'll have you turn it over so you can track and help us understand what you're going to teach us today, okay?
Sure.
Yeah, I want to make sure then the state has stipulated to admit that.
That's correct.
Slides. Okay, thank you. So all the slides that we might be considering today, you agree to?
That's correct.
Okay, thank you. Go ahead.
Thank you, Judge. Will you tell us what you do for work?
I'm a professor at Eastern Washington University.
What do you teach?
I teach social psychology, which is the study of how people interact with each other and influence each other, how we're all affected by social situations.
I'm going to ask you some questions so that I can understand
I'm
the
not
background
sure.
that led
They're
to
not
your
saying.
ability to teach. But I
think
want to know if you're
I'm
here
not
today
putting it.
in your capacity as a professor or in your separate role as an expert consultant.
And here's my separate role as a consultant. So what I'll be talking about today is based on my expert opinion, based on the research I've conducted and what I've learned about in the field, and it's not affiliated with the university.
Thank you for that. Now let's go to your education. What degrees do you hold?
So I have a bachelor's in psychology, and I have a master's and PhD in social and personality psychology, with a focus on social psychology.
What does that mean, a focus on social psychology?
So our area, like I mentioned, it studies how we interact with and influence each other, the power of the situation and how it affects us, like how we're all behaving differently here than in our living rooms. It includes things like how people influence us to purchase things. Like I teach a class on social influence, or influence us to donate money. And then my specific area of focus is on social cognition, which is how we select, remember, and interpret social information.
How long have you been teaching?
I have been teaching since before I graduated from my PhD, so since the late 90s. But I started my positions as a professor in 2002.
2002?
2002 at University of Florida, 2003 at Eastern Washington University.
In your role as a professor and a professional, have you written articles and been published?
I have.
How many, roughly?
Roughly 15, give or take.
Do any of those relate to human bias?
Yes, most of them. So a lot of them are focused centrally on bias, and then many of the others are tangentially related to bias. So it could be biased perceptions of ourselves, how we tend to overestimate ourselves in a lot of ways. It includes biased impressions of individuals, like you might take one thing about a person and make a whole bunch of conclusions about them when you don't know them. And that could influence how you perceive their behavior later on. It includes biased perceptions of groups, so stereotyping and prejudice. And I've also studied biased impressions of businesses.
Have you consulted as an expert in other cases besides Mr. Kohberger's case?
Yes, I consulted in a case around 2016 or so, and then I was involved in the non-dissemination hearing here as well for Mr. Kohberger's case.
So you're telling us that you testified before Mr. Kohberger's case. Is that correct?
Correct.
And have you testified as an expert in any other hearings besides that one for Mr. Kohberger?
For Mr. Kohberger, no, just that one.
How about other people?
Yes, one for, and the case I didn't eke it out. I have a full-time job, plenty to do. But I've been asked to do expert testimony, and I feel like it's the right thing to do to share what I know about bias.
Thank you for that. What is your role today? What did we hire you to do and ask you to do?
So my role was to evaluate how publicity about a case could shape potential jurors when they come in and sit on a panel, and to see if maybe people who were living in Latah County or have some connection to Latah County might potentially have more problems being objective because of media saturation and other issues.
Did you prepare a PowerPoint to help walk through what you have to share today?
Yes, I did.
I'm going to do my best to open that up.
Please.
I am trying to find the right.
You would just go to slideshow, right to the top, maybe 6 down to the right. One more, right. And then on the left, towards its front beginning.
Okay. I think we're there. Thank you for helping me through that.
Do this regularly.
I thought I had a problem for a minute.
All right. I want to know if this is the background of the research on potential juror bias. What do you know about that?
Yeah, so there's been a lot of research on how publicity affects potential jurors. It says roughly 40 years. Really, it's been longer because in the 1960s, there were some high profile cases. And so social scientists wondered, does it matter if there's a lot of publicity about a case? Could that potentially make jurors less objective? Could that influence actual outcomes in a case? And so the research started then, kind of trickled in, and then became more and more popular. And then in 1999, there were enough studies that somebody conducted what's called a meta-analysis. And another one was conducted in 2022. So it's nice to have a recent one. A meta-analysis is when you take a bunch of studies on the same topic and you statistically combine them into one giant study. So they do this in every field. They do this in medicine, every discipline, where you really want to know an overall effect of something. Because I might run a study on the effects of pretrial publicity and find maybe a small effect, and somebody else might find a big effect, and somebody else might find no effect. And it's hard to trust any one study with, a few dozen participants, or even if it's hundreds. I would want to see lots of studies. Just like if I were trying to decide if I want to take a medication, I don't want just one study that tells me it works or doesn't work if I have a serious illness or the medication has a serious risk. But I would be much more confident if there were a whole bunch of studies, dozens of studies combined, and thousands of participants' data. And so a meta-analysis basically does that. It narrows down a specific topic, in this case, the effects of pretrial publicity on judgments, and it examines overall, combined, is there an effect? And so there were, like I said, one is quite recent from 2022. So it's the simplest way to describe this research. It's the easiest way for somebody to know where it stands, even if they don't read all the articles. And what this work has found is that if somebody's exposed to publicity about a case, something about the defendant, something about the case, fact, fiction, that the tendency is, if you look at everything as a whole, for it to affect judgments, and specifically how much you like the defendant, your inclination to say that they're guilty, your judgments of their criminality, etc. And this has been shown with individual judgments of guilt, but even more so with group judgments, with juries. And it looks at participants who are randomly assigned to get pretrial publicity information or not, so that you can really determine cause effect. So this would be a formal experiment. We do lots of studies, and experiments are the ones that I like to look at, because what you do is you hold everything constant except for one thing that you change. You get one people, one experience, another group of people, another experience, and then expose them to all the same things. So all the same trial stimulus materials. And you see, okay, the people who got some information ahead of time that they weren't supposed to pay attention to, did they evaluate the evidence differently? Did they come up with different judgments? And so the meta-analysis in 2022 is based on over 11,000 total participants, and it summed up the studies on that specific topic.
And the sum up, what was the sum up?
Yeah, essentially what's on the slide there are the main findings. The fact that if you get exposed to publicity, you're more likely to render a judgment of guilt, and less likely to, or have lower liking for the defendant, and have higher ratings of their criminality.
Based on your years of teaching and work and understanding human bias, do you know why this happens?
Yes, if you don't mind advancing to the next slide, I have a couple sections here. One is on why we sort of soak up this pretrial publicity in the first place. And then the next section is on why that stays with us through a trial if we are to serve as jurors, even when we don't want it to stay with us. And so if I just start with the first topic, why is it that we soak this up in the first place? One reason is because of how we process information. Since the 80s, social psychologists have studied this model that suggests that it's pretty straightforward. Sometimes we think deeply about things and we scrutinize arguments and find flaws in them. And then sometimes we make quick decisions. We like decision shortcuts. And we only have so much cognitive capacity that the vast majority of our decisions and thought processes are more automatic. And we call this peripheral root processing when it involves an influence situation. So if you're making some kind of determination about something, whether you should purchase a certain car or vote for a certain political candidate or something like that, you can go through and you can analyze every single thing and try to be as objective as possible, or you can make a decision in 2 seconds. Oh, my neighbor has that car and they like it, And so the problem with peripheral processing is sometimes you're going to come to a conclusion that you wouldn't have come to before if you had thought about things more methodically, more systematically. And so the reason this applies here is because people, when they're consuming media, are often processing peripherally. Why? Because they might not be completely able to focus on a story, or they're scrolling quickly through a newsfeed. So if you're scrolling through a newsfeed or a social media feed, or if you're watching the news while you're cooking dinner or something like that, you're taking in information, but you're not able to really devote the resources cognitively to nitpick. And so you'll see something like Bryan Kohberger arrested for the murder of 4 students, or you'll see something like this: among items taken from suspect, knives, guns. And automatically, when we're processing at the superficial level, which again, most of the time we're doing, we'll say, oh, okay, so they found the person who committed the crime and they have evidence. And we don't take it a step further. But if you actually stop and think, then you realize, oh, wait a minute, people get arrested all the time and it turns out they didn't commit a crime. Or wait a minute, we all have knives in our homes, but we haven't all killed somebody. A lot of knives in my kitchen. A lot of households have guns. And so we don't take that extra step to really think deeply about things a lot of the time when we're consuming media.
It sounds like you're telling me that we're just absorbing information. And in Mr. Kohberger's case, from the media, people may take bits and pieces, and that starts to create a level of knowledge or human bias.
We might feel like we know about something more than we do, yeah.
Are there other ways that bias gets created?
Yes, and it looks like you advance to the next slide. So one thing that's relevant here too is listening to authority figures. So I mentioned that we're processing superficially a lot of the time, peripherally, And one readily available peripheral cue, a lot of the time when it comes to this type of situation, is hearing information from authority figures, people who have status or expertise, any kind of power. And we tend to listen more to people in those positions. And yes, a lot of the time they have more knowledge, but there are big problems with this. One is that we assume that they're accurate. We forget that they're humans too, that they make mistakes too, that they have biases too. Like if I'm in charge of trying to make a community feel safe by, arresting the right person for a crime, I have a motivation. I want to make sure, I want to convince myself maybe that, I've caught the right person. And, if I'm in that position, doesn't make me less biased, right? We all have biases, all humans have biases. And they also could be wrong. Like I said, people can get arrested for a crime when they didn't commit it. And what we found in research over many, many years, decades, is that if somebody has any kind of indicator of authority, even if it's something as minor as height, but certainly, an occupational status, title, that people will take their words so far that they'll do things to contradict their own morals, and they'll be influenced in areas beyond the person's expertise, like a doctor influencing you in your relationships or something that's totally irrelevant. And so we take it a little bit too far. And in the case of Moscow and Latah County, it's a really small community, right? And so the authority figures are often going to be people who are known and well trusted. And, so that makes this effect even potentially more problematic. And as you know, Chief Fry, the chief of the police at the time, had said that he was certain that he arrested the right suspect and he didn't have any doubts. And so the community would say, okay, well, the chief of police is sure, so then I can be sure too. But like I said, we can't assume, and there's no trial that had taken place yet. And so we can't assume that that's accurate information, but we tend to take that a little bit too much at face value.
The example that you gave of the police chief speaking out and offering what he thinks about a case, is that something that creates more bias in the minds of the Latah County residents that heard that?
Yeah, they're familiar with him. They know him to be an authority figure. They may know him personally or trust him personally. And so, yeah, somebody outside of Latah County, they'll still be affected by his authority status, but maybe not as much, right? And then he also has power over people in that community, and that seems to carry some weight when it comes to this type of influence. And then also, the president of University of Idaho saying, we can feel safe now, they found the person. It sounds very conclusive when there hadn't been a trial yet. And so another authority figure is pretty major in an area like Latah because so much is centered around the university.
Are there other ways that you found that create bias?
Yes, if you don't mind advancing to the next slide. This is the phenomenon that goes back maybe a century. We've been studying this in so many different contexts, tons and tons of research on this phenomenon called classical conditioning. And it's basically when we make associations between things and it causes us to have reactions that we didn't have before. Like, for example, if your alarm clock, we don't really have alarm clocks that much anymore, but if your alarm sound on your phone, if that's what you use, wakes you up this morning and you have kind of a negative response to it, it might be because you associated it with waking up before you wanted to. Before, I know I always try to choose a sound that I don't have an aversion to, but then it doesn't take long before now I have a negative reaction. So you make this connection, right? But if that same tone was used every time a loved one texted me, then I wouldn't develop an aversion. I might develop a favorable reaction. So classical conditioning is when we develop a response to a stimulus. It could be a sound, it could be any stimulus at all, including a person, because we've connected them with something that it has been paired with, especially repeated pairings. So in this particular case, if the defendant's name is seen throughout media and social media a lot, or his image is shown alongside things that are aversive, negative words, things like terror, murder, or evil, or alongside known killers, alongside details of the murder, alongside information about, tragic consequences, things that make us feel bad. What happens is it doesn't take that many pairings, and then his name alone, which was once neutral, because most people wouldn't have known him, becomes conditioned, and it evokes those same kinds of feelings. And they've done studies like this where they can make this happen within minutes. If I could take a picture of any of you or multiple pictures of any of you, show those interspersed with pictures of other people, and at the same time present words, consciously or not consciously, that say things like terror and evil. And at the end of the study, I can ask people, what do you think of this person? And the rating will be lower. And so if you get that exposure a lot, like in LATOW, where people are getting a lot of media exposure and also social media exposure and having a lot of discussions and attending, vigils, and they're really being exposed to kind of all these emotional reactions. If they're thinking about him at the same time, they can't help but make that connection, even if they don't think he's guilty.
Let me make sure I understand how big this is, how far-reaching this is. We've been with this case pending for 1.5 years, and there's been, suffice to say, a lot of media coverage. There's a lot of pictures of Mr. Kohberger in the media. Do you mean that when we walk into trial and the room's full of potential jurors, there's going to be a great majority of them that before we sit down are going to have a feeling of bias against Mr. Kohberger?
Yeah, I do. And we've seen the pictures, these ominous headlines, and that connection can't help but be made.
Is all the way that bias is created, or do you have another one?
I have one more. As far as things that happen largely while the publicity is coming in and you're getting exposed to it. And it's sort of a category of a lot of different influences that are emotional and motivational. And this one I think is especially relevant to, sourcing people out of LATOW County to be jurors. So the media played a role in inducing some emotions like it does. It likes to attract attention, things like fear and anger and sympathy and empathy. But in that community, people are going to have those emotions anyway from everything that's going on. But if the media uses phrases like killer on the loose, everybody stay vigilant, make sure you report all suspicious activity, then they're arousing that even more. And so what happens is when we have emotions like that, they filter in how we process information. Just like when you're angry, you're more likely to remember things that have made you angry in the past than things that have made you happy. And when you're angry, you're also more likely to have kind of an agenda with new information coming in. And so, for example, and this is something that could stay with somebody, this distorted information processing could stay with somebody and could get, there could be a resurgence during a trial where it keeps affecting somebody as they are reminded of their emotions. Because, they've associated moods with different judgments of guilt. Like, for example, if you're angrier, you tend to be more punitive and you want retribution. And in fact, in one study, they associated anger of mock jurors during a trial with support for imposing a death sentence for somebody. And they, when they were angry, they were less likely to pay attention to defense arguments. So people aren't trying to be biased. It's just that when we're in moods, those moods filter how we process information, how we take it in. And, I think I may have mentioned this already, but there's also kind of an emotional, motivational component to feel like the person who committed the crime is under arrest. It is the right person. I think I mentioned it as, being a motivation by the police, but the community has this motivation too in LATOW because they were living in fear during all these weeks where they were trying to find somebody to arrest. And somebody was arrested and people could take a sigh of relief. But that sigh of relief assumes that he's guilty. And so we have this coping mechanism, basically, where we want to get rid of these negative emotions. And one way to do that is to feel like, oh, well, if he committed a crime and he's under arrest, then I can feel safe now. And so that's something that could come into play too if you live within the region where the event occurred.
And that's because of the fear that was associated with
any of the emotions really could potentially distort information processing. That last point relevant to fear, but a lot of research on how anger influences judgments and how sympathy for victims, empathy for victims influences judgments. And certainly if you are in Latah and have attended vigils and or offered social support, that you're really getting a lot of that empathy and sympathy as well, or if you're exposed to the personal media stories about what happened.
So I think I understand the ways that the human bias just gets bigger and more solid in a person. What happens if we seat a Latah County jury and those biases are there? What happens as we put on the trial and evidence is presented?
Yeah, well, I mentioned this one can get carried through the trial, this idea of motivational and emotional sources. But there are other things that can happen during trial too that kind of exacerbate the problem. And one of these is confirmation bias. So this has to do with us wanting to confirm our expectations of things. And one of the most fundamental human needs we have is a need for predictability. You don't want to walk into this courtroom and feel like you have no idea what's going to happen. That's uncomfortable. We want to feel like we know what's going to happen, and we know how people are going to behave. And so part of this need for predictability is that it causes us to distort reality a little bit. And so in one way that this does this is through the confirmation bias, which is once we develop an expectation of something, once we decide that this is true, this is the case, or the defendant is guilty or not guilty, or the defendant lives a certain lifestyle or behaves a certain way, or has, then once we decide something, everything goes through that filter. I talked about an emotional filter. This is a cognitive filter that we actually process information differently based on what we expect to see and hear. It's just like if, you're going to meet up with a friend and you think somebody called your name, you expected it. And so it made you hear it even when it didn't happen. And if somebody does call your name, you hear it more readily. So we're kind of tuned in. And so the processes I mentioned here, this filtering can happen via 3 different processes. One is selective attention. So if I'm a juror and I have expectations about Mr. Kohberger, and it doesn't have to be just that he's guilty, but it could be expectations about him as a person. If I have expectations coming in and I'm getting all this new evidence during trial, going through that filter and paying attention to information that backs up my idea. Well, I had this idea that he's a bad guy, and this information backs that up. So I pay extra attention to that. And then they talked about something where, where he was kind to someone, and I really have to pay much attention to it. So, we have this filter, and then we process information too in a distorted manner. We actually will change the information to fit in with what we think. It's just a way of our minds simplifying our worlds. And while these processes all help us not be overloaded cognitively, they distort what we take in. So we have to be aware of them. And recall is distorted as well. So, a trial takes place over a long period of time, potentially, and somebody has to remember a lot of information. And if they have distorted recall that's consistent with their expectations before coming in, that's obviously problematic.
Is that the only thing that happens when we have new information at trial?
No, I have a couple other things that I'd like to talk about. And the first one is belief perseverance, which is really a direct consequence of the confirmation bias. So it's just like it sounds. This is the tendency for our beliefs to persevere, even in the face of contradictory evidence. Confirmation bias supplies us with this filter. And because we have this filter, if somebody gives us all these facts that go against what we think, logically, we should just change our minds. A lot of the time we don't. In fact, there's some evidence to suggest that sometimes we even cling more closely to our beliefs. And anyone who's looked at anything on social media has probably seen evidence of this, where somebody has a strong belief about something and then somebody provides actual facts that contradict it. And then instead of saying, oh, you're right, I see your point. Of course, that can happen sometimes. The general tendency is for people to still stick with their beliefs anyway because they've formed them. When you're in the process of forming your beliefs, that's different. But once you've formed something, it tends to stick. It's the same thing with stereotypes. Somebody has an assumption that elderly people are bad drivers, and they see a whole bunch of evidence suggesting otherwise, and even research studies and things like that. Then they no, I still think elderly people are bad drivers. So that's belief perseverance. And in some cases, people will even double down. Again, social media, they might even get more aggressively in line with their initial opinion after seeing evidence to the contrary.
So let's get on the record, please.
These ominous I still think.
Sorry, I wanted to pause here. Y'all, I am far from trying to copy EDB, Emily D. Baker. I don't have a migraine yet, but it's pushing that. And sometimes it helps just to put the shades on. It is very, very bright focus light that we deal with. Here you can see it in my lenses. See it? And so the moment I put this on, I had instant relief. Yeah, you're throwing shade. But people, I don't want, I know I look like her a lot. You can ask my interpreter, Miss Diane, and my good friend. I'm in black all the time. I wear hats a lot. Do I not? When we're not in conference clothes, am I not, Miss Diane? Here, I'll turn your sound on. I'm sorry. Is this not the normal age?
That's the normal age.
Wait a minute, you're garbled, girlfriend.
I'm garbled. I should be. Yeah.
You sound like
This
a
is the normal
robot. It sounds like a
Do I sound
robot.
like I'm underwater? Do I sound like I'm underwater?
You sound like a robot.
I'm
But
sorry.
anyway, she's
I'm
saying that's Ada, unfortunately. Yeah, you're a robot. Okay. Why don't you hop off and hop back in? I'm gonna kick you out and hop back in.
Okay. Kick me out.
Okay. I kicked you from the studio. Come back in. So these, I love these guys. You will die if you know how much they are, but they're unscratchable. They're unscratchable. Ooh, as soon as I take that off, look how pretty. I got 2 of these, but they don't scratch. So, the moment I put them on, the headache is like a 2. It dropped tremendously. So that's telling me I'm having a severe light sensitivity. So you can see everything I'm looking at here. You can see when if I'm scrolling the internet, you can see if I'm paying attention or if I was playing. No. So I really I try to take it as a compliment when people tell me I'm like EDB. I don't want her to think like I'm trying to copy her in any way, shape, or form. This is just who I am, and if we happen to be alike, I'm in good company. We set the people straight. No, but for some reason, light is bothering me today. It started yesterday.
How about
Better.
that better?
Yeah. So
Yeah.
tell them what you said.
Oh, I said she always wears a hat and shades and black. Black. What shall we wear today? Black. And what shall we wear tomorrow? Black.
Well, we do it as a profession. We wear black. So when I was going to college, my entire wardrobe had to be black pants, black shoes, black top, no tattoos. If you wore a hat because you were interpreting outside, as long as your eyes were visible, you could wear a black hat.
Yep. Before I became an interpreter, my closet looked like a rainbow. Now it looks like a black rainbow. It's black,
It
black,
looks like
more black.
we're prepared for a funeral service 7 days a week.
Either a funeral service or witchcraft. Take your choice.
Funeral service.
Funeral
Yeah,
service.
that's the other thing. Somebody in church years ago say, "I believe you're in witchcraft." And I said, "Why do you say that? You're always in black, and only people in black. You're not." I said, "Dude, I interpret for the deaf. That is our uniform."
Yeah.
So go look it up.
It is. It is. It is. It is. It is. I
All
do
right,
cheat
guys.
every
Well,
now and
thank
then
you.
and wear
Coven
blue.
time. We're dancing around the full moon. Well, most of the time when they're dancing around a full moon, there's no clothes on.
Yeah, there's usually unclothed. They is alive, but they's unclothed. We can't say they're
Unclothed.
undead.
No, thank you.
Unclothed.
I don't want to see that. I don't want to have any part of that. Mm-mm. Mm-mm.
Yeah, and
any way, shape, or form.
I used to live where there was a lot of covens, honey. There was some wicked stuff going on. No, thank you.
No, thank you. All right, you ready to go back in, Miss Diane?
Yeah, for a little bit. I need some 5 hours or some coffee.
Well, take a break, go get it.
I will. I'll be back. I shall
Be
return.
right back. I don't understand. I understand the need for this. I do. But what baffles me is the amount of money they're spending on this. Everybody's walking away with coffee. Here, I got mine. We don't have too much that's around here. It's too cold for that crap most of the year. Sneaky, you are so right, my beloved. Y'all, I'm getting my strongest coffee that will help with my head. And, well, since we're all getting our coffee, I'm going to have the Hill Country Ethiopian dark roast. And because of that, let's hear a word from our fabulous sponsor. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. Okay, lovelies. Oh, my computer's deciding to do something interesting. And here we go again. And we're back. My coffee's brewing. I'm getting some fresh coffee. I think everybody needs coffee today. I don't think Friday can come quick enough for most of us. I wish I didn't have some that were so dark. I apologize. I really do. I am going to look in getting glasses, just like, not just like similar to, I'm thinking about taking my turtle shell glasses. You have to have your prescription put in, but the lenses can't have any of the blue light tinge or anything. It's just a plain glass. So I'm going to go have that done eventually. And then I'm going to go in another month or two. Maybe we'll see what September holds, probably October. And I'm going to go and get tested and see what color works best for me. I just hope to God it's not yellow because I can't stand yellow. I looked through yellow lenses before thinking it might help me at night driving. Oh, just didn't like the way everything looked. So we'll go from there. But right now, y'all, I appreciate your love and understanding about my glasses right now. Uh-oh, Interpreter Doggy is having a debut. Up, not no more. He decided he was done. Oh my gosh, this is full. It is full. Uh-oh, I'm going to mute the interpreter. The doggy is playing with the microphone. So what are you guys comment? Let's talk about this real quick. What are you guys thinking about all this? Is this worth it? Is the 20,000, 30,000 they're spending on this worth it? I don't know if that's exactly what they're spending, but they're spending quite a bit of money. If you add in the court fees, all of the, no, they took a small break. We took a small break. Everybody, including the interpreter, me, and Sneaky, we all needed a cup of coffee. And I wanted to take a break and explain the glasses because I'm sure EDB has already heard about me trying to copy her. Aw, none of your business. That's sweet. I thought you ate, Diane. You eating some more? Your puppers had a little debut over here. Okay, guys, I'm going to put that down carefully because it's hot and super full. Reasons for the ongoing bias during trial: belief preservation. Once a person forms a belief, they tend to stick, even if faced with contradictory evidence. They may even double down on those beliefs. This is true. But there's a lot of people who don't follow this stuff. I think they're putting a lot more emphasis on this than they possibly should. Of course, they're going to do that in order to get what they want. But I'm just kind of like, y'all, he did the crime there, then he should do the time there. I mean, now, if you need to change venue because it's not big enough, you don't have enough staff, you can't provide security, there's different things like that. I can understand moving to a new venue. But to have this kind of trial, these witnesses are expensive, and it's coming out of the county's pocket. Okay, Diane, I can't hear you. What?
I got it on.
Yep.
What exactly is a motion hearing?
Okay, say that again in your half out of window.
What exactly is a motion hearing?
A motion hearing is basically a request to the court to hear evidence for decision made prior to trial that can affect the trial. That's the best way I know how to describe it. So I interpret it as information hearing.
Okay.
Informational hearing, not the actual proceeding for court for trial. It's the information hearing where they decide on rules and things that they're going to do prior to trial.
In other words,
you can have a motion to squash or you can have a motion to prohibit media. You can have a motion for change of venue. You can have a motion to keep evidence out. It's just, let me pull the actual
definition.
Yeah. What is a motion hearing? A motion hearing is when individual or attorneys seek judicial intervention in a case. They file a motion, which is a formal request for the court to make a ruling or to take a specific action. But for the deaf, I do informational hearing. Judge decide later, or judge decide. Yeah. Yeah.
So it's basically what they're going to let them do or not do. Okay.
Somewhat. Sometimes they may have a motion for, like with Sarah Boone, they had a motion. She wanted to keep her files in her jail with her. And the jail and the state were saying no. And the judge has the right to, and she went before the judge and requested him order it. So.
Yeah. Okay. I'm now more educated.
I did not get any homework done last night. That's going to be tonight, and I don't think I'll be live during the day tomorrow unless something happens big.
Have you heard anything about your interpreter?
The what?
Interpreter.
Not yet. I was going to call them tomorrow morning. I'm not in a frame of mind right now to call them because if I don't like what I hear, I may become a real nasty Karen.
A real nasty Karen? What's
and
that?
I need the law where it states that if a deaf person requests a specific interpreter, it's to be provided if they provide interpreting services at all. I thought you were going to look that up for me.
I did. I didn't find it yet.
Okay. Well, I know within the state of Texas, it is, I mean, it's said it's taught, but I don't know if it's written. So like if they hire an agency and I request a specific interpreter, if they're not pre-engaged, then they're to provide it. Girl, you
Yeah.
go to town on that. You're chewing on it like it's a rib.
Well, it's not the
Cold.
freshest. Yeah. It's last night.
Cold pizza's good to some people.
I know.
Some people.
I like it.
Everyone deserves a fair trial. In the system doesn't work for the worst of us, how it is going to work for the best of us. That's good. Like I said, the moment I put these on, I'm much better. But the moment I do this, it's like, oh. So EDB.
I can always tell when a headache's going nuclear. And they are not fun.
Well, I normally don't have light sensitivity. This could be an IH migraine. So basically, if you want Diane to interpret for you during your husband's trial, the court has to let her. Yep. But they didn't have an interpreter for me.
Ooh.
I was hard of hearing at that time. I wasn't nearly as bad as I am. They did require the attorneys to stand within arm's length of the witness stand so I could hear and lip read if need be. And I didn't have the ASL skills back then. I couldn't. It was right after that I went to college. But there was some issues. I won't go into it now, but there were.
I bet.
I misunderstood a question and I answered it. And when I realized what had happened, I was already off the stand. I wrote a letter to the judge. It wouldn't have made a difference in the outcome. Absolutely would not have made a difference in the outcome. But that is what it is. J Hatch, okay. I'm just looking at everybody. All right, guys. I think Miss Diane, are you close?
I'm close.
I think that dog has done chewed the bone and you're trying to resurrect it, Miss Diane.
When I was a kid, long time ago.
Really? It was that long?
It was a long time ago. Skip that. I wanted to tell you this. I read yesterday this baby was taken to the hospital. Was dead. Oh, it was unalive. Sorry. Oh yeah. Yes, Andrelia. But when they when they examined it, they couldn't see any physical reason why it was unalive. So they ordered a tox screen. This child had unreal levels of fentanyl in its body. 10 months old. Turns out the mother had coated its pacifier in fentanyl. And when the police did a search in the home, they found that the parents were running a dogfighting ring. And so the mom had coated the pacifier in fentanyl to keep the baby quiet.
So you're telling me this to piss me off?
It pissed me off royally. I'm like, excuse me. Can we put hands around the neck of this mother?
Can y'all just let her go in the field during hunting season?
And and put a pair of antlers on her head. And
don't even need that. It moves, it goes boom.
Oh, I'm like, you have got to be kidding. But it is what it is. And some people just don't deserve the air they breathe. So anyway,
Why can I not find it? Don't
yeah,
want that
yeah.
noise.
When I was a kid, long time ago, and I still do, I love bacon rinds. My mom would cook bacon, and the rind, my daddy would be like, "I'm gonna throw it to the dog," and I'm like, "No, no, 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 give it to me, give it to me, give it to me." Chew on the bacon rind. We all have our things.
Okay, love. Let's get
That's it.
going.
Like elderly
We'll be
people
here
are
all
bad drivers. So that's
Their
belief
story.
perseverance. And in some cases, people will even double down. Again, social media, they might even get more aggressively in line with their initial opinion after seeing evidence to the contrary. So this is one reason that's directly aligned with confirmation bias.
It sounds like they can work together when somebody already has a bias. They've already made decisions about.
Yeah, really any expectation or decision or judgment, even if you don't know that you have it. I heard the phrase of growing legs. Well, there's a famous social influence researcher who used that same phrase with decision making. Like once you've decided something, your decision grows legs of its own. And so now it's not just the normal information necessary that for any rational person, because we all kind of have this tendency to be irrational in situations like this. But it ends up causing us to distort reality a little bit and need a lot more evidence now than we should to change our minds.
What else impacts getting new information during the course of the trial?
We'll advance to the next slide. I want to mention a little bit about cognitive dissonance. And cognitive dissonance is an uncomfortable feeling we have when we have like an inner clash, like an inner hypocrisy, like if I'm religious, but I don't adhere to one thing about my religion, and then there's this inner clash, and we don't like that feeling, and we like to reduce it, minimize it, prevent it. So why is that relevant here? Well, if somebody lives in Latah County, they might have a dissonance experience because if they start during trial to believe that, oh, maybe the defendant is innocent, maybe he shouldn't be convicted, that belief might be battling another belief about loyalty to their community because they know the community wants closure. They know that the community wants him to be guilty. They know the community wants to feel safe. And so they have this inner clash. And what happens when we have this inner clash, lots of things can happen. But one thing that could happen is we could distort reality. That's another reason for kind of being a little bit less accurate when taking in information. So if I'm if I'm a juror from Latah County, and I'm starting to kind of think, oh, maybe he didn't do it. There might be part of my brain convincing me that no, he's guilty because of this inner clash. I want to get rid of the clash.
Is that because of the loyalty a person would feel to Latah County, to their community?
I think that's a big part of it. And there could be other reasons with regard to community connections that could create that clash too.
Like a concern that they might be known?
Yeah.
Who they are as a juror?
A concern that they might be known. They're just kind of picturing yourself sort of coming back to your community with the news that you were involved in a process that actually, acquitted somebody, for example, and having to face people in your community, which is something I touch on later a little bit too.
All right. Should we move forward?
Yeah.
All right. I know the court's going to want to know, can we fix this?
Sure.
Can we get our jurors in here and tell them, don't bring your bias? Can we fix this? What do you think, knowing what you know about human bias?
I would love that to be the case. I just don't see that as feasible when bringing jurors out of Latah County. And I can tell you some problems with all the methods that people try to use. It's just, if you look at the research, there are limitations to these. And so one of them, of course, is juror selection. Let's try to find people, for example, who haven't been exposed to publicity. So there are problems with that. Can you recount all of the publicity that you've been exposed to? No. If I asked you to tell me about all of the interactions you had with people over the course of a week, you're going to have forgotten some, right? But doesn't mean they're not going to be affecting you. So maybe when I was at the grocery store, the person checking me out had a negative expression on their face, and I didn't recount that to you, but maybe that memory is there and it's buried. And when I go back in the grocery store, I'm a little colder to them. And another possibility too is that retrieval cues can make some of these unconscious memories actually become conscious, and maybe they affect us at that level. So if I'm a juror and I'm sitting in and hearing all of this evidence, something might remind me, oh yeah, and I remember they found this information, and maybe it's something that's not admissible, but now it's affecting me. And I didn't report that I knew that because I didn't remember that I knew it until something cues that up. And so that's a retrieval cue, is basically something that reminds you of what you know and can't articulate yet, or maybe don't have knowledge about it at a conscious level. And so there's a problem with that, picking people who haven't been as exposed to a case. And of course, we talked about the saturation of media. It'd be hard to find somebody to even say that, but if they say that, I don't know if that really would be something we could rely on as being totally correct. And then this is something that I focus a lot of my research on, and it's bias. So there's a lot of research on how we overestimate ourselves. We have overconfidence. We tend to rate ourselves as better than average, like better than average in intelligence. There's one study where the vast majority of people rated themselves as better than average drivers, but we can't all be better than average. It included people who had gotten into multiple car accidents. So while people might be thinking that they're making an accurate assessment of themselves, when they're asked, hey, do you have any bias, for or against the defendant? Do you have any, or are you capable of setting aside your bias? People probably often believe that they can set that bias aside because it's in line with all of this research that we know about how we tend to overestimate ourselves. So they're going to say they're less biased than they are. That's been shown over and over again in a lot of settings. And by the way, the people who are the most biased have the most distortion when they're estimating their bias in at least some cases that they've studied so far. That's some research I've done too. And then also they're going to be biased about how much bias they have. That's called the bias blind spot, which has been studied too. So I might acknowledge that other people might be biased, but I won't be biased, and I'll be capable of setting it aside. So that's one process, jury selection that we would hope would work, but there are a lot of drawbacks to it. So I wouldn't rely on that.
Do you think that it's less likely to work in a situation like this with the amount of negative media coverage that has been going on for a long time?
Yeah, if you ask somebody from Latah County to forget everything that they've heard about the case, forget all the discussions they've had, forget all of the media they've been exposed to, forget all the emotions that they've experienced, set all that aside. Can you really do that? Can you unfear things and unfeel things for an extended period of time to be objective? That's quite an undertaking. So yeah, I think that's problematic.
You mentioned extended period of time. This trial is projected to take 3 full months. Is that what you mean by extended period of time?
Yeah, really. The longer it is, the more potentially distortion there can be because your decision has grown legs and things are getting filtered through filters. And then emotional things can carry a little bit more longevity. So so I wouldn't expect it to just go away if it's a long trial by any means, but I'd expect to see it in a short or long.
Is there anything else that can be attempted that might or might not work?
Yeah, my next slide is on instructions. And of course, people would want to try to give instructions to jurors to be unbiased. And like I said, people overestimate their ability to do this. They don't even think they're that biased to begin with. And the first step to not being influenced by bias is to acknowledge that you have bias. So there's already an obstacle there. And then you have to have the motivation to not be biased. And I hope jurors have that. You also have to have the cognitive capacity to be unbiased. And that's where we run into a lot of problems because their cognitive capacity is going to be occupied by serving as a juror, paying attention to information. They don't have time to spend 80% of their mind trying not to be biased and catching all the bias. And in fact, there's research that suggests that when we try to suppress thoughts, that we can think about them even more as soon as we let our guard down, which is very soon, because you have to think about other things at some point. So if I try not to think about something like an argument I had with somebody, or somebody tries not to think about cigarettes, but they're trying to quit smoking, they could do that for a really short amount of time. But as soon as they think about something else, their mind gets flooded with those thoughts. Because in order for you to not think about something, you have to think about it so that you can catch those thoughts. And that process is automatic. Most of what I've been talking about today is unconscious, automatic processing, and that's why it's so hard to control. And with regard to instructions to disregard information, whether it's something that people learned pre-trial or something they learned during trial that turns out to be inadmissible, the research shows that those instructions typically don't work, and sometimes they can backfire, partly because of this thought suppression rebound effect. And then there could be other reasons too, like people not wanting to be told how to think. And I mentioned too that, it applies to emotional information too. So factual and emotional pretrial publicity would still have influence, even if people say, don't let this affect you. I wouldn't assume that works at all, unfortunately.
How about jury deliberation? Will that work if you have a juror in there who's going to maybe accidentally bring something in or interpret something based on something they heard before, or they've remembered something over the course of trial? Will the other jurors push it out, help them not to think about that? Will the group overcome that bias?
Yeah, so we would hope that you get a bunch of people together who are trying to be objective, for them to sort of correct each other. And while some of that might happen, what the research has shown is if some people are exposed to pretrial publicity and some aren't, that can spread. Because you can't expect a juror to remember where they learned things. Like maybe they have information about DNA evidence and some of it came from trial and some of it didn't. And how do you disentangle that? That's really, really hard to do. And so they might spread it unintentionally. It might be spread intentionally too. But even if we're assuming perfect jurors here, it might spread unintentionally and then sort of contaminate the jurors during discussion. And then there's also this phenomenon we've been studying for a long time called group polarization, which is when you get a group of people and if they're leaning towards a particular opinion, when they discuss a topic, that opinion gets stronger and stronger the more they discuss it. Another thing you could see potentially on social media, like groups that, are invested in a particular issue. And so if the group is leaning towards negative judgments about Mr. Kohberger or judgments of guilt or anything, even a little bit, then discussions could actually make it worse and worse over time. It could get polarized. So I don't anticipate that discussions would fix the problem. In fact, I would expect it to exacerbate the problem. And that might be why in that meta-analysis I talked about, the effect of pretrial publicity was stronger when it came to group judgments, verdicts versus individual judgments of guilt.
Based on your years of teaching human bias and your extensive study of human bias, do you have an opinion about whether the extensive pretrial publicity has impacted the Latah County jury pool?
I do. I think it would be so hard to be a member of that community and be able to come in and be objective, and arguably impossible. So we don't have a known method for undoing things, and the things have been done. They've felt the emotions, they've seen the publicity, they've had the discussions, they've been to the vigils, and even if they want to be as objective as possible, and even if we disregard some of the limitations I talked about before, research has not uncovered a way to undo this after it's there. And so the recommended best practice by the vast majority of researchers on this topic is find people who don't have that information, restrict that information in the first place. Find people who don't have that information. And the same goes for that emotional experience and investment and so on. Utilize jurors who've had less exposure, they have less reason for prejudgment, less motivation to find the defendant guilty. It doesn't affect them, their feelings of safety, the community. They don't have to worry about reporting back, and other people maybe ostracizing them if they didn't make the judgment that was expected or wanted. And so my recommendation would be to find a community to recruit jurors from that's as far removed from LATAW as possible, physically and psychologically.
Thank you. I don't have any other questions for you, but if you hold on just a minute, I think Ms. Katie might. Okay.
Thank you, Ms. Taylor.
Is it good, Sneaky?
Your Honor.
Cool. Do you see it by your head,
In
Mitch?
any jurisdiction where there's been a tremendous amount of pretrial publicity, at least some of these biases would apply to a prospective jury pool, correct?
Yeah.
And the best thing, if I'm understanding your testimony correctly, for this trial would be to have a jury pool with the largest percentage of jurors who hadn't formed an opinion on this case already. Would that be fair to say?
I mean, you need, I
You're
can't speak to
wishing, baby.
percentages. You need somehow to find enough people to serve on the jury who have not been exposed. Now, this is a high profile case, so we know the exposure is all over the state, and of course, this is part of it. But if you can have less exposure,
Yeah, I heard nothing.
fine.
I didn't hear anything about this trial, but I didn't say I saw it in sign language or read it.
In a case like this, where there's been so much exposure across all counties, are there unique challenges in selecting a jury that would apply anywhere?
So, well, I mentioned some unique things about Latah County and emotional investment in the community, concern for community members, and having felt that fear and wanting the defendant to be guilty so that they could resolve the fear and anger. So there are all those emotional and social connections, and of course, Dr. Edelman's report, which will come up later, shows that a lot of people who live in Latah County are connected in some way to the university or the police involved in the case. So they actually, know people or they lived in Latah County. And so those kinds of things make, because it's such a small community, make Latah a unique experience.
Have you noticed how much?
And so you've reviewed
judges
Dr.
gotten
Edelman's survey.
I have.
So does it sound correct that 75% of folks in Latah County are not affiliated with the university?
I don't recall his percentages.
Okay.
So offhand, I'd have to see the report. I could look at it if you'd like.
Okay. And I should be more precise. I believe the question was, are you or a family member a student or employee at the University of Idaho in Moscow? And the percentage of folks who responded no was 75%. Does that sound right?
I couldn't tell you without seeing it. Sorry, I don't remember.
Would it surprise you to find out that 60% of Latah County residents who were surveyed reported that they did not feel higher levels of stress or anxiety during the hunt for the killer in this case?
I don't know. I don't know what percentage I would have estimated. I just would have estimated it to be higher in Latah.
Okay. So is one strategy that the court could use in any jurisdiction, whether the trial stays in Latah County or moves to Ada County, would bringing in a larger jury pool alleviate some of these concerns across any jurisdiction?
Well, if we're talking about Latah County, a lot of the things that I mentioned were not in the survey. So, there are emotions I mentioned that weren't assessed during the survey, impressions of Mr. Kohberger that weren't in the survey. So it could be that 90% of people think he's a bad guy, but they don't think he's guilty. And then that still could influence judgments. So it's really hard to answer that question without, I didn't make the survey. And even if I did, there'd be a lot of things that I would miss too, so I can't make that determination. About, you said if you can
stop here for a sec. I honestly feel that they're throwing so much crap on the wall and all these experts hoping to have something stick. IMHO.
Maybe you can restate it and I can.
No, I appreciate the answer. Thank you. Now, I guess the last question I'll ask you is, would you be surprised to find out that in the survey, when jurors were asked, potential jurors who were responding to the survey were asked what their opinion is of Bryan Kohberger, the highest percentage of prospective jurors that were surveyed who had no opinion of Mr. Kohberger were Latah County survey respondents. Did that surprise you?
That they have no opinion about whether he is guilty.
I think the question is just, do you have an opinion of Mr. Kohberger?
Well, it's a high profile case that had a lot of coverage, and the percentages are so high that people who have an opinion, I imagine, I don't have those in front of me, but in statistics, we call that a ceiling effect when all the percentages are high and you can't really see differences. So I don't know if we're talking, I don't know what numbers you're looking at, but I don't know if that applies or not in this particular case.
Thank you. I have further questions.
Ms. Taylor, anything else?
Yes, just a few questions for you. Your focus is on human bias, right? Okay. And you talked to us about media exposure and how that forms bias. Are bias and forming an opinion, you're willing to say, different things?
Bias can come from lots of things, one of which is an opinion that was formed, and then bias can shape another opinion that gets formed, if that answers your question.
It does, thank you. You talked to us a little bit earlier about how that bias gets formed, and then you told us sometimes we won't be able to spit out our entire bias or what we looked at to form bias. Is there a danger in a case like this, where there's been a lot of media coverage, that somehow we seat a jury, but they start remembering things they read in the paper and trying to make the evidence fit into that filter?
Oh yeah, of course. So Dr. Edelman's report, I remember, said that people didn't list everything that they recalled, but when they were prompted to ask about to indicate whether they remembered specific things, then they remembered a whole bunch of things. The same thing would happen during a trial, right? Those retrieval cues, anything that reminds you of something. So our minds have kind of an association network. All of our memories are sort of connected in some way. You could just mention the word white, and maybe I think of snow. So our memories can come up from so many things that I would be surprised if there weren't some memories rekindled.
Thank you. That's it for me.
Thanks, Ms. Taylor. Any more questions?
No, thank you, Your Honor.
Okay. Thank you. May this witness be excused?
She makes.
All right. And no objection to that.
No,
all right.
you're
okay. Thank you. You're free to stay. You're free to stay or leave. All right. Thank you very much. That was very interesting.
Oh,
thank you.
Is it too soon to start decorating for?
Okay, next witness.
Not Halloween.
Next witness is Dr. Bryan Edelman.
Okay. Dr. Edelman. All right, welcome back.
Yes.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right, thank you, sir. Please have a seat, and then please state your name and spell your last.
You're gonna speak slow today, I promise. So Bryan Edelman, Edelman.
Sir, go ahead. Stay with.
Thank you. Good morning.
Good morning.
Dr. Edelman, I see that you brought some things to council table with you.
I did.
What do you have?
It's just a copy of my presentation.
Your PowerPoint presentation? Okay. And is that face down? Perfect. Will you let me know if you need to flip it over to refresh your memory?
I can tell you the second you start, I won't be able to see anything, so I'm gonna need it.
Okay. Your Honor and counsel, then I'll ask if he can leave his PowerPoint presentation face up so he can help us understand this testimony. No objection to that.
Okay, thank you. Go ahead.
All right, let's start with your background.
Going back how far? Let me try.
Well, let's start with what you do right now and then work backwards and forward. How about that?
Okay. I'm a trial consultant. So in that capacity, I'm often in a courtroom doing jury selections and assisting with that, running juror questionnaires, helping attorneys craft oral voir dire questions, And I also do pretrial research, so that's focus groups and mock trials. And then I also do post-trial interviews and do writing in terms of trying to educate or help the legal community. And then I also serve as an expert witness in this capacity. And in that scenario, I'm often focusing on pretrial publicity, the impact of pretrial publicity, and whether or not a defendant's due process rights may have been undermined by media coverage. And I also do post-conviction work, which kind of ties into that, where I might be brought in to look at a case to see if there was a lot of media coverage and whether or not there should have been a change of venue or a request for a change of venue, and looking at the adequacy of voir dire to uncover what jurors knew. So that's kind of reviewing the voir dire transcripts and use of challenges, that sort of thing.
How long have you been doing that work?
That part? Since I think the first one, maybe like 2011, 2012, something like that.
Where do you do that work? What company?
So all over the place. So all over the country in state and federal cases, in Florida, Michigan, Washington, DC, Idaho, California, Texas, New York, a bunch of others. So quite a bit.
How were you educated to do the work then?
So I have a background in social psychology. So I have a PhD in social psychology from the University of Nevada, Reno, which is a program that really focused on psychology and law. That's where the judicial college is, and something called the Grant Sawyer Center for Justice Studies. Am I going slow or I do it better? Okay. And while there, I worked at the Grant Sawyer Center for Justice Studies as well, and did research on the death penalty, so on pretrial release programs and the impact of media coverage, so kind of similar to this. And when I finished that, I went to England and got an LLM in international humanitarian law, and then came back here and started working at a trial consulting firm. I started in 2000, I want to say 2004, that sounds about right, 2000, I think. And then started my own or co-founded Trial Innovations, where I am now, with a business partner in 2011.
Do you do any teaching about your
teaching? So I do like CLE classes and things like that for bar associations. I've done it for public defenders, for district attorneys' offices. I've been like a visiting lecturer at like different law schools, at the ASTC, which is the American Society of Trial Consultants. Did classes on like trial consulting and change of venue. I think I've done one at APLS, which is like the American Psychology Association, a legal society. And I'm sure there's some others out there too. APE, ABOTA is one, and that might be more on like jury selection. That's like a legal organization.
Are you a member of any organizations, professional organizations specific to your work?
Currently, I don't think I normally I'm a member of ASTC, which is American Society of Trial Consultants, but I might have forgot to pay my dues this year, so maybe not.
How about this?
Are you usually a member of that organization?
And same with APLS. That's
What's APLS again?
That's the American Psychology Association, and it's the legal society division. And then I also do for like the ASTC, I've been on like a committee that helps write some of the professional guidelines, particularly around change of venue.
And I understand you do consulting work. Do you testify as an expert?
Yes.
What states?
What states?
Roughly.
Okay. Kind of the ones I mentioned earlier. I'm sure there's more. So Florida, Michigan, California, Washington State, Washington, DC, Texas, Idaho. Wish I had a map in front of me right now. Tennessee, Georgia, Minnesota, and I'm sure there's others, but it's been a long time, so I've done a bunch of them. I've probably done over 100 that I've been retained on for in some capacity related to pretrial publicity in both state and federal cases.
I heard you mention Idaho. You've testified as an expert in Idaho, is that right?
I have.
How about in this case? Have you testified before in this case?
In this case, yes. I did.
All right.
Yes.
Last time we were here, we were talking about a survey that was in progress.
Yes.
So have you now completed your survey?
Yes. So completed the survey in Latah County and then conducted several comparison surveys after that hearing in Ada County, Bannock County, and Canyon County.
Before we get to all of those, I'm going to start a PowerPoint presentation that you've provided for us today, so you can walk me through the process of what you do and how that works. Give me just one moment.
Sure. I'm going to flip this over then.
Looking beautiful, doll. Feeling better? Okay, I have a little logo up in the very top corner. This one is the ASL, and then it says IMH. Oh, and there they go. Oh, I thought they were gone. I thought they left me. I was like, no, don't leave me. Don't leave me. I can't get this song out of my.
Thank you for that, for the patience. I think we have it now. Will you give us a present or an overview of what we're going to talk about today?
Yes. So the presentation is broken down into 3 parts. So the first part is just kind of a cursory review of some of the social science research, some of the basic general research, foundational research, and then research specific to pretrial publicity and juror decision making. And then to get into the actual change of venue analysis, which focuses on the media coverage, so the extent and nature of the coverage, and in addition to whether or not that coverage has had any impact on the jury pool. So that really gets into the survey. And the last part gets into the unique challenges that cases like this pose when we talk about jury selection. So is what you're an effective remedy in cases like this, when there's been a lot of media coverage and people have a lot of knowledge about the case.
I heard you say cases like this. What do you mean?
Sorry, when I say what?
Cases like this.
Oh, cases that have a lot of media coverage. So in a normal case, like a car accident or something like that, people come in, they might have general attitudes about drinking and driving, but they don't have case specific attitudes about this person that are well developed from information I know about the evidence and the person and so on. When you have a case like this, people come into the courtroom with case specific attitudes that are well developed and based on, it could be emotional information, it could be evidence that they already have read, seen, or heard. So they have very well developed attitudes. So that's a unique thing because they're no longer blank slates when they're hearing evidence. They're confirming what they already know, as opposed to jurors who don't know anything and are learning and building attitudes and knowledge structures as they go.
All right, let's go to the background of why we do this, why this matters.
Yeah, so there's decades of research in general documenting the impact of pretrial publicity on decision making, and it kind of falls into 2 areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read the newspaper, I watch it on the news or on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions, and we can't really learn the types of pretrial publicity that are most impactful, and whether or not remedial measures like an admonition or voir dire mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial, how does pretrial publicity impact decisions, and things like do remedies work, and so on.
Do you have an example to help me understand maybe the difference starting with field research?
Sure. So the one we're looking at here is one of the earlier pieces that was published, and it looked at 3 cases that were high-profile cases in California. One involved the murder of 2 police officers I think it was in Yolo County. And then the murder of a dental hygienist from a prominent family. So it was the status of the victim was important in that. And then I believe the third one was a rape of a young girl. So they did 3 cases, and they did surveys to assess the impact of that media coverage. And they learned a couple of interesting things. So they learned that people who consume news, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I'm to have detailed information about that specific case. So there's the first relationship that we look at. And then the next thing is case knowledge impacts presumption of guilt. So people who have well-developed case knowledge, they've read a lot about it and they know a lot of detail, they're more likely to think the defendant is guilty. They're more likely to have an opinion about that. And that stands out as more important than a host of things. They looked at gender, education, attitudes towards the criminal justice system. And ultimately, case knowledge was 10 times more impactful, more important than attitudes like towards the criminal justice system. So it wasn't something like, I'm just a pro-conviction person who tends to favor the government and think people are guilty. It was far more important than that when it came to these attitudes and opinions they developed.
It sounds like the field research has been important in your profession.
Yes.
Fair to say?
Yeah.
Help me understand what experimental research is.
Yeah, so these are more, again, traditional studies where we are able to control. We can look to see, maybe we're testing to see what types of pretrial publicity are most impactful. Maybe we want to know if voir dire is an effective remedy at mitigating the influence or impact. An interesting study someone recently did was looking at the set aside question. And they were looking to see if you did something like normally what happens to jurors on the spot. It's just like, what do you know about the case? And it's kind of like on the spot, I need to think about it and try to recall everything from memory and spout it out right there. So the remedy was, what if the person was given time to write down everything they know and think about it? Think, can they really be fair? And then come back to them and then ask them again. So they were looking at that as a remedy. So that would be an example of an experiment. And like globally, what we find is exposure to pretrial publicity impacts perceptions of guilt, and it influences the defendant's credibility, likability, and sympathy towards the defendant as well. And overall, most of the research shows that judicial remedies are not effective. We're talking about admonitions, so like the judge telling the jurors are not allowed to consider media coverage; they have to set that aside. Voir dire, kind of like I was mentioning before, those don't mitigate the impact of media coverage. Delay is another one. Sometimes there's a long delay between when someone reads the coverage and when they come and do the experiment to see if that mitigates the impact. So overall, those are the key findings and takeaways from the experimental research.
All right. You have a slide in here called, I'm not saying this word correctly, Potower and Singer. What's this about? How is this important?
So this is, again, just an example of some of the research. So in this study, the researchers recruited people who had been excused for jury duty, so they were at the courthouse, and they were put into 2 different conditions. So in one condition, the experimental condition, they read an article, and that article contained information about the defendant. It was a criminal record. And it also included a retracted confession. So they were looking at something that's inadmissible. It wasn't going to come in, I believe, in the story. And the control group read the same article absent those 2 pieces. Didn't mention anything about the criminal past, criminal record, or the retracted confession. And what they found, if you go to the next slide, is that there was a significant effect. So those participants who are in the experimental condition, the ones who had been exposed to the background, the criminal background information, and the retracted confession, were much more likely. I can tell I'm talking too fast. Were much.
Okay, guys, y'all have a choice. I don't know how much more I can listen to this. No offense. With a headache, it's really bothering. Okay, they're on a break. We are going to hop over to something else. Look what I found, y'all. There's just days I can't handle it.
From the defendant. I accept the verdict. And
His
if you could
attorneys
please
haven't
give my
interviewed.
son a chance of parole. His family is still very young, and I would like for him to someday be back with them again. Sorry, I'm the emotional one. We're never going to be able to share laughter with him again, discuss sports with him, enjoy a barbecue with him, or admire his tenacious spirit. The tragic and brutal taking of his life has resulted in a loss that I don't think we'll recover. Thank you.
The jury came back with a suggested sentence, life with a possibility of parole after 20 years. The judge has set a date for sentencing for October 16th. She'll decide then whether or not there will be enhancements to the punishment. Now, we've got some new reaction this morning from the Las Vegas Review-Journal, where victim Jeff Gehrman worked. The Journal saying, quote, "Today, a Clark County jury delivered a measure of justice for Jeff Gehrman, and we hope it brings some solace to his family, friends, and colleagues. Jeff was killed for doing the kind of work in which he took great pride." Now, let's talk some more about this case, and let's look at it from the defense side. Not an easy side to be on, and I said it many times throughout the trial. You all heard me. His defense attorneys did a brilliant job. And he didn't look like an easy client. Let's bring them in now. Let's welcome in attorneys Robert Draskovich and Michael Horvath. Good morning to you, gentlemen. And I really mean it. I just want to start by saying so many of our viewers noticed you two and your advocacy with those very bad facts that you had to contend with. And so I just want to start by commending you on the trying of the case and the great lawyering that you did. You created a lot of doubt that was evident in those jury deliberations. So let's start there. Robert Draskovich, you closed, your close was sensational. In pointing to the hair and the profile and all of that, it seemed that you got the jury hung up on that for days. Your reaction?
Thank you so much, Julie. Michael and I worked real hard to present Robert's case the best we could under the circumstances. Obviously, our job is to create doubt. I mean, you know, these trials shouldn't be like a speeding train getting to their destination of a conviction. So we worked as hard as we could with the facts that we had to present the strongest defense possible.
It was evident that you did. And he didn't make it easy. You know, him testifying, I know that you can't divulge, you know, the client's communications with him, but everybody watching it, analyzing it was saying, surely this was against the better advice of counsel, but he did, and it seemed that he undid a lot of the great work that you both did. Michael, let me go to you on this, please. My understanding is that you both were retained, I mean, like at the 11th hour, right before this trial even started. Is that right?
That's correct. Originally, the trial was set earlier this year, and Robert was retained on the case, and we were going to come in and just try the case when it was set and due to the issues with the Review-Journal and the privilege of Mr. Gehrman's sources and devices, that's why it was continued so much. So then we were on this for several months leading up to this court date.
Well, and for not having a lot of time to prepare, there was a lot to go through, a lot of evidence this jury had to consider. And it seemed, based on their questions, that what they were hung up on was that video. And Robert, which you pointed out, I want to go back to a clip from your close where you're pointing out the suspect having hair.
You have this evidence. It wasn't part of his presentation, but it's been provided to you. Look at the profile. What's that look like on the top of the head? I'd submit to you, that looks like hair. We've seen Mr. Tellis. He gave testimony from the witness stand. Does that profile match the profile in that vehicle? I mean, it's no secret. The man's bald.
Okay, Robert, take us kind of inside. When did you notice this? When did you kind of devise the plan to go after this in close?
You know, we were aware of this days before closing, but we thought the most effective point to bring it forth would be at closing. That way the state could not rebut it. You know, every time we come into these cases, and most of the cases we try are sexual assault cases, racketeering cases, murder cases, we bring a team approach. It was myself, Michael Horvath and Josh Berry of Manifest Trials. We try these cases together, and oftentimes we try and out-analyze the state or the federal government. We try and out-investigate each and every case. This was one of those grenades that we wanted to just drop at the end to try and stop their proceeding forward with getting a conviction. So we knew about this several days before closing, but we thought the best time to present it would be at the very end.
Oh, that was so smart. So smart. I have another clip here. Let's take a look at where you're talking about how there was no blood found in Robert Tellis's vehicle.
There was no blood or DNA evidence concerning Mr. Gehrman in Mr. Tellis's home, in or on his vehicles, in or on his clothing. None of that would implicate Mr. Tellis. There was not a positive identification of the subject vehicle or Mr. Tellis at the scene.
Another very favorable fact for your defense team.
Just a little ha-ha before we go on. I knew some case here in Texas where a guy committed a act similar to this. He went to a local car wash, took all his clean clothes out of the car, changed clothes, put the clothes up on the wall where you put your floorboard, what are those things called? Floor mats, and high-powered wash them. Now, baseball players sometimes do that with their white bottoms because it really cleans well. And so there was nothing found in the vehicle because he had a tarp on his seat and he took everything out and power washed it. And he was found innocent because they didn't have it. And then years later, he committed another crime and was in jail for it. And he finally confessed how he got rid of the blood.
And right before Robert Tellis testified, and Michael, I'll go to you on this. You all had done such a great job creating what do I want to say? Not creating, rather substantiating the alibi with the cell phone expert talking about where he was and not being there at the scene. And you couple that with what we just saw, no blood in the car. Michael, after you all did such great work there, I can't imagine what it was like sitting there with then Robert Tellis getting up there and undoing it all and having the testimony come in on cross, the message from his wife, the "Where are you?" text.
He went there.
What was that like? What's that like as an attorney when you really have a client kind of undermining your work right there in front of the jury?
Well, myself and Mr. Draskovich, when we were talking with our client, obviously in every case you advise your client of the pros and cons, the pitfalls of if someone testifies, if a defendant testifies. And Mr. Tellis was well aware that if he testified that there could be good things and bad things, and he ultimately made that decision. And it's the client's decision to do that. And as defense, as we go in and we do these things, and Robert did a great job on this case on lead, we have to deal with what we're given and what the client's wishes are.
No, certainly. How is your client doing this morning? Clearly he didn't take the news well yesterday. How is he today, Michael?
Well, we spoke to him briefly yesterday. We anticipate going to see him at some point today to discuss potentially the next steps, what he would like to do, what our involvement would be. So we can have an update on that maybe later. But at this point, we didn't get a chance to talk about him or talk with him at length.
Sure. And again, certainly want to acknowledge, I know that there are privileged communications that you just can't share legally, ethically. When we saw him testify in narrative form, right away, we started in with analysis, and I said, it seems very apparent to me that these are two very ethical lawyers who do not want to violate any ethical rules, and they're going to have him testify in such manner. Is there anything at all you can share with us, or anything else you would like the public to know about that? without violating any privilege. Anything more you can share, Robert, about that situation?
Well, obviously, it's every defendant's right to testify or not to testify. And I'm really glad, Julie, that you pointed out, obviously, the communications we had with Robert Tellis are privileged. We honor his right to testify, his right to present his case. I mean, generally, defendants don't want to face juries and tell their story, but Robert Tellis is an articulate, educated man. It's always his choice. Ultimately, it was his choice to present his side or his version of the facts, and that's what he did. I'm not really going to comment on why it was in narrative form, but nonetheless, he was able to get his points across to this jury.
Mm-hmm. Right, as is his right, as you noted. Is there anything else that you would like the public to know about this case? Anything that maybe didn't come into evidence or couldn't come in that you would like to share with us about Robert or Michael? Either of you, please.
Robert's going to continue to fight this case. He has a great deal of resolve. That's one of the great things about our American justice system is that those that are accused with serious crimes or all crimes have a right to fight their case. We have this due process, right to confrontation, right to present evidence, and file motions to exclude the state's evidence. This is a very important step in the justice system. However, I anticipate there will be many steps that will follow this one.
Sure. Will you be staying on his case as he seeks post-conviction relief or perhaps an appeal?
That's a very good question. That's something we're obviously going to have to discuss with him. We try cases. That's kind of what our firm, our law group is focused on.
Sure.
He obviously has a right to appeal. We anticipate him pursuing an appeal. That's one of those things that are yet to be determined.
Right. Well, it is very evident that you two do trial work. And if he needs to get someone who does primarily appellate work to handle that, we would understand. Your trial skills were tremendous, both of you. We would love to have you two come back on someday after you've gotten some rest and give us some analysis on another case that is not yours. How's that sound?
Thank you so much, and we appreciate being on your show.
Oh, wonderful.
Yeah,
Robert Draskevich, Michael Horvath, thank you both so much. Take good care. Now, right to...
He's like, we out of here. Oh, nope, we're good. I still have it up. Y'all, yeah, that was stepping on toes there. They had to be careful. They had to be very careful with what they said because they are going to be in an appellate situation now, whether they're his attorneys or not. So they're not going to say anything to jeopardize it because they don't want it to come back on them. But I think they did the best they could with what they had. I do believe that there was some verbal brawling going on whether he should or should not testify. I think that being brought in later in the case, like that other gentleman is I think he may actually be regretting it unless he got paid very handsomely. I would love to see lawyer, go after some of this stuff. I'd love to see him in court. I'd also like to see Rob in court. I'd like to see Ian, although we have seen him when he was much younger at the Supreme Court level of the Canada system. But I think it'd be fun to see some of the people that we see hosting shows like we are go into court and try. But I don't know. I think it'd be interesting to see how they do things. It's one thing to watch their commentary and everything. It's another to watch them actually in action. I think that would be cool. Once I get set a little more in my school schedule, I am planning on going to judge, what's her name? Begin with the B, the one that RA always has on. I see her face. The black lady, San Antonio. Her. I'm going to go to her court. I want to sit in there. Y'all can sit there. I'll put it on live and y'all can watch it while I'm sitting in court. Oh, I'd love to see Peter's dad. Oh, Lawyer You Know's dad. I'd like to see them together. I think that would be fun seeing them together. Judge Boyd, that's it. Judge Boyd. She's fabulous. Some people really don't like her, but I like the fact that she holds people to a higher level in society. Not that you just say you can't drink, can't do this, can't do that. She expects people to be better people in general, not just deal with the crime itself. But I want to know, why did you come here with shorts on and a spaghetti strap shirt and purple hair? What is it about you that you struggle with? You know, she's just brilliant. I'd like to spend time talking to her, because I'm really on the fence about, depending how I do in the next year or two with my college, I am considering law school. God help me. So, we are still waiting for the court. I'm sorry, this is a little boring in the sense of it, it's not a bunch of flash and bang. This is a typical motion hearing for this kind of stuff. Excuse me, we do have, I wonder if we should go ahead and just start this. We do have the audio only for the Daybell case. She's great, but she can be acquired taste. Then again, I've learned that, well, she's a typical Southern judge. And she expects people to have ethics and morals and try to be better instead of accepting for the least of everything. So, what do you think, Miss Sneaky? Should we go ahead and start listening to the Chad Daybell case? It's about 30 minutes. It's the judges. They're wanting more time. Daybell's attorney. Okay, I'm going to go ahead and just put that on audio. Can you hear?
Daybell versus State of Idaho. This is a post-conviction matter. The state is represented by Lindsay Blake, the Fremont County prosecutor, and Rob Wood, Madison County prosecutor. Counsel, who's going to be presenting argument on behalf of the state today?
I will be, Your Honor.
All right, Ms. Blake, and probably called things up in reverse because you're the defendant here. So the state is represented in this case. Mr. Thompson, Mr. McCarty, and Mr. Lenton are here today. Who's going to be arguing on behalf of the plaintiff in this case?
Ian Thompson.
All right, Mr. Thompson, thank you. Before the court is an issue regarding a request made by the petitioner in this case on a motion to find extraordinary circumstances in accord with Idaho Code 192719 to extend time. The court will note that there is a statute in effect in Idaho that governs these types of post-conviction proceedings, indicating that the matter should be decided and heard within 90 days of judgment. Court would calculate that to be October 15th of this year. The petitioners filed a motion and a memorandum in support of the motion, requesting that the court find the extraordinary circumstances set forth in subsection 8 of the statute, and a finding that it would be impossible to fairly consider the claims within the 90 days and request that extension. I'll note the motion was timely filed for this hearing and scheduled today. The petitioner, Mr. Daybell, is appearing remotely by Zoom from IDOC. I would note also the state, in my review, has not filed a written response. Is that correct, Ms. Blake?
That is correct, Your Honor.
All right. Does the state intend to offer argument, though?
Just briefly.
Very well. At this time, then, what we'll do, Mr. Thompson, I'll hear any argument in support of the motion.
Thank you, Your Honor. Would you like me to stand, or am I okay seated?
Why don't you remain seated? I think we pick it up better on the microphone that way, and your client will hear you better as well.
Great. Thank you so much. Your Honor, we've already filed our motion and memorandum. Included with that are a number of affidavits and declarations. We were concerned the statute indicates under oath, and so we wanted to present Your Honor with some information by affidavit and declaration. And so those affidavits include affidavits from Ms. Shannon Romero, myself, Ian Thompson, Dennis Benjamin, an attorney in Boise, Sean O'Brien, Kathleen Elliott, and then a declaration by Mark Bookman. And then I've included a couple recent court documents out of Caribou County in the Idaho Supreme Court. So I filed quite a bit of information, and I incorporate by reference all of that. I don't want to rehash all of that because it's on paper, and we assume everybody's read up on that, so there's no need to repeat that. Instead, I wanted to take just a brief moment while we're here to explain, I guess, our position on the extraordinary circumstances. 1927-19 essentially provides Chad with a single opportunity to make any collateral challenges to his judgment and conviction from his case. And unfortunately, under the statute, unfortunately from our position, he has only 42 days from the judgment and conviction to do that. So in Idaho, post-conviction in capital cases is different from any other felony criminal case. Unlike under the UPCPA, under 1949-01, the filing of the post-conviction in these capital cases precedes a direct appeal. And as the court well knows, in every other type of criminal case, that's not the case. A defendant will have the opportunity to conduct their appeal immediately after judgment and conviction. They file that notice of appeal. They go through that appellate process. And then only after the resolution of the appeal do the timelines, the 1-year statutory timeline, kick in under 1949-02. So the defendant has the opportunity of raising IAC of trial counsel and of appellate counsel all at once, or both. Here, Mr. Daybell must raise all of his trial ineffective assistance of counsel claims first, prior to ever even taking up his issues on direct appeal, any trial errors that occurred. That also means that in the normal course of proceedings in other felony cases, an attorney has already scoured the record and transcript of the trial. They've identified all the legal errors, and frequently they identify attorney errors, error that was unpreserved, or things that from an appellate attorney's perspective seem to have gone awry. And they can also often talk to their client, pass that information along, and identify those issues and indicate to a defendant, hey, these are potential post-conviction issues. These are possible ineffective assistance of counsel claims, where the trial counsel either failed to raise an issue, failed to properly preserve it, and then those issues, after the appeal is resolved, can proceed under the UPCPA. But none of that work has been done in this case. Chad has not gone through the appellate process. Attorneys have not reviewed an appellate attorney has not reviewed his transcript or record, and he hasn't benefited from that rather lengthy appellate process. So nevertheless, even though the order of operations has been flipped in capital cases, the Idaho Supreme Court has found that the requirement to raise issues in post-conviction in a capital case within 42 days of judgment and conviction is still constitutional. But that legal precedent often cited for that proposition, that the 42-day timeline withstands both equal protection and due process challenges, goes back to a holding of the Idaho Supreme Court in State versus Rhodes. And this is 120 Idaho 795, and it's 1991. And this is the case that all of these successive cases cite, where the court held that IAC claims, quote, should be reasonably known immediately upon the completion of the trial and can be raised in a post-conviction proceeding. This proposition was again upheld in two subsequent cases, in State versus Card in 1991, later that year, and then in Pizzuto versus State in 1995. However, it bears pointing out that each of these opinions, each of those three opinions, Rhodes, Card, and Pizzuto, was issued in an era when capital post-conviction counsel was the very same counsel that represented the defendant at trial. And all of our cases from the 80s, in the modern era of the death penalty since 1976, in the 80s up through the first half of the decade of the 1990s, that trial counsel was charged with filing the 42-day initial petition. Every one of those three cases that I cited preceded the adoption of Idaho Criminal Rule 44.2. Rhodes was September 12th of 1991. Card was December 31st of 1991. And then Pizzuto was August 3rd of 1995. And the rationale employed by the Supreme Court in Rhodes was born out of a completely different capital post-conviction regime from the one that Mr. Daybell now encounters. And this is the language that the Supreme Court said in Rhodes. These challenges arise out of the judicial proceeding just concluded. At this point, counsel has been closely involved with the case for some time, has been present at trial, and has had notice of all issues that are appropriate to be raised within this 42-day limit. All that counsel is required to do is to organize all challenges and issues that arose during trial and are appropriate for appeal within 42 days. That is not an unduly burdensome task. and that's Rhodes at page 80, Idaho 806. None of those contentions are true in this case, nor any other capital case in Idaho, since Idaho has required petitioners to have new post-conviction counsel appointed, as ICR 44.2 now requires. So just 5 days after the issuance of the opinion in Pizzuto, the Supreme Court adopted ICR 44.2 on August 8th of 1995. And since then has required the appointment of post-conviction counsel, and the language is of someone other than counsel who represented the defendant prior to the imposition of the death penalty. And that's now true in every capital post-conviction case. So these are the circumstances Mr. Daybell now faces in 2024 that present extraordinary circumstances under 2719. First, Mr. Daybell, just a few short months ago, has wrapped up a capital trial that took over 3 years to conclude from the time of charging. Number two, that case presents an enormous amount of material comprised of clerk's record, transcripts, exhibits, shared discovery, meaning from the prosecution, and then trial counsel generated material. Number three, he has lost any benefit, as the Idaho Supreme Court would have said in Rhodes, of having continuity of counsel in lieu of new counsel in his post-conviction. Basically an attorney that's intimately familiar with all this material. Number four, this does allow a fresh new set of eyes for Mr. Daybell, but comes at the cost of requiring a tremendous amount of catch-up by his new counsel. Number five, all of his IAC claims, which he's been told by the Idaho Supreme Court are most appropriate for post-conviction and not appeal, must be identified immediately, rather than after the benefit of having meticulously scrutinized the record that is going to be on appeal. And then number six, the reinvestigation of a capital case necessarily entails not only a revisitation and examination of the evidence that was produced at trial at what we call the merits phase or the guilt phase, but also must entail a complete investigation of the defendant. And that's because that forms the basis of mitigation in a capital sentencing, which is unique to a capital sentencing. I mean, the presentation of mitigation to a jury only happens in one type of case in Idaho. And this is essentially why capital criminal defendants file what we refer to as a shell petition that acts as a placeholder in order to meet the statutory deadline presented in 1927-19. So we've got to review the record and transcript of a combined 16,800 pages about. And that was received 5 days after we filed our original petition. We filed on July 17th, and we received that transcript and record on July 22nd at our office in Boise. We also have to review those trial counsel files, which we've indicated is 12,700 gigabytes, approximately 18,000 compact discs worth of material.
Okay, guys, we're back on the other trial. I apologize, but we're going to hop on over here. Sorry, let me get my mic. We're back. But no sound on their end.
Okay. Mr. Thompson, anything else on that or corrections?
No, Your Honor, we appreciate the court's concern. We have the same concerns, and I think this is a reasonable way to proceed. We'll reach out to all defendants.
Great, thank you. Okay, so we're going to take a break and we'll start up at 1:30, but the first 10 minutes will not be screened. All right, thank you.
Are you kidding me? How many breaks are you going to take? What the hey? Are you going to hop on today, or are you going to stay behind the curtain? I can't hear you, babe.
Hello.
Hi.
How are you feeling? How's your head?
It's a low roar, but the moment I pull these off in that high,
yeah.
I should not have fallen asleep this morning.
They said the first 10 minutes of them being back was not going to be. I didn't hear if they stated what that was going to be regarding. Like if defense said what that 10 minutes was going to be regarding, or
I think
whether
there's somebody they're going to be bringing that they are trying to protect, maybe, or something they don't want on record. Well, it's on record, but not on public record. Yeah.
Yeah.
Yeah. So,
Interesting.
how's your dog?
He's doing okay. He's resting, so he's still not back to his spunky self, but he's he ate kibble today, so that is like the first time in 2 weeks, so we're heading in the right direction. It's good. Things are
It's been
getting better. Yeah, so
Yay.
it's just the med schedule he's on is every 12 hours, but it's 3 medications that have to be given 30 minutes apart. So once you start, it's like, and then it has to all be given on an empty stomach until the last one. And that's when I can feed him. Except for my other dog, who is like a piglet, does not want to wait for me to finish that whole like succession of meds with my sick dog to feed her dinner or breakfast. So yeah, she thinks she's getting super pooched somewhere. But yes, thank you everybody for your love and concern. I really appreciate it. He's getting better. He's just having some super snoozes. And he was getting some sunshine today. Yeah. It is, hey?
I think this should be a logo up here.
Pardon me?
People can watch me. I said the little logo up here with the eye. I think I'm going to flip the hand.
Oh, okay, yeah. I love the logo though. I don't know how everybody else feels about the logo, but sorry. Let us know.
I'm
about the logo in the corner.
I'm going to flip the image.
Because I think it's pretty spiffy.
Yeah. And I'm going to save it that way. I do it 3 or 4 different ways, and I save them, and then I decide, and then I'll delete the ones we don't keep.
Yep. Yeah, no, I thought that one was really cool.
Well, yeah. I'm trying to come up with something that I can start branding, you know?
Mm-hmm.
Okay, so that's that one. Here's this big, but see how it gets lost? But see if I flip the hand, it's a little better.
Mm-hmm.
Small for now. I think I like the hand that way better. And when people hold it up, it's, I'm looking at it from that way.
Yeah.
So, but I just need to embiggen this one now so we can see it better. So, yeah, I'm trying to get something because we desperately need to start finding some merch and some things. But we also need to start doing some more things. I'm going to start doing, I can't call them quick bits because, that's taken quick bits.
Yes.
Sort of that way, sort of the same thing.
Yeah.
But I got to think.
Haley was asking before, hey, Ada, what does the sign mean that looks like when you're squeezing a bum? She was asking before when you were busy.
I like what?
She says when it looks like you're squeezing a bum. So I don't know.
Oh, this is information I'm receiving, information I'm giving. This is interesting. Interesting. I'm interested.
Thank you.
This?
That could be it.
This is like to get, to grab, to take.
Mm-hmm.
Okay, there it is a little bigger.
I like that. That's a nice size.
It doesn't, well, that's that one. It doesn't, it's not obnoxious.
Mm-hmm.
Ooh, shows up good there.
Oh, hello, Britt has a great idea. Do you have the letters IMHO in their sign equivalent, like their?
Yes. It takes up so much space. As it would be IMHO. It takes up a lot of space.
I
I
see.
could put on a t-shirt.
A t-shirt might be a good option, yeah, because she said I'd buy a shirt with that.
Do a whole shirt that says IMHO, and on the back it says, "In my humble opinion."
Yeah. That would be a good idea for
Yeah.
the shirt. Hi,
This-
Cindy.
I really don't want it really very bold. I want it real subtle because it's not distracting. But I think if I get it printed on shirts and things like that, I think I can lighten it. We can pair it. See, when you just put it on a back, it has a. See, look. Oh,
that looks really nice.
Yeah, but you don't like the way stuff.
No, but see, with that does look really nice with it. So with that logo, it does work. So even though my motion twistiness doesn't necessarily vibe with it, that looks like the best with it. Although I guess it does sometimes get cut off by the yeah, although we can have ourselves over here. I wonder if my hair will give it a nice color to go off of.
But see, in this program, I could only put it only goes in that corner. Now, I can make an overlay that I can put it anywhere.
Right.
But I am enjoying. I wish I could slow down this video. I wish I could really slow it down, but I don't think I can. I'll have to see if I can.
Gotcha.
It's my
yeah, slowing it down would definitely help for the motion twistiness. Definitely, because I bet you that probably does not help with your migraine.
Not the best. I gotta find that again. You know how hard it is to find this stuff once you find it, and then you're like, oh, "Where was that? I can't find it." So let me go. Okay, here's that design.
Dizzy. Oh yeah.
Ration. Let me look. I should be able to play back video speed. Let me see. I want it real slow. Oh, I can.
Do you think you could do like a very basic sketch and draw? Because Ada might be able to do like a more refined mock-up of something. Just if you do have an idea that you would like to explore. Ooh, sorry.
I've extended the competition time, but I'm not getting any entries. So paste, and let me see how it plays. Oh, it's real slow. Ooh, let me see if I can share or download it. I'm downloading it. Okay. So I'm doing, oh, I love having these multiple screens. So the one I have is like slow. So I'm going to delete this one. It's a little too fast even for me. That's why I haven't used it, but I love it. But it's just too fast. It's cool though. It's my psychedelic. And
it is really cool. Haley Mouse has sent a picture of the sign that she's trying to talk about with the bum pinching. And she's taken a picture of it in Discord, which I find delightful. And so you're teaching us, and it's very instructive.
Want.
Okay.
I want that. It's like, gimme.
Yes, see?
Gimme. Money.
Very, very self-explanatory.
Good one, Haley Mouse. Good one. That's a good way to do it, girlfriend. Thank you. Gimme. Gimme a man after midnight. Better be careful or I'll get in trouble.
Thank you for being so interactive, guys. I love
Yes.
that you guys do that. I think that's fantastic. So thank you for making my day.
Yeah. That's a good way for you guys to do. If you see a sign and you're like, what is that, man? Just do what she did. Take a picture of her doing it. And then, hey, let's
It's a
edit this video or this background. Let's see if I can cancel. We'll do it here. Add file. Desktop. Okay, once it downloads, we're going to put it on and see how you like it. Okay. It's yeah, Miss Kevin's going to be gone for a little while. She's got a wedding. Her brother's getting married. Okay, Missy.
Oh, see, this is nice. This is very calming. Even if you sped it up a little bit, if that's too slow for you, but still,
No,
this is calming.
it's easier than that because what I don't want is to be able to have this kind of a thing going, or even this, and it would be too distracting, I think, at any other speed.
Right.
But yeah, Misa likes her.
1 second.
Yep. But I think for trial right now, this is my favorite background because look how it blends perfectly with my background set. I also like this one.
Hi. You should not be getting as much feedback now. I forgot I had my speaker on it, my headphones. I'm so sorry.
Somebody else could. I apologize. Uh-oh, pupper goes off. Pupper going off. Go get the puppers. Pupper. So we have so many things going on right now. It's hard to focus on any one. But we're going to go ahead and continue listening.
And as we pointed out in the U.S. Williams, Wiggins, and Rimpilla, all of these were issued well after the Rhodes decision in 1991 by the Idaho Supreme Court. IAC claims are most frequently involved now and relate to trial counsel's conduct that occurred outside of court, whether any investigation was undertaken or whether that investigation was abandoned, whether there were nominally strategic decisions that were made by counsel. In fact, we just kind of uncovered or came across some information in this last week, just a few days ago, in trial counsel's materials that radically changes our framing of the issue with regard to mitigation. And as we delve deeper into the case, we expect those insights and revelations to continue to emerge and occur. So we have to try to accomplish all of this as his new counsel, while attempting to satisfy those duties that I laid out in my memorandum and in my declaration, including ethical obligations, the governing guidelines in capital cases, case law that has been established that heightens the burden in capital cases, and then the Idaho statutes and the court rules. That's that's kind of the background of the context, I guess, for that I didn't provide in the memorandum. I included in this material a survey of all of the capital cases that we are aware of, which I believe is all of them, which have been reviewed under 1927-19 after a sentence of death since 1998, which is the year that our office, the State Appellate Public Defender, was created. And we were charged in that originating charter statute to represent death sentenced individuals in post-conviction and appeal. We did that not to show that every case is essentially required more time than I don't think that that's useful when you're looking at a statute. We submitted those cases to show a relative comparison, to show that if any case since 1998 requires a finding of, quote, extraordinary circumstances, which would make it impossible to fairly consider defendant's claims in the time provided, and that's 2719 subsection 8, it is this case. More than any other case in the last 26 years, this case does present those facts. We believe it is also necessary, or it's incumbent on me, to consider for the purposes of this motion, the other capital obligations imposed on us as counsel in the capital litigation unit, to mention the 7 other capital cases that we currently have. I understand that that's of no concern of the court, meaning the court can't do anything about that. But that caseload makes it necessarily slow going for us and will not allow us to devote our entire time to Mr. Daybell's case, even if that were our desire. We work as fast as we can, as diligently as we can, while trying to make all of our deadlines in all of these capital cases that all work under either court-issued scheduling orders or statutory deadlines, like 2719. But we also do have human limits. Along with my affidavit, I've tried to clear up any misunderstanding about the extent of our involvement in Mr. Daybell's case prior to our appointment, or any preparations our office had made in anticipation of being appointed. Mr. Leighton, the State Appellate Public Defender, is with us today to answer any questions the court might have regarding our institutional limitations, whether that be staffing limitations, financial constraints, the limits on the staff imposed on our team, meaning that which we are permitted and not permitted to do prior to appointment, even in a case that we are anticipating to be appointed on. And we can make Mr. Leighton available to court for questioning if that would be useful. But we would ask this court to make a finding in this case based on the information presented in our memorandum, and particularly in the affidavits, my own declaration, that of Ms. Romero, who worked at our office for 18 years, yeah, and ran the capital litigation unit. And to allow us to make that finding of extraordinary circumstances, allow us to finish a review of the record and transcripts, get through as much of trial counsel's files as we can under our obligation under Williams, Wiggins, and Rumpilla. And at that point, allow us to file an amended petition. In that amended petition, we will be able to consolidate or add all of our identified IAC, primarily IAC claims. We will be able to winnow or pull out from our original petition those that are no longer founded or contradicted by the evidence that we come across. Winnow and narrow his claims and preserve those claims that the Idaho Supreme Court says we have to bring up now because they will not be addressed on appeal. From our experience, we also believe that the court is going to permit an amended petition in this case. It saves everyone time, energy, and resources to not require the state to file an answer and response or a motion for summary dismissal until the amended petition is actually filed. And I know your Honor has seen the stipulation that we already filed with the court, relieving or us waiving the 30-day requirement in the statute for the state to respond to our original petition. And that waiver stands through any scheduling order that this court would issue. That's largely what I wanted to cover this morning, Your Honor. I'm available for specific questions as to my declaration affidavit, anything that our office chief can offer. We are clearly committed to Mr. Daybell and giving him the very best representation we can. We also know the constraints under which we operate, and we are going to do the best to meet both, I guess. We are in a bit of a predicament, though, in that we really do feel that it's imperative for additional time in this case, and that without a finding of extraordinary circumstances, Our position is that Mr. Daybell has a statutory right to counsel in post-conviction, and that along with that statutory right comes a constitutional right that's attended to it of effective assistance of counsel. And without additional time, we are not going to be able to represent Mr. Daybell effectively in his post-conviction. Thank you.
All right. Thank you for the argument. I don't have any questions at this time. Ms. Blake, response from the state, please.
Thank you, Your Honor. And last time we were here, I think this had been contemplated, and that's why we set this hearing. The state's understanding was specifically to determine whether or not the court would grant an extension pursuant to 1927-19 subsection 7, or subsection 8, excuse me, which would allow the court to extend the 90-day time limit that's placed by the statute. Counsel was willing to sign a stipulation to allow the respondent state additional time to file a response in this case while we waited to see if there was going to be a determination that things would be continued. At that time, I think the state's position had been pursuant to the statute, we really needed to see something in writing or under oath with the requirement pursuant to that statute. We recognize we've now been provided multiple affidavits expressing the...
I'll try and work that up, Andrea. Thank you.
The petitioner's position that this simply cannot be done within 90 days, that it is an impossibility. The state has also looked at where we're at currently just in the timeline and recognizing whether or not that gives us time for the state to file a response, potentially have a hearing on a motion for summary dismissal, and then also have an evidentiary hearing on any remaining matters while still allowing the court time to draft the decision as is required under the 90 days. We recognize the reality is that is probably an impossibility at this point. We also recognize what counsel's referring to when they talk about the amount of discovery in this case, the voluminous court records that are involved in this case. It was a lengthy trial. There were multiple pretrial proceedings leading up to the trial. The state is cognizant of that, and we recognize counsel needs an opportunity to review the transcript from the proceedings in this matter, as well as trial counsel's file. The one thing that I would note, the state had started a response brief, and I recognize why counsel's briefing was so thought out and why so much was contained within it, where they were asking and they had the burden to show the court and demonstrate why they would need the extension of the 90 days. As the state began the response, I think we were getting a skew of the issue just before the court today, which was why we opted not to move forward with that filing. The state understood the issue just to be whether or not that 90 days is going to be extended. So I would indicate while the state essentially acquiesces in the fact that 90 days is probably inadequate time to complete this post-conviction proceeding, I think we may disagree and have a dispute as to what will be entailed by the post-conviction proceedings, how long they should be continued if in fact they are in some of those matters. The state had anticipated those would probably be decided at a later date. If the court does want to have discussion on that, the state would be prepared to give the court our estimate and our thoughts regarding that. I would note that with regard to Idaho Code 1927-19, I did attempt to find any case law regarding the 90 days itself and the extension of that. The bulk of the case law surrounding that statute really seems to be around that initial 42-day deadline to file the initial petition, and then subsequently discusses a lot on filing successive pleadings. With regard to the 42 days, though, I would mention that in State v. Payne, 146 Idaho 548, and it cited the Harrison v. State, 144 Idaho 51. Essentially, they reiterated that that 42-day deadline was not unconstitutional. We have Langford v. State, 127 Idaho 100, where they specifically talk about the legislature identified a problem and attempted to remedy it with a statutory scheme that is rationally related to the legitimate legislative purpose of expediting constitutionally imposed sentences.
Could you repeat the three sites, please, Ms. Blake?
Yes. Sorry, I went kind of quick there. The last one was Langford v. State, 127 Idaho 100, and then also State v. Payne, 146 Idaho 548, and that was citing to Harrison v. State, 144 Idaho 51. Payne and Harrison had specifically reviewed the claims that had been made regarding 1927-19 being unconstitutional, a violation of due process, or a violation of the Equal Protection Clause. And Harrison and Payne had indicated they were still finding that it was not a violation of that. Other cases, such as Langford, lay out the legislature does have a legitimate purpose and does have the ability to set statutory timelines. So while I don't think there's anything unconstitutional about the 90 days, I also think that's why there's a provision within the statute that creates a carve-out where the court can find the impossibility and extend time if necessary. Also under the 1927-19, we see another carve-out that does talk about the ability to file successive pleadings if there is something that was not known or reasonably could not have been known at the time of the filing of the petition. And in Dunlap v. State, and I apologize, I do not have this. Oh, there it is, 159 Idaho 280. They had talked about in a successive pleading, they still adopted that 42 days. And they said for successive pleading, that should be filed within 42 days of when the matter became known or reasonably could have been known. So I think we see time and again, the courts have approved that 42 days and even extended it to successive pleadings. While that's not really the issue before the court, I think the state would just note that time and time again, these have been held to be constitutional to have these time constraints placed by the legislature, specifically with regard to 1927-19. All of that being said is to just support the state's position, I guess, that while the 90 days, it appears, would need to be extended, I don't think that the extension is meant to be indefinite. I think the legislature clearly had a set purpose in mind in putting these time constraints in place and was thoughtful in creating some carve-outs for matters such as counsel indicated that new matters may arise, or in this case, that if it is an impossibility, that we're allowed to have that extension to get the matters fully litigated before this court. And if the court has any questions, I'm happy to answer them, but that's where the state is at today.
All right. Thank you, Ms. Blake. I don't have any further questions at this time. Mr. Thompson, essentially the state's not contesting that, as I understand their argument in my review as well, the showing that the petitioners made here in regards to circumstances that are extraordinary in the case that would make it impossible to fairly consider the petition within the 90-day time limit. Some other issues were brought up in argument that will come up in the future more likely than they would be relevant today. However, if you have any rebuttal argument you'd like to offer on the issue of the extension, you can do that at this time.
Not in rebuttal. The only thing I would mention is I do want to make clear that we're not challenging the constitutionality today. We're literally operating under the premise that within the statute, this court is permitted and it's contemplated to allow for a finding of extraordinary circumstances. So we're not, I don't want to get into Langford or Payne or Hairston or any of these cases about the constitutionality. We've raised that issue. That's an issue for another day. It really is whether this court is going to make a finding of extraordinary circumstances, submit that to the Supreme Court so that we can all take a breath and not be operating under this October 15th date. So.
Okay. The court's considered the arguments and matters submitted. Interestingly here, I'll note that there's some pretty specific direction to the court in Idaho Code 192719, subsections 7 and 8 about how I'm supposed to handle these proceedings. We are having this hearing to make a determination under subsection 8 as to whether or not, as the statute indicates, there's been a showing of extraordinary circumstances which would make it impossible to fairly consider defendants' claims in the time provided. The court also notes that there's a requirement in there that says if the court makes such a finding, that shall be in writing, shall be immediately reported to the Supreme Court, which shall at once independently consider the sufficiency of the circumstances shown and determine whether an extension of time is warranted. So in terms of considering the motion today, first I'll note in the 105-page memorandum filed in support of the motion, the court's considered the affidavits there. This court's obviously very familiar with the facts of the case, the time involved in the trial, the discovery in the case, the magnitude of the issues in the case, since I was the presiding judge in the trial as well as all the pretrial litigation. The court, having considered the record and looking at this October 19th deadline that's coming up, that's the reason to have this hearing, as counsel has indicated, to determine whether or not there is going to be an extension of time and proceed in an orderly manner. The court, having said all that, I am going to make a determination today orally on a finding that this case does have a showing of extraordinary circumstances and presents extraordinary circumstances that would make it impossible for this post-petition conviction to be fully determined and completed by October 15th. As Ms. Blake indicated, there's not only a need for the petition to be fully completed, there's a chance for the state to have a summary dismissal opportunity if they wish to file that. We'd have to have a hearing there. In addition, we would have to have a hearing on the petition, on an evidentiary hearing, and then the court would have to issue findings. And given the scope of issues in this case and the amount of discovery, et cetera, I just don't see any way that that could all occur on or before the 15th of October. So for the sake of counsel, I typically wouldn't make an oral ruling knowing I have to have written findings, but I do want counsel to know that's what my findings are going to reflect. In terms of a time frame, I'm going to make an effort to have the findings done and completed by next week and submitted to the Supreme Court. Because of that next required step of an approval of the Supreme Court, and the court at this point not knowing, and I'm not going to speculate on what they may or may not do, I think it would be improper to further consider any scheduling going forward, because the schedule we're still under right now is the 90 days with an October 15th deadline until such time, if and when we receive an approval of the Supreme Court granting the extension based on the findings the court's going to enter under subsection 8 of the statute. So, counsel, I'll make an effort to timely and expeditiously get the written findings out, submitted to the Supreme Court. If the Supreme Court approves that and there's an extension, then we would conduct a scheduling conference and determine a reasonable time frame to keep things moving forward. To Ms. Blake's point, if that does occur, I do think that clearly this statute has a policy behind it to move these cases along, and so the court's going to keep that in mind when looking at a scheduling order, assuming that we do get approval. If for some reason the Supreme Court does not make that finding and indicates that we're not allowed to have the extension based on their approval, then of course we would meet again to talk about scheduling and how we would be able to complete or get things done by the October 15th deadline. So that's, I'll call it a provisional ruling for today, that I am going to grant the motion to extend time, but it is dependent on me completing the findings in the record, submitting those to the Supreme Court, and then having the answer from the Supreme Court. So that will be the court's determination on the issue today. Mr. Thompson, do you have any questions on where we stand at this point?
Not on that, Your Honor.
All right, thank you, Ms. Blake. Any questions on the court's ruling there?
Not at this time, Your Honor. Thank you.
All right.
So we're done with that one. Okay, so the next one we're waiting for. Everybody look, this is the design. I'm going to share it bigger. I'm going to embiggen it. I'm going to share when, wait, can I share? No, we're going to have to do it this way. Here's the design that Andriel. What do you think, Andriel? What do you think, Sneaky? Can't hear you. And I can't see you. I see you better this way because I don't have my glasses.
I think it's cute. I think it's super cute.
I love it, but the only concern I have, I really do love it. It'd be cool if we had a pair of my glasses up there, but no. The more items we have, if I go to reproduce this entire thing, it is going to be exorbitant amount of money because they have to do the pink, the black hat, and then each letter, the hand, and each letter. I will use it. I will take out the white background, and we will be using it.
Oh yeah.
I will say, you have made my mind up for me. I love this lettering. I'm going to try and see if I can find someone who can do this. The problem I have is it probably will have to be a stick-on and not a stitch-on. Unless somebody has a machine that can do the multicut colors. I love the mug.
I do too. That's great.
So
I will be back shortly, but I like it a lot.
I just don't have my glasses, so I can't see you this big. All right. Okay, thanks, love. So I will take the background out. I will resave it without the background. It is cute. I like it. You did good. I just got to see. I'm not sure we can do this with on a t-shirt and things like that. But I can definitely use it as is, and that is going to be the ADKILY. Yes, I know I'm going to save it the same again, and yes, I'll need to override it. Okay, so now it's adorable. It really is adorable. So I'm going to delete this one, and then I'm going to reinstate, but we're going to do it this way. And I'm going to pop it up there. That is cute. I didn't use the kind of hat that you put in there because I don't wear that style hat. Mm-hmm. Mm-hmm. We'll offer different styles. Mm, I don't know how to send this in. Well, how do you want to play with it, Andrell? Because I don't know how to send this in a way that you can play with it using the StreamYard. We'll talk about it later, but yeah. Yeah. Um, we'll come back when they do. So, how long were they going to be gone? Oh, I don't know. Yes, I know my software update has happened. Leave me alone. Both my phone and iPad updated in software. So, Andrea, what would you want to do to it? Mm. I have already wished all these people happy birthday. Why are you sitting? Facebook sometimes pisses me off. They sent me messages, wish everybody happy birthdays. I'm like, I did at the beginning of the live. 3 older brothers, and I'm the baby, no sister. Andrea, you want to help me figure out how to send this to you? I'm waiting. Okay. So we have several different things we can use depending on what's going on. And I like having variety. So we have this and we have this. And then I also have just that, but it just depends. So I think that one's going away. That's too small. Yep, that'll work. I still have this. I still have the red Solo cup. I'm gonna do something fun with this when we go back to that. And then I have this, then I have this, then I have this, then I have that, which you can't see. So this is it for now. This is it for now. Okay, guys, I think I was not going to be on stream all day today. Promises. None your bits. How you doing? I can send it to you, Andriel. You just need to help me. Help me figure out how to send it to you. Oh, who all is with me? Oh, sorry, guys. I gotta wake up.
No. No.
Okay, I guess I don't have to wake up. That's a problem with eating lunch a little early. You're hungrier earlier. Okay. No problemo. What program do you use, Andriel? I'm a Photoshop and Canva girl. But that I like the cap. We could put all that on the cap. If I really wanted to have fun, I could put a hearing aid going over the handle. But I don't want to do that. I think that this serves a good purpose. I'm so sorry. I haven't done anything in Pixlr. Okay, I've done those. I've done everything, every single one of those. Every single one of those. You're a twin, aren't you? Yeah, I have a twin brother. I had to do all those. I find it interesting. I had to play with his dump trucks and everything with him, but he never played with my dolls. Because boys don't play with dolls. Girls can play with dump trucks. I thought that was plumb mean. I'm like, what's good for the geese is good for the gander, y'all. But, you know. Trying to see if we have anything interesting in the news. Oh, for those who want to know, the spiders are doing well. My big one's getting bigger. They've made their little nest in the upper corners, and we'll see how they go. The big one's cute. Oh, really close in age. Yeah. My brother did the same, and of course we squealed, and he got the biggest thrill out of it, and I was upset. Finally got to the point I stopped squealing. I started ripping the tires off his truck and burying them. Then I got in trouble, but he didn't. Go figure. I didn't do frog gigging, but what I did other stuff. Oh, I wish I had the energy I need and want to get some things done. I still got homework to do. Now that's easy. When I get off here, I have nothing tonight. I'm better at studying at night than I am in the morning. I'm not a morning person. 3 kids with 2 weeks shy of 4 years between the eldest and youngest. My kids are 4 years, 4 months, and 4 days apart. Well, 4 weeks. Yeah, 4, 4, 4. Someone told me 4 is my lucky number, and I said it's never been up except for my kiddos. Ooh. Y'all, I can't quit yawning. Help me. Now I really do look like EDV. I wish I could reach out to her. I've tried. I've gotten nowhere. I know she's kept really guarded because she is so popular, but I still want to talk to her because there's some of her stuff, especially on YouTube, how to do YouTubing thingies, and I really want to interpret those. But I can't until I get her permission. I don't want to get in trouble for copyright infringement. I had to hide my dolls. My brother would tear them up, and he played Tea Party one time, and I think the other brothers ragged him. Yeah. Yeah, got that one. I have a twin brother. I mean, some of this stuff is typical brother sister stuff. He used to put scorpions in my bed, put them in my dresser drawers. Sometimes he'd catch 2 or 3 and put them in my bedroom and wait for me to find them. Yeah, that wasn't the best of experiences. It wasn't the best of experiences. Can't blame him. You know, Mariah Carey's been on my mind. I'm not the biggest Mariah Carey fan. I'm really not. I mean, yeah, she can sing high, but she's just not my cup of tea. But to lose your mother, I mean, I don't hate her. It's just not my cup of tea. There's some stuff I like of hers, but I'm not like I am with Celine Dion or other people. But my heart goes out to her. She lost her mother and her sister They both passed on the same day. Now they're not talking about how. I think her mother was ill. I'm not sure. But y'all, that's tough to lose both in one day. Yeah. What did our I mean, our brothers always this cruel? I mean, scorpions were bad enough, but when he put a snake up my pants, God, even though I didn't know it was a grass snake, I just knew it was a snake. This chick came unglued. I I kid you not, I came unfreaking glued. And my mama fussed at him, but she told me, "Boys will be boys. It won't hurt you." They still bite. Bites are bites. Oh, well, I didn't. I didn't have an opportunity to. I had 0 opportunity to do that to him. I think the worst thing I did to him was not tell mama the truth about something, and he got punished for it. And in my mind back then, it was just cause. So many times he did things to me and he didn't get in trouble. So he caught up with the tax collector, so to speak. And then when he got punished, I felt so guilty. I felt guilty forever. And he used it against me. And so whenever, ever anything happened and he didn't want to get in trouble, if I didn't, and I knew because our parents were like, if we catch you lying, you think the punishment your sibling got was bad? You gonna get it worse. And his was bad. So I was like, I'm not gonna tell that truth. it was I was probably in my 30s before my mom found out the truth. Yeah, I'm not scared of nothing. I was scared of him. Probably. Boys will be boys, but you're right. You're right. So, oh, what? Who are those? Rawhead and Buddy Bones. I don't know who those people are or characters are. I don't know what those are. Sorry. Educate me real quick. I have no clue what you're referring to. But my brother, we had a male babysitter. I may have told this before. And the male babysitter came to the house and my parents left and they had a good old time scaring me. And do you remember I don't those who are old enough, do you remember when the portable recording cassette machines came out? They were the big square ones like that. It was the it was the bomb and we each got one and he recorded my dad had made him a toy chest, one for each of us. Do you know that vinyl, that thick puke yellow vinyl back in the 70s? And he had the Kermit the Frog piggy bank, and he went thud, thud, like someone's walking. And then he went, and then the other guy was growling. I mean, they were making all kind of stuff. Well, he waited for me to fall asleep and he put that under my bed and he pushed play. And he got back in his bed. And when it woke me up, this girl flew out of that room like a freaking banshee. And he ran and got the cassette recorder and hid it in his bedroom. He just threw it under his bed. And my parents come running upstairs, and I mean, they were like, "What's going on?" And then I told them, they looked under my bed. They said, "You got to stop this. It was a dream. You got to stop this." I said, "No, it's not. I swear." Well, my mother went and checked on my brother, and she stubbed her toe on something under the bed. And when she pulled it out, it was a recorder. And you know what that mother's intuition is? She pushed play. Ooh, if he didn't get a butt whooping. You okay, Miss Sneaky? Yeah. So are we interested in hearing the rest of this trial that we've been watching to see if they're going to move this to Ada County, or y'all done for the day? I can go either way. I can report on it and tell you. So was it supposed to be 3:30 my time that they were going to be back? What time did they say they were going to be back? Yeah. Yeah, you don't show fear, but boy, when you're sound asleep and it wakes you up, that fear's there no matter what. Are they what time zone are they? It's in Idaho. So what time is Idaho? What time zone? Guess I could look. "2:17 PM, so they're an hour behind me. So that's you said 3:00 their time? 1:30 their time? Um, so we have 15 minutes? Yeah, I don't mind waiting that. Mm. You know what I hate is when you're sitting in a room or somewhere and there's nothing sweet to eat, and all the commercials that pop up are holiday treats now. All these candies, Oreo cookies, which are my favorite. I mean, it's like, yeah, everything's about Reese's Pieces in cupcakes and pie crust in a bottom of a crock pot. I mean, it's just nothing but candy. How do you know? How do you know that I'm hungry for candy? Is the internet psychic? Ugh. Oh, question. Because I'm considered a junior, they are saying that we can order our class rings. Now, those things are expensive. Should I or should I not get a class ring from college? I no longer have my class ring from high school. It got stolen. Should I get it or not? It's something I'm going to have to save up for, maybe do next year. I don't know. The one I want, $1,600. $1,600. Of course, it's diamond chips and gold. I can do silver for 1,100, but I just don't have that right now. But maybe I'll get it next year. Maybe I can order mine next year. I just don't know. Yeah. Do all of y'all who went to college have college rings? Now, I'm thinking if I can go to A&M for a master's program or wherever, law school, I might get a ring there. But for my bachelor's, should I get one? What's your thoughts, Miss Sneaky? Well, the ones that they have for us have little itty bitty diamonds all the way around it, and it's gold. Didn't finish college, yeah. And it's gold, and it's kind of like I don't mind silver. But with the cost of gold nowadays in US is as horrible as it is, I can't. It's so much, so much. Did you go, Sneaky? You went to college, right?
No, I did not. I went and did a 1-year vocational program to be something called a nursing unit clerk, which is basically just somebody who does paperwork in hospitals and answers a phone to keep a nursing unit running. And it's not somebody who actually does any nursing work. It's just somebody who does the paperwork end of stuff and doesn't actually know shit.
Not
Sorry.
because let me tell you, without people like you, those nurses wouldn't know whether to wind, what is it they call scratch their watch or wind their butt.
Well, and the thing is, too, is that with doctors, right, they can't do their work without nurses. So crap rolls downhill, it seems. And it's funny because the little man always seems to be the one that gets in trouble. But I worked with some really great people in the hospital, and I worked in our hospital here for a number of years. And then I switched over into IT in like healthcare and supported our healthcare staff in that way in clinical applications and stuff. So I went to like a year program of something really specific, but I didn't actually do any like programs or anything. So I think it's something that you should definitely that you should commemorate. Like, it's, especially if you do a bachelor's degree or a master's degree, like, I think that's a big deal, right? It's not something I've ever done. I've done.
Let me see if I can pull it up. Let me see if my search. I'll pull it
And
up.
so I just think that if you, Ronnie has a great idea. She says maybe you can design your own ring with turquoise in it. That, you know what, Ada, that might be a great idea. That might mean more, and it might cost less. You never know.
You know, that's right. But I still want the logo.
Okay, fair enough. Yeah. Like, I think class rings are more of a thing, and like more of a staple in pop culture in the United States rather than in Canada, even though I know people in Canada in bigger schools do have class rings. So I think it's a lot bigger deal in the States, and it's a lot bigger deal, especially for high school students, right? Because like I didn't ever do class rings for high school, stuff like that. So
I hate mine was stolen because my cousin, who's deceased now, had a jewelry store and he custom made it, and it didn't look like a class ring, and it broke my heart.
That's awful. I'm sorry.
Can I drop a link for anyone here that is not a subscriber to his channel? I don't understand. I'm 55 hitting 60,000 views. I just hit 50,000. Dang.
I'm sure she would have no problem with you dropping a link to RA's.
Anybody here who's not a subscriber, RA, please go subscribe. I want him to hit the 60,000. Here are my ring choices. I don't like the rope one. I'll tell you that right now. I'm not too fond of the rose gold, but you can get these in any color, any gold. This one here, the way these have a single and then one comes out, single, one comes out, that's going to snag everything. So I'm kind of between the bottom one here And I think this one would be pretty in gold.
Are you talking about the bottom one that's in silver? Like it's oh, that one. Okay, thank you.
That I don't
Isabella ring. I see, in gold. See, that's a nice ring.
That is with silver gold plated, and then 10 karat gold is 14 karat gold. You know, you're seeing the prices.
Miss Trial, please feel free to post a link to RA's channel. Sorry if you didn't hear us. We are definitely friends of RA. We would like him to succeed. I think most of us are definitely subscribers, but please do. Thanks for asking first, though. We appreciate that.
Yeah. There's some people that I'm not that crazy. I don't mind a little bit. RA can always be name dropped here. There's certain people who, RA, I'm only here because I have this many subscribers because RA. This is one I'm kind of liking, but it's $1,000 and 10K.
And as you said, it may get caught. You never know.
Yeah.
Like
So
the little settings.
Is this one this one down here.
I think for everyday wear and just for, like the commemoration of the event, right? That's the best. That's kind of like the best ring.
Yep. And there's our Angelo State University.
It's a nice crest.
Yeah.
Mm-hmm.
So we'll see. We'll see. Yes, RA and I are going to have a long talk after his son's wedding. We got to figure out how to get this baby installed to where I have sound in my ears and sound through you guys.
Ronnie, I love you. She's rinsing out the color in her hair. I need to dye my hair soon, so I need to do that.
You know what, guys? I used to dye my hair all the time, but ever since I've had chemo multiple times, dye doesn't do as great, so I have to go get it professionally done.
Mm-hmm.
And it's $300 every time. So I let my hair grow. Roots are about this long right now, so it's about twice a year I go get it done. But I need to go get it done soon because during the holidays I do a lot of interpreting. If Sandy Patty comes to Kerr Patch, which she does every couple of years, Kerrville, I call it Kerr Patch. I do a lot of Christmas concerts for the Hill Country Chorale and things like that. So I always make sure my hair's done by mid-October.
Nice. Well, yeah, you have to look good, right?
Yeah.
Yeah. I used to have a really wonderful hairdresser who lived in town, and she used to do my hair from her house, and she used to give me a smoking hot deal on it. Her name was Lisa. If Lisa ever finds this, Lisa, I love you. She moved away. I miss her. I miss her so much.
Well, my hairdresser, I didn't see because I can drive by and when you look in the door driving by, you could see her. I don't see her anymore. So I got to find a business card and I got to go, ma'am, did you move booth? Or are you out of there? And if you're out of there, where the heck are you? Because she's the only one who's done my hair. I don't see, it's all natural looking. I don't have big clumps of color and it's very thin, very fine. I don't like the chunky. It's like my nails. I make them do them really thin. Partially because when you sign and they're thicker, believe it or not, you feel that weight. And they go, you break, you'll know thin now, you'll break now. Too thin, they'll break. No, not good. Not good for you. And I'm like,
they'll be fine.
Take half of that off. This person, now I paid, I mean, it's normal. This was done in San Antonio. The price is a little higher there. but it is the perfect thickness. They're consistent
nice.
across the top. They're all cut even. You don't have one that's cut like this. And I have asked for this kind of tip. Let me do that. Because when your nails are shorter and then they put that white so thick, it makes your fingers look wide. My nail beds kind of go like a duck's foot, thinner down here and wider up top. But when you look at them, they don't look like that because he angles it in and he did just the tips. There are tricks and tips to the trade, and we have a lot of nail techs, but I'm in love with this one. Absolutely in love.
That's awesome. Like we were saying a bit earlier in the chat, doesn't matter what job you do, everybody has the thing that they're good at, or like those natural abilities, and it's great to be good at a job, and it doesn't matter what that job is. So excellence is to be appreciated.
Yeah, and I told my children, I said, not everybody's meant for college. My son took some college, but he was taking business class, and unfortunately, the business classes he was taking were stuck in the 80s. And he goes, well, when you have to find a supplier, you got to get the phone book. You got to do. My son's like, you got to send them all this paperwork and contracts and stuff. And my son's all like, dude, I just Googled him. I emailed him. He sent me a contract. I sent him a picture of my establishment. We're done. A total waste of money. So, I was like, it's okay. It's okay to go to a trade school. There's a lot of money for mechanics. There's a lot of money who people work in any kind of service. And even your trash collectors and your plumbers and all of these people, very important and dignified jobs. We may not, some of us can't handle the crap, but somebody has to do it. And I've never treated anybody lesser than, even the street sweepers. It's important. You're working hard, earning a living. You're not out thieving and all of that. It's an honorable thing to work no matter what you do. Just take pride in it.
Well, and I am the daughter of a plumber and a pipe fitter, so I grew up thinking that trade schools were just as good as a bachelor's degree, because you do 4 years and you are fully ticketed at the end, and you pretty much can make just as much or more. So,
and the other thing is so many people go to college. I went for 4 years to get an associate's degree. Interpreting is different though. And it's hard to get a job. And I've been told if you had a bachelor's degree, we'd hire you, but it's requirement that we hire. We don't care what the bachelor's degree is in. And I'm like, but you don't understand. I did 4 years, 105 hours. And you're telling me it's worthless because it doesn't have a BA next to it? Yep.
yeah.
Oh, dang.
I know one of my friends, Bo, he works for the government, and he says, it sucks because you can work in healthcare and get a really decent wage because of what you're certified to do and your experience. But in my sector, even though you're completely smart enough and qualified, you need a bachelor's degree in order to be promoted. And if you don't have it, that's it. You're done. You are an entry-level person forever.
Well, no, there's
so
exactly. And like case one, veterinarian, medical, legal. I mean, there's some fields out there that you really need a degree in. But I really struggle with those who belittle those who choose to go to a trade school. Not everybody can be a lawyer. Not everybody can be a doctor or wants to be either. College is inexpensive to a certain point. You are so correct on that. But
we're getting to the point now where there's lots of people who want to go to university, but there are not many people who want to go to trade school. So we have lots of people who are like lots of cities who need their infrastructure rebuilt and like retrofitted, things like that. And we don't have the people, we don't have the young people who know how to do it. And the older people who can teach you how, like, are phasing out, right? So all of this opportunity is lost.
Yeah, those who can do, those who can't teach.
Mm-hmm.
And the other thing is that you know, I was a photographer for over 20 years. I had a studio, and I had photography students come to me and want to interview, and I'd start asking them questions, and they go, "Well, I don't know all this because I haven't gotten out there." And they go, "Well, do you know this equation for this, 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 and this?" And I said, "I know my equation. I may not know what you've learned." "Well, then how can you tell me you won't hire me? I have a degree and you don't." And I said, "Let me tell you something. When it comes to photography, you can know everything out your butt when it comes to the paperwork and to the book. What experience do you have? Because let me tell you something. Body memory coming and being able to adjust the aperture and the speed and everything all at the same time and be moving, 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 moving. I mean, when I'm at a wedding and I'm walking, I'm looking, I already know that I'm going to have to set mine at maybe the speed, maybe 300, because this is going to be a moving shot, and I'm going to have the aperture at 4.5. Okay.
Mm-hmm.
I know by experience what I'm going to do. Because in the book, you can set it like that, but when you get there, it doesn't come out that way. And back then, we had film. We didn't have digital. And I could not afford to hire somebody to shoot a wedding and everything be exposed wrong because the book said this. And then I had people come in who'd have 5, 6 years experience, and I'd start them out at $50 an hour for a wedding. And the peon, who was a college student, had to carry the bag. Oh, they were mad. But it's true. Not every, just because you have the book smart doesn't mean you have the physical capability.
You can't take those photos again when it's a wedding. Those photos don't come again. Like, sorry. That's why they pay wedding photographers big bucks.
I had a $70,000 wedding.
Exactly.
It was on the medium format, which is the negatives are this thick. It's a big box. And I had a college student who said they had some experience. And I had given him a camera and said, "Okay, this is your interview. If it comes out great, if it doesn't, great. I'm going to capture all the main shots. You're going to capture and follow behind me like a backup. If I'm shooting, you're shooting next to me. But you can't ask me. You have to make your own decisions."
Yeah.
I put my camera down. And he saw that I had it set on a certain setting. And he said, "She's screwing this up." And he changed it and didn't tell me. The entire groups of pictures, groups, people from all over the US came to this. It was a multi-million-dollar wedding. None of them came out. They were way too dark. And I couldn't figure out what happened. And I said, he was, and one of the things they have to do is they have to, once the film comes in, they have to card every negative. Then we had to send those back to the lab. They printed them. Then we get the little 4x5s, and we had to proof them up and put them in a thick album, and they got to look through and choose what they want. And I just dropped my negatives down with his, and I just told him to card them all. And he came to me, "What happened?" I said, "What do you mean, what happened?" He goes, "Well, I set this to the right setting." And I said, "You touched my camera is what you did." I'd photographed in that church. I knew that lighting inside and out, backwards and forwards.
Mm-hmm.
But guess what this chick knew to do? Called bracketing. When I shoot big groups, I bracket. I lighten it 1 or 2 because I take 5 shots. What I want, 2 lighter, 2 darker, just in case. Because digital is much easier to fix. May not be perfect, but easier to fix. I had something that I had to put every single one of those. I had to pay $85 a scan on each one of those negatives so I can put it in Photoshop. And that was when Photoshop was new. Lighten it, fix it, send it out. And it cost me so much money. And so that's it. It was a nightmare. And then
Don't think about it. You're going to give yourself a migraine again.
fine now. I had I had a lot of $1 million weddings because we had this place called the Dominion. This bride was drunk before 9 o'clock in the morning. She had a second generation wedding dress made of silk from China, and her husband stepped on it at the photos right after the altar and tore it out of her face. But anyway, she was plaster drunk at 9. But her makeup artist, that I told them, no concealer under the eyes, no concealer on the face. You're going to have flashback. For those of you who don't know, concealer actually has an iridescence to it, and it will make you look as white as a piece of paper on film. That girl concealed her entire face and then put the foundation on top of it. So all 100% of her photos, white face, blush, looked like a freaking clown. So sitting here with a heart attack, I had taken some of them. I knew how to touch up on a negatives on a machine. Well, it's basically a magnifier with a light, and I know how to touch up negatives. So I added some colors. I couldn't get it perfect on a couple, so the parent and her can see the difference. And I was willing to, but they had to pay me because that was her fault, not mine. And I told them not to do it. And I know they had the money, and the mother and showed up, but the bride wasn't there. And I said, daughter going to be here or is she at work? She's at work. And I said, well, I've got some bad news. And she goes, well, I do too, but let me hear what you have to say. And I'm like, oh crap. And I said, do you remember when I sat down with y'all and I told y'all that you make sure your makeup artist doesn't use concealer? She goes, yes, why? I said, she did. She goes, well, I told her not to. I guess my daughter told her to. And showed her the pictures and she busted out laughing. Now, this was about a $12,000, $15,000 job for me back in the 90s. Well, for the student, back in the 90s. And she was rolling on the couch laughing. I'm about ready to vomit because I'm sitting here expecting her to want a refund, and I'm not going to do it. And I'm expecting a lawsuit. And she goes, I said, okay, what is so funny? She goes, 2 days after wedding, he filed for annulment and kicked her out of the house. We don't want any of the photos. Keep them. The bride's mother.
Oh.
And she said,
okay, well, that was definitely worthwhile.
If they were still going to be married, I wouldn't blame you because we had the discussion that there was not to be any concealer on her face because the lights I was using were the old. I mean, it's the big with the it's the Hasselblad. It was like the studio kept the money because here's the thing in the contract: you pay for our services, and then the final prints you purchase are so much a print. Just for us, I had 4 photographers at her wedding. This was a multi-million. She married a music producing mogul. I mean, he was famous. I don't know who he was, but I'm not into that. But it was a massive wedding, massive. And I looked at her and I said, are you going to miss that million? And she goes, my husband might. And I said, so what's going to happen now? And she goes, oh, my husband's all but disowned her. we tried to talk her out of getting married. We even tried to talk him out of marrying her. She is actually, and this is not to say anybody who has these conditions can't get married. But when you are a multimillionaire music producer, you can't have a woman go to an award ceremony, stand up and go, whoo! I just nearly spilled my coffee. Hoot and holler, drunk off her butt, and start dancing on the table 2 days after you got married.
Probably
That's
not.
what he did. And he goes, I'm not going to live with this. I don't have to. We're Catholic.
Bad for business.
We're annulling it. We're done. My partner came, and I had him and his wife in so much pain. I told him, I said, look what happened. I showed them, and they were like, oh my God, do we have the money in the account to refund it? And I said, yes, because we have other jobs and stuff coming in. I said, yes, but do you know that camera we were going to get? Yeah, that's going to go bye-bye for a while because we needed to upgrade a camera with a lens. And digital was getting ready to come out. We were and a digital back for my camera alone was $32,000 back then.
Yeah.
And so he was sitting there and his wife, and she started crying, and I could see he was turning.
Mhm.
Are you okay?
Shit. Sorry. No, we need a moment.
No
For
problem.
Dr. Bullbutter.
Oh, no,
No.
no problem. I got you. So anyway, they were
No, sorry. We just need a moment for Dr. Bullbutter. She says, listen, guys, I need to ask for a prayer. My mama or my friend's mama had a heart attack.
All right. Do you need me to pray? I'll pray online. I don't have a problem with that. Would you like me to, Dr. Bullbetter? Yes or no?
If anybody can just do a quick one for Dr. Bullbutter, please. Sarah would appreciate it. And I just wanted to quickly get that in there, and then we can
I'm
continue
sorry. I
on.
thought you were having a problem. Well, right
Oh.
now, and please, don't be offended, but I'm going to pray because I'm a chaplain and that's what I do. All right, Heavenly Father, you know the situation. What's her name? Type her name in real quick. Father, we ask that you surround this friend's mother right now with your healing touch. Guide the doctors, the nurses, the EMS, everybody involved. And Father, we ask that you bring peace to the family and that they'll have confidence in knowing that the doctors know what they're doing and are able to do this. And Lord, we ask that you just touch Linda, Father. Touch her. And we thank you in advance for her healing. We thank you for the medical technology. We thank you for the family that is there with her. And Lord, we just ask for a good outcome. In Jesus' name, amen. So please keep us posted. Just keep us posted. Not anyway, but back to the story real quick, but we'll keep posting. He literally was about ready to go get sick. And then I told him, well, guess what? His mother came in and I just met with her about an hour and a half ago. And he just sunk in his seat. I had him going for about 2 days before I told him we're keeping the money.
Oh my gosh. Oh. She's very welcome, Dr. Bullbutter. She appreciates you. Sorry, I don't mean to speak for you, Ada. I'm gonna go make some tea, but thank you.
No problem.
I'll be right back.
Yeah, we've had some really close. Photography is hard. People don't understand how hard it is because the expectations people have, they see these photos online and then they want you to recreate it. But the problem is you have a skinny couple, a bride and a groom and an engagement couple, and they're kind of doing the dip. Well, that's all fine and good. But when you have a groom that's 300 pounds and a bride that's over 200 pounds and they try to do the dip, it don't look so graceful. You still do it, but there's some things just ain't going to work out. You do it to make them happy, but yeah, not going to be good. What, baby girl? You can lay down. Come on over here, out from underneath my toesies. Thank you. Well, one thing about this channel, if we ever have some situation, I will pray, and if that makes you uncomfortable, mute it. I'll be praying for you too. Oh, anytime. Anytime. If we have like a tornado that's hitting the ground and I'm alive, I'm live on this channel and I'm still alive. I will drop it and pray. So that's just who I am. We all could use prayer. So don't be afraid to ask, especially in a situation like that where it's medical. Very much important and needed. But when we're having issues in the community, like when a certain ex-president got shot. You're welcome.
Yeah. And ADHD Jelly Bean, I'm not religious either, but I really appreciate that we all take care of each other around here. So each to their own, but you can take what works for you and leave the rest, right?
I'm not, see, and I want to explain something about me. Religious is, to me, a lot of people, I'm not religious. I'm not Baptist. I'm not Methodist. I'm not Catholic. I'm a Christian. I'm not stuck on the religion. I'm stuck on my personal relationship and my personal connection with God. But as a chaplain, I learned about all faiths, including Wiccan. And all of those, because if I am called as a firefighter to a accident scene and someone wants me to pray. Now, there's some things I won't pray, and it's one of them. But I need to know if you're Baptist, Methodist, Presbyterian, Episcopal, all of the other stuff, whatever it is. So I know how you pray, and that way you're comfortable with the prayer. So, yeah, I can give. It's interesting. I can give sacrament, meaning I can. In Catholics, the bread represents the body.
Yeah.
But they actually, once they bless it, Catholics believe that actually becomes a representation or becomes Christ.
The body of Christ, yeah.
Right. So a priest, I have some in a container, and the priest will bless it. I can administer that as if someone was on the way to the next level of life, but I cannot give the wine or what represents the blood because I'm female.
That's interesting. I did not know that was the connection there.
Catholic.
Interesting.
I'm not
Thank you.
Catholic. Yep.
I am. One of my best friends in high school was Catholic, so I did go to mass with her quite a bit and her family, and it's just interesting the stuff that you like pick up, and kind of things like that. So it's just
if you're not able to receive communion, you can go up and get a blessing. You just put your hands like this. A male chaplain could, yes, even if they're not Catholic, but I can't. I'm a woman. But I'm thinking, what about nuns?
Yeah, the Catholics. That is something that is quite central to their doctrine.
Yeah. Spirit-filled people don't speak in tongues over a Baptist or Church of Christ or other people. Yeah. You just, as a chaplain, you just have to know because you don't want to do anything that disrespects the other person. Well, they took the live down. They said they were going to come back at what time?
It said they were coming back at 1:30, I'm pretty sure, but I don't.
But
I guess
they
not.
all had that opening part. So
I'm 10 minutes, so 1:40, but that should have been still 15 minutes ago.
I'm going to stay on until 4:30. If they don't, then I'm going to get off. But we'll stay on for a little longer.
Okay.
I know, right. Well, I feel like a new woman since I got my nail. And do you know what my son said? Because I went up and scratched his head. He goes, "Oh, I'm glad you got your nails." My daughter, my pupper, my dog loves my nail, and my cat. You know, right between the shoulder blades, her head's facing me, and I just do this right between. She just hunches and rolls. Feels good.
Oh, interesting. See, I learn something new every day. Learn something new every day here, guys. Thank you.
That's right. I know a lot, but a lot of people, even people who are in the Catholic faith, have different way of explaining things and saying things. So I try to keep it as very neutral and basic as possible.
I just don't know a lot, so I learn. I sit and I listen because I have lots of random facts about silly things.
Catholic women can.
I thought that was interesting too.
Well, I have had one time a person was deceasing, and I knew the couple very, very well. And both of the husband and wife were in a nursing home. She had dementia. And he said, "Please, I do it. I want it. I don't care if you're man or woman." So I did, but one of the RNs was very uncomfortable with it and said I shouldn't have, reported me to the hospital chaplain, and the hospital chaplain said, "She doesn't work under me. She's not a part of my team. They asked her to come because they know her, and if he asked her to do it, it's none of your business." I was like,
Thank you for having your back. That's
some
nice.
people, yes, some people do, Andriel, but a lot of people usually that's mostly Catholic or that do that, but a lot of others don't. Oh, I know. A lot of kneeling and standing. You get your exercise. You get your exercise. But I does not offend me if we have, and I'll say it before I pray. I won't just drop it. So if y'all are there's somebody who just absolutely doesn't believe in it, doesn't want to be a part of it, can mute it. And when I bring my head up, you can put the sound back on. I normally sign when I pray, but I'm too close to the mic. I didn't want to move back. I learned at school allowed to do certain sacraments if an ordained priest is not available, especially like last rites. Yeah. I mean, I do all the last rite stuff. I just don't serve wine. I can do the Eucharist. That's the word I was looking for, Eucharist. But I don't, even though I have it with me.
That's the one thing that was really challenging about going to Catholic Mass and not being part of the Catholic faith. There are so many different words that you don't know. Holy crow. So I felt like I needed to go and get a dictionary afterwards. It took me a little while to figure out like some of what was going on because there are lots of words like Eucharist, and I'm like, huh? Because it's just not really something you hear outside of Mass.
No, you don't. And yeah, I do actually. I don't sing anymore, even though when I put my heart into it, I do still have a decent voice. But in church, when I can't hear the music, now I may know the song, but the key I know it in is probably different than what they're playing it in. So I sign all of my worship. I sign all of my worship. I I only sing here in the studio when with me and the mics are off, and the songs that I know, like CeCe Winan, I know what pitch she sings it in. So, and if I'm not on the same pitch, it doesn't matter. Except for if my son hears me, then he goes,
Well, you enjoy it, which makes it the best, right? Because that's part of singing, right?
well, I miss
Is you enjoying it.
I miss being able to sing. I miss a lot of the performance I used to perform. In Sweet Adelines, I used to sing in praise teams and choirs, and I've done shows, and I just can't do that anymore. And I watched a barbershop quartet thing the other day, and I was watching some of that, and it just was so hard. I just had to stop because I miss it. And then my favorite, of course, is country or gospel as well, and I can't do either. So signing is what I do. I do. So yeah, people just don't understand how much your hearing can take away from you. Yeah, the beginning, I've got the feed up. I am waiting. Um, well, it just popped up.
I want to give a shout out to Ronnie. I was having a hard day yesterday trying to function. Ada makes things like easy because she's doing like a whole bunch of different things at once, and I'm usually not. So Ronnie was just being nice to me, and I appreciate it.
Longer than 20 seconds.
I hear mouse.
It looks easy, doesn't it? It really does. But learning where to pull and how and right now, when I get this ATEM fixed, then I can have the presets done, and I can have things in different windows and just hit a button.
Okay, we are back on camera. Sorry for the
I do like the
disruption about that, but
I don't think
we're going forward now. Okay,
But I
Ms.
like
Taylor?
what you do.
Thank you. Your Honor, may I attempt to share my screen?
Yes.
By the way, Sneaky, you did fabulous, my dear.
Thank you. It was an
All right,
off day,
Dr.
but
Ellen, let's talk
Ronnie
about
makes it
community
easier.
attitude survey.
I need
What is that?
you to send me your ad.
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Is there a specific way you set up to do a survey?
Yes, of course.
Can you tell us about it?
Sure. So a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial Consultants, and also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample. Everybody has a known chance of being included. And the first section is a screener to assess to make sure people are jury eligible. So we have to live in the county, have a driver's license, or be registered to vote, be 18 and over, and so on. And then they're introduced to the survey. There's an introduction actually at the beginning, even before they answer a question, or they're told why they called. We're calling to get their opinions about an upcoming trial, and that their opinions are important because they were selected as a representative, household or whatever in the community. And then after they go through that screening process, they're instructed that there's no right or wrong answers to any of the questions. They can always report that they have no opinion or they don't know, and everything will remain anonymous. So the first few questions try to measures just basic criminal justice attitudes to get them familiar with the process, familiar with the survey, answering questions. And then they're introduced to the actual case, so the case recognition question. And then if they know about the case, they continue and are asked prejudgment questions, open-ended questions to assess some key opinions, then case knowledge questions, which are recognition questions. And then they go into the demographic section, which is how they consume media. And yeah.
You mentioned two organizations, and I think earlier you mentioned that you were regularly a member of those organizations. Do they help set standards for how surveys should take place?
They did.
And tell me a little bit more about the introduction. Why do you do that?
The first introduction or the instruction after that? They get through the scale screener.
The introduction and then the instruction.
Yeah, well, you're trying to encourage people to participate to increase response rates, right? So you're told again why you're calling. It's not a sales call. We're calling to get the opinions of people in your community and why. So it's not just random. So they understand it's about an upcoming trial. We don't tell them what trial because that would clearly lead to potential response bias. And they're encouraged to continue participating because they represent their community. They were selected randomly. And then there's efforts to increase response rates by we do callbacks. So everybody, each number is called up to 3 times at different times of the day. So if somebody maybe is at work, you still have a chance of being included in the survey. There's soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy, can you call me back? We try to find out when can we call you back so we can talk to them later, just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They're not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question, or I'm not going to answer that.
All right. So you did a community attitude survey in this case. Did you only look at Lake County?
No.
What counties did you look at?
So we looked at 4 different counties overall. So we looked at Ada County, Bannock County, Canyon County, and Layton.
Congratulate Mr. R.
I'm going to talk to you a little bit later about the 3 comparative counties. But for now, can you walk us through your high-level findings for Layton County and Ada County?
Sure. So I think high level, you can see case recognition is very high. And it's also high in Ada County. It's 93% there. It's almost everyone in Layton County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. So this is extremely high. They're pretty much the same. And it's not just a passing familiarity with the case. It's not that they recognize it but don't know much. You can see people in Layton County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at this slide and I look at the prejudgment, I'm guilty of murder, and am I using that term right? Prejudgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the prejudgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's 2 questions. One is, should the case be moved? Not where, it's should the case be moved? Has presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So second question is where? In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67%, 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So that's one variable you look at, but it's not just that. There's a host of other things. Extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors that play in. It's not just one item, it's the totality.
I am EDB's mini-me.
Totality of the findings, not just one question.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside. They're running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I think you're going a little too far, sir, by saying they locked their doors for the first time. Really? How many of you never, ever in your life locked your front door? I have a lot of respect for argument, but those kind of statements kind of make me go, no. Actually, it makes me feel like this. Wait a minute, maybe I am an EDB. I got the goat too. No, not. Here you go.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Latah County. And that correlates to the sampling of things you showed us a few moments ago, just your sample of what's out there on social media, on Netflix, and that sort of thing. Is that right? It's higher in Latah County?
It is higher in Latah County. Now, when you say correlates, like I didn't do a statistical analysis, I would say that's the stuff, the content out there. That's what it looks like if you just do a search and you're following it. And on the anxiety question, that number for Ada County is about 32%. So it's much lower.
Looking at this slide, what does it mean with these differences we're seeing in numbers?
Well, to me, again, it shows personal connection, the personal experience. In a big county, there might be a sensational crime, but you don't see people feeling that way. Because crime is unfortunately frequent, and they might be something else that captures their attention, or there's so much going on. It's not shocking. Here, this is something when people talk about, again, there's an idyllic community where everyone felt safe, and this person took it away from us. It was like shattering this sense of security and safety that we had. And everybody experienced it. And my guess is a lot of people can probably reflect on where they were when they learned this and how it impacted them personally. So it's very unique.
What are we looking at on this slide?
I think you skipped a slide.
how can you sit there and tell me you never locked a door? And
Okay.
girl, we gonna have a conversation about The Color Purple. Oh, that was a movie. And I didn't mean to do that, but I love that movie. I have always been a color purple girl with a touch of pink. Now, my bedroom from the age of 5 till I graduated high school was purple, no matter where we lived. Purple with a touch of pink. Now that I'm an adult, I would never paint my room purple. But my daughter's baby room was purple with a touch of pink. So if EDB, who's younger than me by almost 10 years, I don't know, but she's in her 40s. I'm in my 50s. I'm going to have to say she's copying me.
I like this Andrel. She's the Cali girl, you're Texas girl. It's like Cal-Mex and Tex-Mex. Tex-Mex is more authentic. I just like Tex-Mex.
Get a lip gloss on for this one, honey. She's now from Tennessee, living in Tennessee. I was born in Tennessee. I lived in Cali.
True enough.
I grew up in Cali for a few years. And then, so, Ronnie, I'm just being silly. I have utmost respect for that woman, and I think she's a genius and brilliant. And I love the fact that she owns her shit and that she knows where her limits, i.e., her neurodivergency and her dyslexia. And it made me feel comfortable coming here. If it wasn't for her openness, I wouldn't be here as a deaf woman with dyslexia.
Mm-hmm.
So I love her. I'm just giving
she's a force.
NDL crap.
Is this one that starts with lived or know someone who lived?
Yes.
Okay. So again, this comes back to personal connections. So 78% of survey respondents either lived or know someone who lived in Moscow when the murders occurred, compared to 20% in Ada County. And that's not surprising because if you look at the size of Latah County, it's about 32,500 people over the age of 18, compared to about 406,000 in Ada County. And I think it's like 66% of Latah County is in Moscow, so it's a huge percentage. So it's not shocking that people were here or know somebody who was here heard. And a large number of people are students or employees of the university. It's a quarter of the sample. I ran across one citation where it was like 36%, so it's even higher, much lower in Ada County. And you can see 40% of people have visited a home or walked by it where this crime occurred. And again, if you look at some of the opens, somebody talks about seeing the house from their office window. So it's a constant reminder of this awful thing that happened. These are things, again, that jurors coming into that courtroom will see. It's like, you know, indicators in the community of what impacted them. People may be fearful of, you know, people know they're on the jury and all those things because it's such a small community and people are so invested. And you can see that 22% of the respondents actually work or know someone who worked for a law enforcement agency involved in the investigation. 22% compared to just 4% in Ada County. So again, direct connections to this case.
And those direct connections, those are things that Latah County juror would bring in. Is that right?
Yes, and that's where we see these big differences in national cases like this. This is typically what you see when the entire state is saturated with coverage. Everybody's going to know about it and have opinions to some degree, but it doesn't necessarily have personal connection. That's why cases like the Oklahoma City bombing case was moved. I mean, that was a national case. Everybody knew about it, but they still moved it because of the personal connections.
Now advance to the slide. What are we seeing on this slide?
Well, this goes back to case knowledge. So we talked earlier in the day about how case knowledge and impacts prejudgment and how we have this belief perseverance. So people develop these more complex schema and case knowledge. They're more resistant to change. And you can see almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey, almost 80%, and 52% knew 7 out of the 9, or at least 7 of those items. So they have a lot of case knowledge here. It's quite high.
While we're here, I'm talking about the media items. Did you test on every media item you could find?
No.
Did you have to select a certain number so that you could do the survey?
What I do is I read all of the media coverage that is local, those local newspapers, and I'm pulling items that stand out, that are repeated quite a bit. So there's like multiple references to certain things and things that are inadmissible, prejudicial, things that are likely to create bias and have an impact.
All right. I want to talk a little bit.
Okay, none your business. I am not dissing EDB in any way, shape, or form. People are dissing me because look at me right now. On other live streams, I know we're going to move on from EDB, but other live streams, I've had people leave comments that I am trying to copy her and to ride her coattails of fame, so to speak, and cash in, and using sign language as my niche to do so. And I love EDB, and if she ever popped on this channel, I would crap diamonds. That woman to me is what everybody should model themselves after when it comes to the ethics of running a YouTube channel. And I watch her all the time. I mean, I may be on all day, but at night I'm laying in bed watching EDB and Rob and Ian and RA and Law and Lumber, and I love them all. And there is no way on God's green earth would I ever be negative to her. People have accused me of trying to be her, and I have been a little sensitive about it because I never thought about the fact that I wore black all the time, that I have black hats. I have other hats that I beaded the rims on, but she's amazing. And let's see, I have heard the problem with her channel is that chat. I never heard anyone diss EDB. I saw her many times. Yeah, I know. Not everybody's everybody's cup of tea, and she has fabulous mobs like I do, and they keep things out of chat. There is a slight delay from when I stream to when you guys get it. And the chats who are actually in my live with me and watching can get a few second heads up. But just understand that I am getting a little tired of the messages. And when I go back and watch, you know how once this shuts down, the people, what do they call rewatchers or replay crews or whatever?
Replay crew or rewatch crew or whatever they call them.
Yeah. I have popped up messages on my phone and people have been really mean to me about how I look. My face, I mean, we do have a similar shaped face. I'm looking at her and look at me. If I had her glasses and her hair, we could be family. Heck, we even got our noses are almost the same, but she's more flat bridged. I got a button nose. But I just want to thank EDB for everything she's done. And I'm wearing glasses today. Oh, this is the first time I've ever done this, right? I'm wearing them because I'm fighting a migraine. And right now it's at a low roar, but if I stay under this light, it's going to be a bad roar. So just everybody know that I wasn't making fun of her. I was more making fun of myself. I wear black because it looks best with blonde hair. Yeah. And I wear black all the time because I have a wardrobe black and I'm not made of money. And EDB with her husband and all the hard work he's put in and she puts in have a lot more money than I do. I live on a very meager means, even though I don't look like it, but I do. And I can't afford to go change my wardrobe. And I like black. It's very slimming. And I don't have to worry about matching.
Hi,
So,
Eddie. Thanks for joining us. Oh, sorry. Go ahead. Oh, I was just saying thanks for joining us, Eddie. Please continue, Ada.
Hi, Eddie. But just know that that she, out of all of them, if someone said you can meet or talk with them today, it would be EDB, because she has a fabulous little thing that most people don't know she has about what you should do when you do what I do and do what she's doing. And I've watched every one of those videos, and I've got a question, but she's simply amazing. And if EDB ever sees me, I hope she knows that utmost respect and honor to that woman. She's paved the way for people like me.
Hi, EDB.
Hi, EDB. And I can handle cyber bullies. I mean, I got thick skin, but sometimes you have to wear sunglasses inside. And those of you who suffer like I do from certain medical conditions, another one is intracranial hypertension, and I have a fan on, and it's blowing and hitting my eyes. I have a little pressure behind my eyes. It hurts, along with the migraine. So, love her. So I hope that clears up for anybody who thinks I was dishing on her, because I was not. I was making fun of myself. On to the next show.
Bit more about how you set up the survey. What are we seeing?
So this should kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper, on TV, to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's the recommendation, again, in the ASTC professional guidelines. We usually pick up 1 to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information questions?
Yes, it's actually even deeper. So you get the introduction. First, you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right or wrong answers. You can always say, I don't know. I can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information, and now I think he's guilty because you just told me he confessed, or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey is designed that way?
Yes.
All right, let's talk about some of the survey results. Walk us through what we're seeing here.
Okay, so again, the data suggests that this case has captured the community's attention. This is not a case where people have moved on. Almost everyone in the community recognizes this case. You're at 98% recognition rate. And it's not just a passive familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
All right, what are we seeing on this slide?
So this is one of the ways we test the validity of our survey. So we talked again, when we talk about the research, we know that people who closely follow a case, people who have a lot of case knowledge, are more likely to believe a defendant is guilty. So one of the things we would expect is to find a similar relationship in our survey, which indicates validity. So, and that's what we find. So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely, within that group, the guilt rate is 84%, and somewhat closely it's 73%. Just kind of looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant's guilty of murder. So the more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to have an opinion.
All right, what did you learn about prospective jurors who are talking to each other?
So one is the fact they are talking to each other, and we don't always see that. Sometimes that's 40%, 50%, or even less in terms of talking about a specific case. And you can see here, it's almost everyone. 88% of people who know about the case have talked about it either in person or online. That's quite high. And they're following it, seeing things on social media. They're watching, Netflix episodes or Paramount or whatever was on. They're seeing shows. They're seeing it in their news feeds. They're closely talking about it. In a small community, that's how information gets spread. It's what we call this informal communication network.
Did you have an opportunity in your survey to learn more about different rumors and things that are going around in Utah County?
I did. So we asked an open-ended question after the prejudgment question, and then it should be what they know about the case and their opinion. And we asked what rumors or theories they've heard in the community to see if they're regurgitating some of the stuff that's been in the newspaper, on social media, the idea, again, of informal communication networks. In smaller communities, you tend to get a lot of like, well, I knew somebody who knew this person, or personal connections, and information gets spread that way. And that's what we saw here. There's a lot of references to things like, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder on a paper, or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made and from years back, all that kind of stuff. And then references to him, having obsession with some of the victims, ritual animal killings. And these are just a couple examples. Like you'll see that stuff everywhere, but the amount you see in Latah County is much higher. Like, if you go through comments in Ada County, you'll find some too. You can find examples, and I'm sure if you go to Bannock and Canyon, you're going to see them because the case has gotten so much attention, but not to the degree you have here. And given the size of the community, it's much more significant.
Did you record and document all of these comments in the actual survey report?
Yes.
Okay. And that's something that we provided to the court, and the state has no objection, so the court can read the full scope of the rumors from Latah County residents on his own time, I guess.
Yes.
Thank you.
Some fun light reading.
All right. What did you learn about Latah County residents that were related to Moscow, specific Moscow connections?
Well, this is kind of the unique nature of this too, that I see in cases like natural disasters, like wildfires is a good example, where it's this like collective trauma everybody goes through. So you can see 76% of residents here lived or knew someone who lived in Moscow at the time of the murders. So they either are here, the loved one is here, and creates anxiety, right? So I think it was like almost 40% of students left during Thanksgiving, didn't come back because they were scared for their safety. And you see that in the other questions. So asking,
how does that equate to fires? Dude, I'm a firefighter. What the hell are you talking about? I'm trying. But I don't get that. Did you make that connection? I ought to look up at you like this, like they do in the Brady Bunch. Did you get the connection? I'm like, what you talking about, Willis? I don't get the connection.
Don't get it. No.
You reaching, dude. You reaching hard. Anybody else thought that was, Yeah, no.
About if people experience stress, anxiety, or fear during that search. And you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a crosstab. And the question is, did you or someone you know? It jumps up to 63%. So a large percentage of people were anxious and scared about their own personal safety or the safety of someone they know and care about.
Tell me about the open question. about people's sense of security? Did people respond to that?
So one of the questions we ask is, how did this crime impact your community? And if I do this in a big county and I ask this, or big venue, federal case, you get a lot of, it didn't, or not much, or, I didn't live near it, so not me, or something like that. You get a lot of that. And I'm sure there's some of that here too. If you look at different venues, Ada County probably has a lot of that, and Bannock. What really stood out to me was this shattering our sense of innocence, right? This is an innocent town and no crimes or horrible things ever happened here. And this guy took it away from us. We had this idyllic, safe community, and this person destroyed it. This crime destroyed it. And they talk about people, they never locked their cars before, their homes. I think one person said, he didn't even have a house to his key when he bought it, or a key to his house. That makes more sense.
Excuse me?
And suddenly people are locking doors because they're fearful. People are scared.
I'm sorry, I call BS. You did not have a key to your house when you bought it?
How much bullshit are we going to take today? I am going to go EDB. This is bullshit. Here we go, y'all. You're seeing it. This was bullshit. How much bullshit are you handling out today? Y'all.
Interesting.
I'm trying to be careful. I'm trying to be careful.
The waft of something funky this way comes. Smells like crap.
Y'all.
You're seeing a whole bunch of funny faces on this stream because I can't handle some of the phrases and sentences I'm hearing.
There's so much bullshit that if we wait 2 weeks, we'll have a cow chipping contest like never before. If you don't know what a cow chipping contest is, when you go collect all the dried bull crap, and they're about like patties, like a Frisbee. And when it's dry, you sling it like a Frisbee and see how far you can get it. Yeah.
It's a fun game.
Yeah. Just make sure you have your kids wash their hands before they eat. Because usually it's at the local fish fry or somewhere outside. You're in the 4th of July.
Mm-hmm.
Oh my gosh, y'all. I'm perplexed. I'm
gonna keep listening to this, but I'm gonna go run around and do some chores because I don't think anybody else is gonna handle my funny faces.
I love your funny faces. What are you talking about, Willie? What you talking about, Willie?
I told Braxton one time, I'm like, if I had a channel, it would just be an autistic woman making funny faces and things. I'm just like,
I could be. I don't know if I am. Never been tested, but I'm making some pretty funny faces.
It's funny because, honestly, I can't handle some of my reactions, but every once in a while you just hear something out of one of these experts, and he's actually quite a smart man, but this is not the smartest I've heard him.
If he was my lawyer, we'd be having a problem. Abizer, I need your attention, please. Attention. We're having a problem. Okay, love. I'll keep playing it.
See you guys later. I'll be back for more ridiculousness in a bit.
This is getting
scared to go to their cars. Again, someone mentioned you could see the house from their office, and students and staff would run to their car to be safe. People's partners were scared to go to the grocery store, and there were tons of comments about that. This idea that we have a safe community and it's never going to be the same. It's lost. It's like our sense of safety and security. This special place, this tiny little place that's a bubble from all the bad stuff in the world, and then this thing happened.
the comments that you've depicted in this slide, is that all of them, or are there others for the court to take a look at?
There's plenty. On top of reading the other stuff, feel free to read all those opens.
Okay. What about the connection to the house where this happened? What did we learn?
Well, I think it's comes to like, again, this like direct and indirect connections to this case, which makes it unique in Latah County, which you don't see everywhere, is, 40% of residents who know about the case, which is pretty much everyone, have either visited the home where the crime occurred or walked by. And so there is this constant reminder of this awful thing, their daily lives. And also you see a large percentage of people are students or employees at the university, or connected to it, the investigation itself. 22% were connected to the criminal investigation. And then 25% were either students or employees of the university. And we know, if you look at it, like the university is a big employer in this community. And when all of these students leave, it has an impact on the economy. Over 60% of the county is made up of people who live in Moscow. And if you look at some of the data, it indicates about 36% of people in this county are either students or employees at the university. So even higher than we saw in the survey.
All right. I want to talk about the prejudgment question. What did you learn?
So this question is one of the indicators of undermining the presumption of innocence. So I look at it, I'm always looking, when I think about due process, is the presumption of innocence. And you see when it shifts to a presumption of guilt. So in this case, 67% of prospective jurors who recognize the case believe Bryan Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during voir dire, 66% of them already think he's guilty before they've heard any evidence.
And that's just the prejudgment question. That's not talking about the other factors that you talked about, media awareness, case connection to the community, things like that.
No, that's just looking at everyone. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever. So that's just looking at the entire set. Start looking at other things, that prejudgment gets even higher.
You've talked about what you've defined as a fixed opinion or a fixed presumption of guilt. What did you find about that?
Yes. So the question I ask is basically based off, I'm going to start talking circuit now. Based off of what you've read, seen, or heard, would the defendant have a difficult time convincing you that he's not guilty? So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, what do you know about the case? And they would tell them some information or minimize what they know. And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing you that he's not guilty? And they, oh yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with these other indicators of bias. So it seems to be more of a valid question. And when they did it, you see basically 51% indicated a strong opinion that we shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair because I see it all the time. But this doesn't mean they can't. We heard a lot about that earlier today. Yeah.
All right. And did you ask similar questions, prejudgment for guilt, I guess prejudgment for the sentence?
Yes. So because this is a capital case, I did ask whether or not which sentence do they believe the jury should select if he's convicted. And you can see 52% reported that he should get the death penalty based off of what they've read, seen, or heard, whereas just 23.5 or 24% reported that he should get life.
Did you ask a fixed question about the penalty?
Yes. So I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death and that he couldn't convince them that it should be life. Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
This is a small community. What did you learn about the impact of this case on this small community and the pressure of a juror in Latah County to do this?
So one of the things I wanted to look at, because it's a small community and people know everyone, and the pressure when coming in and out of this courthouse on a day-to-day basis, when it's been inundated with journalists, and my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that. Is there pressure? Do the jurors ever feel pressure that there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments and a range of themes from people would basically kill him to they burn the courthouse down or assume that the jury failed or that he would have to prove that he was not guilty. Again, shifting the burden. So it's like, I can't imagine that happening because they have so much evidence against him. We would be dumbfounded. Like how could he not be guilty given the amount of evidence? Several would be on the hunt for him to make sure he gets what's coming to him. And then just emotional stuff about it would be devastating to the community. Other people talked about the fear if he didn't do it, well, who did? Like that means this person's still among us who creates the same stress and fear and anxiety that people had before. So this community needs closure. And you have to imagine what that's like for a jury from months on end, in and out of this courtroom in this tiny community and trying to explain to their neighbors, what they did and why. And that shifts the burden again back onto the defendants.
The comments that you've captured in this PowerPoint slide, is this all?
Yeah, these are just a few examples.
Plenty more for the court to read?
Yeah.
Did you ask these open questions in the comparative counties too?
Yes, it's the same question as in all the counties.
Were the other counties as high of rate in these kinds of answers? Did they have a similar kind of answer as Latah County potential jurors did?
No. And now you can read through it and you will find answers that people would be angry and upset because you're talking to hundreds of people and you're going to get those. But they're much less strong. They're much more, no opinion. They wouldn't have an impact, things like that than you see in other places. Very few people in Latah County have that.
All right. I think we have a couple of slides on the questions that were in the survey. I think we know those.
Yes. So these are our case recognition questions, we call them, or I call them recognition items, I guess. So we do ask an open-ended question. What have you read, seen, or heard about the case? We'll get into that, but that's the typical question you ask in jury selection. And people answer that, but they often use minimization language or unable to recall everything. So we ask later on these case recognition items to see if they're familiar with widely reported media items. And if you look at the professional guidelines, this is what's recommended. So we first ask an open-ended question, and then later you follow up with these closed-ended questions.
What did you learn when you did that in this survey with Latah County?
So I'm not going to go through all of them, but we learned that people are familiar with many items that have been widely reported in the media. And you don't always see that. Sometimes case recognition is high, but people don't know a lot of detail. Maybe they know a few items or recognition rates are 40, 50%. But what we found here are people have well-developed attitudes and opinions and have been recall a lot of prejudicial content. So in Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right? 9.
Yeah, up to 9.
And I think you mentioned, but I think your chart's going to explain to me why more media recognition items correlate with the prejudgment question of guilt.
Yeah, and this goes back to validity of the survey. Right? We know from earlier research that case knowledge is correlated with prejudgment, and that's exactly what we found. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to have developed a perception of guilt. So people who are familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call it that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested, and you can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. And you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he would have a difficult time convincing them otherwise.
What about another media item?
What about what?
Another media item?
So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match for the defendant. And you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail. And 82% of those who do know that believe he's guilty. Quite high.
How about the cell phone tower media item?
So on that one, you see a case recognition rate or item recognition rate of 79%. 79% of survey respondents knew that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media item stories?
So this would go down to like a misinformation, I'll call it an inaccurate detail that was widely reported, that the defendant had stalked one of the victims. And you can see recognition rate currently at 45% when the survey was done. And 81% of people who knew that detail reported that he's guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media. 45% recognition rate, and 79% of those who know that believe he's guilty. And these are all statistically significant findings.
Let's talk about some of the comparative counties that you surveyed, and if you can give me a high level of your key findings in those counties.
Sure. So now, in my mind, this shows significant bias, that there's a reasonable likelihood that the due process has been undermined in the sense that there's a presumption of guilt in this county. And the question is, if you were to move it, where would you move it? That's the question 2.
We're on to the second part.
We're on to the second part now. That's where this comes from. So you'll see recognition rates are high in these 3 counties we tested. So we tested Ada County because it's the biggest county in the state. It's about 406,000 people over the age of 18, and other high-profile cases have been moved there before recently. Canyon County we picked because I believe it's the 2nd largest county, and it is also near Ada County. So it's a big county. We picked that, and we picked Bannock County because it's just far away, and it had less media coverage. So we wanted to see if there was a possibility that people would have less case knowledge there. And you can see recognition rates vary from 90% to from 84% to 93% across those 3 cases. And you can see that in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher. The guilt rates are essentially the same, or it's a little higher in Bannock County. But because of the population size, there's a big difference. So again, you'll find about 16 times more people in Ada County who have not prejudged compared to here. And then similar in terms of the strength of opinion and difficulty in convincing them that he's not guilty, similar to what you see here. And sentence similar as well. So you're in the 49 to 57%. So these numbers are also high.
Where do you start to see differences that matter?
You start to see differences when you talk about personal connection. That's where the big differences come up. So remember we said 79% of people in Ada County had talked about this case. Might be wrong, might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Bannock. So it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other two counties, it's only 11%. It was 39% in county here. And then whether or not they know someone who experienced higher levels of stress, we had 45% here. Here we're down to 24, 19, and 19. So you see big differences there in terms of the community connection, the personal connection, their case.
What about the connections to Moscow that are unique to this area?
Yes, so just 20% in Ada County know someone who lived in Moscow. 15% in Canyon and 16% in Bannock, 78% in Latah County. Whether or not they were a student or employee in Latah County, that was 25%, and we're looking at 4% and 3%, much lower. Whether they visited the home or saw it, Latah County is 40%. Here we're down to 8%, 3%, 2%, much lower. Whether or not they knew someone who actually was involved in the investigation, in Latah County, that number was 22%, I believe. And in Ada County, it's just 4, Canyon it's 2, Bannock it's 2. So much lower when it comes to those type of connections, the personal connection, personal investment in the case.
What about the recognition of media items?
Yeah, so we had, I think it was 79% in Latah County knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Bannock. If they knew 7 or more, that was 52% in Latah County. It's just 42% in Ada, 27% in Canyon, and 29% in Bannock. So less case knowledge. And we know case knowledge comes back to belief perseverance, right? So the more you know, the more resistant your attitudes are to change, the more likely you are to attend to and process information consistent with what we know. New information about the DNA evidence, I already know about that. That's credible, I give that weight. So you're much more likely to see that in Latah County.
Y'all, I
all right.
As they say, for shit, giggles, and grins, I would love it to be in Ada County because it's my name. But y'all, the thousands upon thousands upon $1,000 they have spent today for this is really driving me nuts.
I think you told us a little bit about the population size. And is that why you selected Ada was the population size?
So I'm not selecting anything. I'm just pointing out some possibilities. So I selected Ada County in terms of to do the survey because it's the largest county in the state. And, you know, it was the Daybell case was moved there. So you know that they can take this case in. We know large counties, it's less of a big deal when the case moves there. It doesn't become the biggest story in that community. So I wanted to test Latah County. Pick Canyon because it's the second largest county, over 184,000 people. And then I picked Bannock because it's further away. It's quite far away, hundreds of miles from here, and it's in a different media zone. It does have some of the similarities of Latah County. So for example, there's a university there that's the second largest employer. So there's a risk there. About 18% of the population is connected to that university. So there are those risks. And I think the problem there, while some of the numbers are good, or it'll become a huge deal if that case is moved there. You're gonna have the media circus move from here to there, and it's gonna become, again, a huge story in that community. So there is risk if you choose a smaller venue that something like that. Wow.
And that risk is tied specifically to the size of Bannock County?
Yes, smaller counties, you don't have stories like this regularly happening. So it's more likely to become a big deal in that county. And you could end up with significant bias between the time the case is moved and the time it goes to trial. because there might be an increase in media coverage there.
When we talk about the survey itself, was it only people who knew about the case that took the survey?
No. Explain to me what you mean by that.
Well, I'm looking at your slide here about people who, whether or not they know about the case, do they finish the survey? I think one of the things the state's criticized about is a non-response bias. So I want to understand if you can tell if that about how the survey works, this one and others.
Right. So first of all, one thing we do is we do comparison surveys in a host of different cases. So if you look at other cases we've done this on, if that were true, you would find that only people who know about the case take the survey in the comparison county as well, right? So you can see in Renfro, this was an Idaho case, in Kootenai County, 89% of survey respondents recognized the case that took the survey, that completed it. In Ada County, 67% of the people that completed the survey did not know about the case. So you would expect you wouldn't see that trend if people just say, oh, I don't know about this, I'm not going to take the survey, I have no opinion. In state of Tennessee, v. Andrew Delkey, similar findings. So in Davidson County, 67% of the people who completed the survey knew about the case. In Hamilton County, 84% of people who completed the survey did not know anything about the case. In United States v. James Cloud, which was in Washington, you can look at, we did 3 venues, and in Yakima, 55% of the people that completed the survey knew about the case. In Richland, 82% did not know about the case. In Spokane, 90% did not know about the case. What's unique and why you see high recognition rates across the surveys here is because it's a national case. And when we have national cases, you see high recognition rates all over. So this last one, the state of Minnesota v. Alexander King, was the George Floyd case. And you can see high recognition rates in all the counties, just like we see here. The reason is because there's a lot of media exposure everywhere. But it's not that people are hanging up because they don't want to take the survey. In fact, if you look at the call data, after they were told the case recognition question and described the case, only one person hung up out of the 1,200 people that completed the survey. We had one person who terminated the survey after being told what the survey was about. Everyone else.
All 4 counties?
All 4 counties, one person.
All right. We have talked quite a bit about the bias and the prejudicial media coverage and the difficulty, the impossibility that will have in seating a jury in Latah County. I want to talk a little bit about jury selection in cases that have a lot of publicity. Are you familiar with that?
Sure, yes.
All right. Why should we talk about this now? Why do we not want to just wait and try to pick a jury first?
Well, I think first of all, I've done a lot of jury selections. I'm sure you have, Your Honor, you have, I'm sure you all have. So we all know how the jury selection process works. So in a normal case, people do not have case-specific attitudes. And we know specific attitudes are predictive of behavior. So I might just have a general passing attitude towards something. I mentioned DUI, or it's like a contract dispute. Like, you can ask me questions. I don't have strong opinions. I don't know anything about the case. So they're not specific attitudes. So jury selection is effective in that scenario. It's fine. But when people have case-specific attitudes and case-specific knowledge, and I've heard information and evidence, even if it's coming into trial, I've heard it in the context of a news story. There's no rules of evidence that were applied. There was no cross-examination. There was no counter expert to refute what was said. It was just said by a public, speaker. He was on an editorial on a television station, on Nancy Grace. So it's very different. And then when I hear it as evidence, it's just confirming what I already know. It's not new, not processing it for the first time. So that's one of the big problems. So why you need to identify people that have that content and information. And there's challenges because of the way memory works. Recall is limited, and we'll get to that. But when you ask people, what do you know about the case? They are not able to give a full account of everything they know. So it's very hard to assess what people know, which makes it very difficult to exercise cause challenges and predicate challenges. And the other thing is just the nature of change or of jury selection. It's very easy to rehabilitate a juror to get them to say they can be fair. It happens all the time. So a juror says that I had this experience, or I think I'm leaning towards one side, and it's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. Give leading questions. In one study, they actually analyzed a transcript or 3 trials transcripts, and it was like 60% of the comments during voir dire were from attorneys and judges. Just 40% were from jurors, and 63% of the comments from jurors were one-word answers. And I see that in the post-conviction stuff I do when I analyze transcripts. It's 3 pages of indoctrination into what a juror is supposed to do, ending with a closed-ended answer, can you set it aside? That's not an indicator of their ability to do that. People can't just men in black flash sheeping themselves and forget everything. It doesn't work that way.
I think we may have covered voir dire and honest disclosure with that, and I didn't advance the slide. Can you give us a case example or an example of this?
Sure. So this is an example of a stealth juror. So a case like this, you're a stealth juror, there's a likelihood that people want to be on this case, right? It's a high profile case. It's going to be on TV. You're going to get a lot of attention. There might be a desire to seek justice and you want to be involved in that. Well, how do you identify jurors like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division, Rampart. And basically there were a number of corrupt police officers who were stealing drugs out of the evidence locker, shooting suspects and planting guns on them. It was these rogue police officers. And one of the people, his last name was Ovando, he had been shot by a police officer, this guy Perez, who planted a gun on him and alleged that Ovando had shot at him. So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of a locker room. So he confessed to all these things and Ovando was released. He got like a $20 million settlement against LA County. Then he sued the public defender, claiming that, they should have figured this whole thing out and known that, there was this scandal and so on. And it won like $6 million in that case. And then later when they looked, it turned out that one of the jurors on that case had been in a movie about the incident called Gang Wars. And when they were asked, has anybody have a connection to the case? She didn't raise her hand. But during the deliberations, she talked about stuff she knew. She talked about stuff that didn't come into trial, and it resulted in a mistrial. So that's just one example. There's other examples as well. But yeah, so that's one challenge you have in a case like that.
All right, recall and recognition. I think you're going to talk to us about how hard it is to ferret out what somebody
I bet this judge is like, hurry
So
up,
to me,
it's done.
this is one of the biggest challenges
I'm gonna up
in
speed.
high-profile cases. So the question you ask on the juror questionnaire and open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is, on the spot, I need to search my memory and see what's accessible and salient and what I can remember on the spot. And I'll tell you. And that's and then you usually follow it up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I ask you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high profile cases that are not a problem in your run-of-the-mill typical case.
Have you seen that bear itself out in a real case?
I have. This was a case in Texas where we actually had community members come in during the venue hearing and treated them like mock jurors in a sense, and asked them what they knew about the case, and they told us. It was a big case at the time in Hidalgo County in Texas. And people told us what they knew, and then we asked, "Is that everything you know?" And they'd say, "Yes, that's it." And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, "Well, did you know that he allegedly confessed?" And then it would stimulate a memory, and the person would say, "Oh yeah, I did know that. He actually confessed twice at a monastery." So it triggered a memory. And then it was, "Well, is that everything else you know? Do you know anything else?" And they say, "No, that's it." And say, "Well, did you ever hear that he had committed another crime?" And they say, "Oh yeah, that's right. He actually attacked another girl at a different church in a nearby town." And it was, "Well, is that everything you know? Take your time, search your memory." That's it. And then we do it again. And it was, "Well, did you know there was a cover up?" "Oh yeah, the Catholic Church covered it up, and the police department." And it just demonstrated the problem. Now, that was fine in that little demonstration we did, but you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial when you don't know what they know.
Do we have a glimpse of how that works in Bryan Kohberger's case based on the search warrant?
We do.
All right. How do we know? Tell me about that.
So we always use the open-ended question. What have you seen or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items, to see if there's additional items that they actually recognize that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, "What have you seen or heard about this case?" Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific detail. But later when we asked those closed-ended questions, that person knew all 9 of them. Another one is just what I've read and seen on the news and newspapers. Again, knew all 9. Read articles about the case, knew 8 of the 9. Just what I read in the papers, same as everyone else, 7 of the 9. So these are just a few examples, but this is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well developed schema and attitudes and case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that had not reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognize this item when we ask, "Have you seen or heard it?" But when we asked the open-ended question, "What have you seen or heard about this case?" only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognize it later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, "Did you know that Bryan Kohberger allegedly stalked the victim?" So that's a difficult position to be in.
Let's look at one more example of how that works.
So this is the one about the knife sheet, whether or not police found a knife sheet on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, "What have you seen or heard about the case?" very few people mention it. This is what you see.
All right.
I don't know where he's going.
That's a question. Can you set it aside and be fair and impartial? Is that going?
I think part of the question, and they could so simplify this. I don't know why people, other than the longer he's on the stand, the more money he makes. It's simple. When we fill out a questionnaire, sometimes it doesn't trigger a memory. Then when you're sitting in trial and you hear something, you're going, oh, yeah, I heard about that. And it triggered your memory of what you heard. And that's a risk you take with anyone on a jury and any trial. But if the jurors are honest, they will only consider evidence that was brought forth in trial. Doesn't matter if what you heard is brought in or not. If it wasn't brought into trial, you can't use it. Oh, that's such a waste of money.
Work. I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help
Will
us?
it work? What does work mean? I don't know if you think that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And it's not, there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders. For his wife, he went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this miniseries on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, of course I shot them all, or of course I
We
killed
only
them
have
all.
about
He's talking to
4
himself.
minutes of it.
So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, this is the true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested. So if somebody said this in public about this case, I think we all agree that person probably can't be fair. You're publicly stating it to the world. You think he's a sociopath. So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we recruited said that he could not change their mind about his guilt. So almost everybody. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. That he was like a suspect in his wife's disappearance. Probably not admissible in a different case. His murder trial in Texas. We asked several of these, and the confession, the captured confession, because he 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, I cannot be fair and impartial. There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence. Common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change their mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why. And so this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Durst was a sociopath. Well, they, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated as a fair and impartial juror, which demonstrates like a person like that should be answering that question no, but they don't. And even kind of going back to the Rideau case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that throughout the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair. And the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
All right. Based on your years of experience, your education, all of the work that you do in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments, do you have an opinion about this case and whether we can seek an impartial jury in Latah County?
I do.
What is your opinion?
So my opinion, again, is based on whether or not there's a reasonable likelihood of using that standard, which is less than the preponderance of the evidence. Latah County is a small venue, and the crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrate they experience fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convict. I think given the reaction that people think the community would have if he's acquitted, that's particularly concerning. We know from the data that jurors have closely followed the case, they've talked about it, they're familiar with prejudicial details. I think that the presumption of innocence has been undermined and presumption of guilt prevails in this community. And I think that pre-existing attitudes and opinions will influence how people process evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence, I don't know about the videos, versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter that is consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy, given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor. And Dr. Edelman can kind of use the statement.
Okay, thank you, Ms. Taylor. So this would be a good time to take a break. And we'll come back at 3:20. Thank you. Dr. Edelman.
Okay, they're going to take a break. And we are going to hop over here. And we are going to listen. I have not heard it. I can't wait to hear it. But it's going to be the jail call for Wade Wilson after. I think it was yesterday. We'll see.
Part of the process of our case is we've been requesting and reviewing his emails and phone calls to all of these women. And maybe a lot of these women don't realize, but all of this is public record. So their names, their emails, where they work, the photos they sent, all of that is public.
Hello, this is a prepaid call from.
Once again, this just hit.
An inmate at the Lee County Jail. To accept this call, press 0. To refuse this call, your current balance is $16.13.
Rich.
This telephone call may be monitored or recorded. Thank you for using GTL.
What's happening, babe?
Oh, that thing.
What's up?
Hey, what's up? Are you busy right now?
Yeah, trying to teach people how to cook because they're ruining my food.
Nah, they're burning it.
No, they add too much water and make that shit like piss.
Oh, make it soupy? Like real soupy and shit?
Yeah.
What are you making? What are you making?
It's one of those easy meals in a bag, man. All you gotta do is put the sauce in the goddamn pan. The kid wants to still fuck it up.
Nah.
I'm like, what the fuck? It's like easy to read, bro. Like,
Yeah,
but you can't read? Like, you're not English or something? What the fuck?
The directions
Yeah, the
are like
directions are right
1, 2,
on the
3.
goddamn bag. Yeah, it's white people's food. It's not anything hard to do. It's right out the bag. The sauce comes with it frozen. Like, all you gotta do is defrost the sauce, put that shit in there.
Oh.
And you still fuck it up.
No, man. No shit. Did I call back at like a decent time though? Or what?
Yeah, you did. Yeah,
good?
you called back at a decent
Did
time.
I?
Yeah, I'm straight.
Okay.
Well, my boy's here. My brother. He's like my brother. Yeah, my boy's here with his girlfriend cutting my son's hair.
Oh yeah. Oh, he's getting a haircut.
Mhm.
Yeah. Yeah. Did you get my message that I sent to you?
Yeah, send me.
I did.
How much you have?
Good.
for
You
my-
get all my messages, right?
I do.
You do?
I do
You
get
got
all
the
your
little-
messages.
You got the little notification thing on your phone?
I told
where
you,
it's
it goes ding, ding.
Yeah, you
It tells me that smart jail mail came in. Smart jail mail. Smart jail mail.
Hey, what were you? Hey, what were you doing? What were you doing awake at 4 o'clock this morning? What were you doing? You sent me a message.
Why are you investigating me now, Mr. Wilson?
Yeah,
Mr. Wilson?
no, I'm not. I think I'm the last person to do that, but
No, actually,
I'm
I
the last
couldn't
person to
sleep.
do it.
Hey, the door's
Yeah.
open. The AC's coming outside. We live in a fucking barn. I sound like my fucking father. Jesus Christ.
Yeah. Nah, listen, I used to be on the street and I would be up at like weird times like that all the time too, and people would ask me, and I'm like, bitch, don't
Nigga, that's
even worry
because you was
about why
doing some
I'm up.
crazy shit. You was doing some crazy shit.
Shut up.
Stop playing now. I don't know what type of stuff you was on, but you
Okay,
was on
you're
some
right,
crazy
you're right.
shit.
You're right.
Yeah, I know. I don't know what ice cream.
Oh, sorry.
Like piss.
Oh, make it soupy? Like real soupy and shit?
Yeah,
What
yeah.
are you making? What are you making?
It's one of those easy meals in the bag, man. All you gotta do is put the sauce in the goddamn pan. The kid wants to still fuck it up.
No.
I'm like, what the
In the courtroom along with counsel, and also counsel for the state. And, Mr. Edelman is ready for cross-examination, I believe, and you're still under oath. So go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Oh, okay. May this witness be excused.
You may, Your Honor.
Okay, thank you. You're free to stay, free to leave. Thank you. Appreciate, for you being here. Okay, another witness?
Yes, Your Honor, our last witness is Dr. Dare.
Dare. Okay, I thought maybe Dr. Dare was going to be, rebuttal
By the way,
to the
pause
state.
real quick. Y'all, I am not going to play the rest of that call because I was listening. There's so much bad words in there to the point that I could actually get I don't want to lose all my demonetization. I have not been up for a year yet. So I am still kind of in what's called the probationary period. I mean, I'm not really on probation, but they look at these my kind of videos because I'm newer. So I will go and listen to this and see how bad it gets. And if it gets any worse than what we just heard, or if it continues, I'm not going to play it. Y'all can go listen to it. But this is, it even makes me cringe. And I've been around people who cuss up a sailor.
No.
The woman is horrible.
Your Honor, we disclosed Dr. Dare twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony. Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but we ask that she stay for that if that's the case.
Okay. So Dr. Dare, line it up. Please face the court. Raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury. Yes.
Thank you, ma'am.
Those
Please,
were
have
just
a seat, and then
judge's name.
once you're seated, please state your name and
Judge.
spell your last.
His last name is Judge.
Yes, Veronica Dare, D-A-H-I-R.
Thank you. Ms. Taylor. Go ahead.
Thank you, Judge. Good afternoon.
A little bit when it's appropriate, like.
All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno.
Sling it.
I'm also the director of survey operations
for sure
for the Nevada Center for Surveys, Evaluation, and Statistics, also at the University of Nevada, Reno.
Do you also do consultations outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
Yeah, I saw that.
I have a bachelor's degree in psychology and a master's and PhD in interdisciplinary social psychology.
Not bad.
From the University of Nevada, Reno.
Thanks, Ron.
My master's and PhD are from the University of Nevada, Reno. In terms of my work at the university, I have a joint appointment, as I mentioned. I run two different research centers at the university. One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is a survey lab. I also teach in the Judicial Studies program. I teach a graduate level course called Scientific Research Methods for Judges, which is a course for judges getting their PhD across the nation. They're sitting judges that are on the bench. I teach another course called Scientific Methods for the Justice Management program, which is a master's degree program at the university. I have taught social psychology, criminal justice research methods. I've taught other courses, but that was quite a while ago. Right now, I'm just teaching this graduate level course. I serve on several dissertation committees for various departments on campus: social psychology, psychology, School of Public Health, computer science, natural sciences. There's many. I serve as a dissertation advisor and committee member for students that are getting their degrees, and primarily in the Judicial Studies program, I have served as an advisor and as well as the social psychology program on campus. In terms of my role on campus, I do primarily, let's take the Sawyer Center first. We do research on justice-related topics broadly defined. My background is social psychology with an emphasis in justice studies and law. And so our research that we've been doing there is specifically related to research in the justice system. We have many different populations that we research and do surveys with, including jurors, judges, attorneys, both defense and prosecution, court reporters. We've done many surveys on diverse populations as well, including people experiencing homelessness, LGBTQIA populations, the elderly, prisoners, inmates, Native American populations. So we've done many, many surveys in that capacity. In my role as the survey director for the Center for Surveys, Evaluation, Statistics, I am in charge of multiple research projects that have to do with surveys nationally, regionally, and locally. Most predominantly, the one that we have been doing since I've been there in 2006 is the Center for Disease Control and Prevention, otherwise known as the CDC, their BRSS survey, which stands for Behavioral Risk Factor Surveillance System. I am the project coordinator for Nevada, and I've been doing that role since 2000 for the state of Nevada for the last 3 years. But before that, I was the data collection supervisor for this project since 2006. So I've been working on that project for quite a while. Prior to my role in both of these programs, I also worked on surveys. I've been doing, I would say, surveys and research for almost 30 years, since I've been a graduate student, and even before that. So not before graduate student, well, I did research, but before my role in this area, I did research. Most predominantly for the Sawyer Center, we did a nationwide survey on Daubert, and it entailed 400 randomly sampled judges across the nation. And we looked at the effect of Daubert on judicial decision-making. In both of my roles, I work with many organizations to do surveys. We do work for, besides the CDC that I mentioned, many state agencies, Nevada Department of Transportation, Department of Training and Department of Employment, Training and Rehabilitation. I won't do all the acronyms. I won't do that to you, so because I can shoot off all the acronyms. But we work with the National Judicial College. They're right on campus. I'm in the building actually. National Council of Juvenile and Family Court Judges. We've worked on projects with the Federal Judicial Center, the State Justice Institute, and many more organizations. I know you're going to ask me other questions, but I wanted to get those out. So
I do have a couple of questions for you. You said 30 years about of your life you spent doing this work.
Yes.
And it sounds like it has a whole lot to do with survey work.
Yes.
Is that both designing surveys and then critiquing surveys?
Yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals. I personally have published on different aspects of survey research in Judicature, Justice System Journal, Future of Evidence by the American Bar Association. I have a chapter in there. That was not specific to surveys, sorry. I have other publications, but specific to surveys, Survey Practice Journal, Law and Human Behavior on the judge survey that we had done. There are numerous. I don't know if I can remember them all right now, but in terms of technical reports, we do a lot of technical reports for our projects. And those are basically reports of findings that we give to our clients specifically to use for their organizations based on whatever topic it is that they want us to survey or study. So I mentioned some of them before. We DETR, which is Department of Employment, Training and Rehabilitation, Nevada Department of Transportation, Nevada Department of Corrections. I don't think I mentioned that one. And we've done 140 over my career there, 140 technical reports, all of which in some way or fashion have related to surveys or survey research. We do a lot of evaluation projects, needs assessments, and most of those always entail a survey of some kind.
Are there guidelines or standards that govern survey work?
Yes. Ones that have been mentioned here already. APOR, the American Association of Public Opinion Research, and specifically for change of venue surveys or community attitude surveys, ASTC, which is the American Society of Trial Consulting.
Are you familiar with the standards of both?
Yes, I'm a member of both organizations.
I want to know why people do surveys. It sounds like you've had a hand in a lot of surveys over the years. Why do people do surveys?
Many different reasons to find out information about a specific topic or population. People do it for needs assessments. They do it to find out more about support services. If they want to increase support services in their organization, or if they want to just find out an evaluation of what their program is, if they receive funding from a government organization or a grant to do a specific project, they want it evaluated, and that usually entails surveys. People want to know community attitudes. For example, as I mentioned, a couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not what their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision-making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing research. You guys have been asked to take many surveys about projects that not projects, but things you bought, things that, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have got bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of surveys that reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization. And in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information, and that's in order to make a decision.
Yes, decision making, and especially within their organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to the legislature for whoever our clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call Assembly Bill 122 in Nevada, where they were looking at the assisted living communities within the entire state of Nevada to see if there should be change in those areas. So those are some examples. And primarily, like, I guess a good example would be the behavioral health, BRFSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes. So we ask questions like behavioral risk that's related to how many fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practices, substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Yes, I mentioned a couple of the examples that we have done community attitudes on. And that's basically measuring attitudes of the community on a specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted relating to venue issues?
Yes, I did. Excuse me. I forgot. I have these.
Okay.
Exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
Okay. And I can see you just placed those face down. If you need to place them back face up, will you let me know?
Yeah, I will. Sorry. What was can you repeat the question?
That's okay. I'm wondering if you had an opportunity to review the survey work done and conducted by Dr. Bryan Kohberger.
Yes, I have.
Okay. And do you have an opinion about whether that survey was conducted in a valid way?
Yes, I do.
What is your?
In my opinion, it was a valid survey.
What do you base that opinion on?
So there are standards and professional code of ethics that I mentioned earlier, suggested by AAPOR, again, AAPOR, American Association of Public Opinion Research, and the American Society of Trial Consulting, ASTC. And specifically, ASTC has a section on venue change surveys. And there are many things that can go into a survey to determine its validity and reliability. I guess I should talk about that before I go into that. When you're talking about scientific reliability, by the way, it's very different than evidentiary reliability. So evidentiary reliability is looking at the trustworthiness of evidence, whereas scientific reliability is looking at the consistency and repetition of a survey done over time, across different populations. And validity is more looking at trustworthiness or accuracy. So if we talk about reliability as consistency and stability of results, and validity as accuracy, that's how I'm going to talk about those things. And with respect specifically to this survey, there are many types of validity and many types of reliability, but I'm not going to go into all of them here. I think specifically for this survey, what's important is content validity, construct validity, measurement reliability, and response reliability, specifically with this survey, and looking at coverage error and what we would call external validity. There are other types, as I mentioned. There's criterion validity, there's inter-rater reliability, test-retest reliability, convergent validity. There's many types of validity, but I'm not going to talk about those here. I'm just going to talk about the things that made me come to my opinion or form my opinion based on the survey. According to the ASTC standards, we're doing a change of venue or community attitude survey to look at whether or not a change of venue should be conducted, or a change of venue might be considered. You want to look at 6 things. You have screener questions, you have case recognition questions, you have questions related to the source or the media where the information comes from, you have demographic information, and then case knowledge questions. I think I got them all. And that's what I was looking at with respect to the content. And those were all there in Dr. Edelman's survey. The other thing I looked at was the questions themselves. Do they have what we would call construct validity, which is basically, does the survey measure what it purports to measure? And then does it have content validity? Does it cover all those things? And it does. I mentioned that already. That's the content validity, those 6 items. And was it done in a way that you can consider it? The measurement was reliable, and I would say yes. I read the methodology was brief, but based on what I could gather from the report that Research Strategies did, they did all of the things that we would have done. I would have probably done a little bit more in terms of looking at, some of the disposition codes were just a little bit hard to determine, but that's not that important for this. What I would say is that they did everything we do in our lab. We are very strict, I would say strict when it comes to our methodology for our surveys, because we follow APOR, which is the strictest standards that you could follow for calling on a telephone survey, or what we call an RDD survey, random digit dialing. And primarily that's because we have to do the CDC survey, and the CDC survey follows APOR guidelines. And so for all of our projects, whether it's BRFSS, whether it's CDC or not, we follow the same protocol. So no matter what project we do, whether it be for NDOT or DETR or any of these other organizations that I mentioned, we would definitely follow the same protocol procedures. And that includes things like good questionnaire construction and design. That's the first thing. In order to combat what we would call non-response bias, the first thing you look at is questionnaire design. Are the questions written in a way that would get the responses that you need? Do they have content validity? Are the questions valid? And by that, I mean, we look at things like question order. We look at the whether they're leading, whether they're loaded, whether they're double barreled, whether there's many things we look at. So I looked at that. And then we also look at how the survey was sampled. And according to Research Strategies, they did use a random digit sampling frame. And by that means they probably, I don't have all the details. I'm just going based on my opinion, my experience. What we do for our surveys is we order our sample from a sampling company, and we get replicates of phone numbers. And what that means is we get them in blocks of like 30, for example, and you would call your replicates of 30 phone numbers until completion. And that's to make sure that you are not biasing your sample. So you don't want to call, here's an example. If you get 20,000 phone numbers, you don't want to call all 20,000 phone numbers just once. That's not how it works, because you're only getting those people that answer the phone on the first ring. So that's biasing. Also, you're reducing your response rate by doing that. So what we do is we call them in blocks of numbers, and we call them several times. From my understanding, they called them 4 times. Research Strategies is they called them once, if they didn't get a hold of them, they called 3 more times, they did callbacks. That's also proper protocol. We like to call our surveys at least 3 times during 3 different time periods, either the morning, afternoon, and evening. We also like to call them during the day and on the weekends. My survey lab that I run is open 7 days a week, and every single holiday except for Christmas, Thanksgiving, and believe it or not, Super Bowl Sunday. It's the other American holiday, apparently. Anyway, people get mad when you call them on Super Bowl Sunday versus Father's Day, Mother's Day, and Easter, believe it or not. But anyway, so we call these numbers at different times. And from what I could tell, they did follow-ups, they did different call timing, they did callbacks, they did the replicates, they used both cell phone and landline. It is customary practice now when you're looking at coverage validity, you want to get more you want to make sure you're getting the population that you're interested in. And now so many people have cell phones. So in our lab and most labs across the country now, we do like 90% cell phones versus 10% landline. Now it's customary because of the reduction in the number of people that have landlines. Anyway, those are some of the things that I looked at, and whether the questions themselves, like I said, were valid in terms of what they were being asked.
It sounds like
Did I answer the question?
You had a really
Okay.
thorough look.
Okay.
Before you had your opinion as to whether the survey was valid.
Yes.
Do you have an opinion about whether it was reliable?
Yes, in terms of measurement reliability, which includes things like if you are an interviewer and you are asking questions, it could be biasing if you're not trained properly. And the mode of survey that you're doing for change of venue surveys, the typical mode is RDD surveys, which is phone surveys versus paper or in person. And so the interviewers must be trained and supervised. My understanding is that research strategy has been around for 20 plus years. So I'm assuming they're like our lab where they were trained properly and they have supervision where there's supervisors also supervising the interviewers. So that's another way to combat non-response bias, which includes refusal conversion training, which is, I think Dr. Edelman alluded to it earlier, things like soft refusals. If someone calls up and says, I'm making dinner, I'm too busy, I'm giving my kids a bath, I'm running to the store, whatever it is. We train the interviewers on how to handle those situations so that we don't get only the first person that answers the phone or only those people that are saying that they're busy. So that's all part of the training to make sure that we get at non-response.
Right. I think that you have answered my questions really well, and based on, just to sum it up, based on your look at the work done by Dr. Edelman with this survey, your opinion is that it's a valid survey.
Yes, basically it's what I would have done or what we would have done in our survey lab.
Thank you. I don't have any other questions right now, but hang on and prosecutor.
Okay, thank you.
Thank you.
We have no questions for this witness, Your Honor.
Okay, great. Thank you. Is it?
Nobody that easy.
So easy. So,
thank you.
Witness be released.
She may, Your Honor.
Okay. Thank you for being here. It's very interesting. Help yourself, yeah, as much as you need.
Thank you.
Thanks. All right.
Fit for witnesses, Your Honor.
No more witnesses. Okay, any witnesses?
None from the state, Your Honor.
Okay, we prepared for argument?
Let's do it.
Okay, go ahead.
Thank you, Your Honor.
Your Honor, the decision to change venue rests on what you've heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is a huge amount of coverage. The kind of coverage is prejudicial coverage. and it's had an impact on the Latah County potential juror. The court can see actual prejudice by understanding the results of that survey. Reading the hundreds of comments from Latah County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Latah County. The court can also presume prejudice by looking at this case as it is. It's an extreme case that comes out of the Haddon case in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Latah County, it's bigger, it's a state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written, primetime television shows have happened in this case. It just doesn't stop. And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items. At least some of them. This is all before the other things contained in the media are subject to admissibility rules, even if they're awkward. Subject to cross-examination and full context explanation of what they mean. So you have this coverage that permeates the community. Bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming. That doesn't take care of all of it though. The live stream is captured and replayed almost in real time, if not real time. Everything that happens in this case is on social media, and all kinds of things that don't happen in this case run rampant in news stories, in social media stories, and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helped train. It's all negative. It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there. When you have this much information surrounding a case, it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by Crusoe this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County is. So that's a lot of coverage directed into Latah County, and that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing misinformation. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. We understand that, Lauren, from Dr. L. O'Leary this morning, when she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudgment of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away. You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a scheduling order a couple of months ago. And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings. And that's a lot of media coverage, and people in Latah County are going to see it and read it, and they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition, and there's prejudgment in Idaho, but there's hope. When you look at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good, because that links right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in this state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller. Imagine with me that we are here in June of 2025, and we're here and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. You can't be sure that there's a way to pick an impartial jury in this community. In Ada County, we don't have that. We don't have Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. There are people who don't have those connections. The other difference that I think is really important to think about too is the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider, but in the community about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the courtroom. People in Ada County do not have. And why Ada? Why not Canyon or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to Bannock County, I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem. So that's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Laytown. Canyon County is the second largest. And Your Honor, honestly, if the court says, let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through the media. They would be kept private and in secret and secure. It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures. And the right to a fair trial cannot happen in Laytown County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue needs to be changed.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor. Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Laytown County, Ada County had significantly more coverage than Laytown County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense And that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor, I'd like to talk about what the numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit F1, Dr. Dare. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with 400 survey respondents in a population within the range of our population in Latah County and in the population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County, 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon, 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County, 29%, Ada County, 25%, Canyon County, 23%, and Bannock County, 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing as we approach trial to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it. I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete.
You're fine.
When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do. We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? 19% said no, 16% said no opinion. You add those up and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger?
Business, it's driving me crazy.
No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Canyon County. And frankly, Your Honor, as we move toward the issue of convenience, if anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more convenient options closer to Latah County. Either Kootenai County or Nez Perce County would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, student or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it. But if the court were persuaded that a Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County. Lewiston is approximately 30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that. Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks.
Yeah, that's where I live.
Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County Courthouse in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County Courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job with that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they can accomplish that with careful planning and preparation over the many months between now and trial.
Know when to stop is more important than to know what to say sometimes.
It's also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view.
That is a good point, though. It's going to create.
Moving on to the cost of travel expenses, council referenced the cost of transportation to and from the airport and correctly noted that the Spokane Airport is considerably further from the Latah County Courthouse than the Boise Airport is from the Ada County Courthouse. That's absolutely correct. However, the Lewiston Airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that were.
Okay. Do you realize that this whole procedure started 8 hours ago? We are 8 hours, 25 minutes, and 50 seconds into this live. And it's been because of this all day. Wrap it up, folks.
We're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also
it is a huge burden because not only are the taxpayers already paying for the trial to happen where it is, which is still, they have to pay the hourly wages and all that kind of stuff. But now for a trial that could last, they said, as long as 3 months. Can you imagine the court staff having to be gone Monday through Friday for 3 months from their homes? I think this is a little big ask. I didn't know it was that far. 300 miles. If I worked for the courthouse and they wanted me, man, it would be time and a half. But no, they get paid their hourly plus their expenses and their hotel. But that doesn't negate the fact that they have a right to a life and a family. The defendant doesn't have a right to pull them from their life, their family. What if one of them has an infant? What if one of them has an elderly parent they have to take care of? That courthouse is not a big enough courthouse that they could swap the staff like that. I hope he doesn't.
Logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth.
Amen.
I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, a larger side, on the larger side for counties within this state that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty. Ms. Taylor?
Thank you, Judge. Governor, as I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood?
So his right to not have people who in the community that's heard about his case comes above everybody else's right to have a life, everybody else's right to work and go home and have it just blows my mind. I know all they care about is their client, but this move if it was 22 miles away, I wouldn't have a problem with it. 300 miles away, y'all, that's me going to Houston from where I live. And if I worked in the judicial system, I wouldn't get to come home till weekends. I don't understand how staff and their families should be inconvenienced for 3 months for him or any defendant. And it will cost millions more for the county. Because those hotel rooms, y'all, they ain't no $50.99 a night. They're like $200 and $300 a night now. Y'all.
That it impacts the impartiality of the jury. Yeah. That it impacts Mr. Kohberger from getting.
And the jurors are going to be sequestered for 3 months, at least during the week. Y'all.
A fair trial. Don't think about county's numbers. Don't think about Canyon County's numbers, and don't think about Bannock County's numbers. Think about Latah County's numbers. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County.
Especially if there are buses involved.
You know, the jurors have been exposed to prejudicial media. You know that there's been an impact on you. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot. The court then has to decide, what do we do? But answer the first question.
What the heck?
I'll do my best. It's a challenge. So That's probably all I should say at this point.
I knew he
But,
was not going to give an answer today.
I listened carefully all day and I thought there was some really important things to think about,
No.
both sides. And that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
Taking it under advisement, y'all. He took, and I knew that was going to happen. This is too big and too important for him not to take it under advisement. He will make his decision in a written ruling. Smart to do so. But I get that the defense doesn't feel they can get a fair trial. But at the same time, I think that the population is big enough. I think what they ought to do is try to find the jury. And if they can't seat a jury, then this becomes an argument. I feel like you put the cart before the horse. That's how I personally feel. I'm not a lawyer. I'm not in the courtroom. It's my humble opinion. So be it. I think he's probably made up his mind by this point. If you notice, at some points he was signing documents and still working, which I think is funny. But this was boring as hell. And for me to have 8 of y'all still here, I'm impressed. Don't get me wrong. I think if I didn't have this headache, I'd be a little more engaged. But there was so much crap floating around, y'all. And talking about putting jurors in a hotel, 3 months of a juror in a hotel, let's say it's $200 a night. That's 25 nights a month. That's 75 nights total, just say. Times 300. Because they do not necessarily give breaks to the court systems. Not every hotel is going to be doing that. I'm averaging. That's $22,000 a juror. And if we have a jury of 12 plus alternates, we'll say 15. Just say we have 15. $337,500 just for the jury alone if it takes 3 months. And the alternates if they move it. Not including all the support staff, the judge, and everybody else. And nobody's going to drive 300 miles each way every day. That's 600 miles a day. That's halfway across Texas. That ain't going to happen. Now, it's not about sequestering the jury. The problem is what they're arguing is that they don't think they have a jury pool where they are because of the social media and the media. They think that this jury pool of the town in which they live is so tainted by the media and social media, they cannot get a fair jury. Oh, leave it there and bring in the jurors. You can't do that. If the court moves, then they have a bigger pool in Ada County. Wherever the court happens is the county in which the jury pool is from. Now, I don't disagree with that. That's still $337,500 that they're paying, even if they bring them from Ada County to where they are now. But all these charts and stuff, they can't say, do you know how many old people don't follow this? Do you know how many people like me I don't watch the news. I don't get the news at home. I pick and pull what I want to see because there's too much crap on the news. But I could be a juror because I really don't know anything literally that these students were no longer with us and that this man is being accused. Other than that, I didn't pay attention because when I first started doing all this or even thought about doing this, I wanted to do it like an alternate juror. and come in like a juror and not have any more information so I could look at it with the same eyes as a juror. And I sort of do that still. I do have a capability of looking at things and then, okay, and putting it aside and only looking at the evidence. Sometimes I get a little, well, sometimes I can get a little more involved, but that's by my choice. So I don't think the jury pool is going to be as bad and hard for them as they're putting on. I think they think they have a better chance in Ada County. That may be true. I don't know. But for me, there are millions who can't even tell you who's president at any given time. Ain't that the truth? And they don't all have Alzheimer's. So, guys, the 8 of you, 10 of you who hung through this with me all day, those of you who hopped on and off, thank you very much. We greatly appreciate all of you. I'm going to go finish dealing with this headache. It didn't get much worse, but it sure hasn't gotten any better. So I'm going to go. I do have homework to do. So I'm going to go take meds. I'm going to eat dinner, and then hopefully I can get some homework done. Brooks and Rittenhouse are the only two. Let me get to my comments. I'm sorry I changed it. That didn't change my mind. He's not going to change the venue. He didn't even. You're welcome, none your business, Ronnie. I think they have probably 75% chance the venue's going to stay, but there may be some stuff that we're not aware of. I don't know. But I'm appalled that they think this is going to take 3 months. I think we're going to be sitting here for 3 months on this one case. Ouch. But that's next June. Oh, shoot. That's my vacay month. Well, we'll see what happens. I can always change my vacay month. So I will, unless, and I said it last night and I'll say it again, unless something happens tomorrow, important, I will not be on until tomorrow night if I'm feeling well and Rob and Ian do their Friday night frenzy. Then I'll interpret it. But that's a big if. We'll see what they do. We'll see how I'm feeling with headaches. Oh, y'all chatters have been a lovely day, evening, boring parts. The boring parts, yeah. We had some really dry moments, y'all, but that's part of court. So I will see you for sure, and keep an eye out. I think it's going to be 7:00 Central. The members only. Now, there's a lot of you who are not members on today. My membership starts at $1.99. That goes to $1.99, $4.99, and $9.99. If you become a member between now and Saturday, even for the 99 cent, I will let everybody. It's going to be an open member. Normally, our members only live are from the level of $4.99 and up. Okay. But this time I'm trying to get my mods to go in with me, but I don't think they are. We'll see. Maybe Ronnie will, or her granddaughter, but Being Boozled. We're going to be playing that. I got to figure out how, and it's going to be fun. So please, if you have not become a member and you would like to be a part of that, even if it's a 99 cent, I'm going to open it up to all members. Okay. If you haven't liked and subscribed, please do so. We appreciate you. If you're new here today, thank you so much for joining. This is not my norm, but I appreciate your understanding. All right, guys, see you later. Until we meet again. Good night. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.